వస్తుందిగా. Hello friends, good morning. Online students, am I audible? Am I visible? Please respond. Yes. Okay, sir. Yes. Hello friends, today let us start Indian polity and constitution. And before starting this Indian polity and constitution, may I please know what do you mean by Indian polity? What is Indian polity and what is Indian constitution? Very good. Indian polity is a form of government. Then if Indian polity is a form of government, then what is constitution? Okay. Okay. I mean to say, now I am clear that you are saying Indian polity and Indian constitution are not the same. Indian polity is not Indian constitution. Indian polity is not law for that matter. Then what is Indian polity? Indian polity is a form of government. What are the evidences to say that in India we have parliamentary form of government? See, when you are saying that polity is a form of government, then the second question which I was supposed to ask was, in India, which form of government do we have in India? Parliamentary form of government. Good. Then what are the articles which suggest that in India we have parliamentary form of government? Loudly, please. Can someone off that fan, please? I am unable to hear. Yes. What are the articles which suggest that, or what are the evidences to say that in India we have parliamentary form of government? Article? Only 75? Anyone in this class? What are the evidences to say that in India we have parliamentary form of government? Okay, you are saying bicameralism, very good. Please tell me articles which are related to the parliamentary form of government in India. Good, very good. Perfect. See, my dear friends, if someone asks you this question, what are the evidences to say that in India we have parliamentary form of government? There are 5 articles in the Indian Constitution. I repeat, there are 5 articles in the Indian Constitution which says that in India we have parliamentary form of government. Article 74, 75, 79, 163, 164. These 5 articles are the basis of the existence of parliamentary system in India. Okay, then if I divide this into like this, 74, 75, 79, 163 and 164, will someone please tell me why did I classify these articles into 2 types again? What is Article 74, 75 and 79? They talk about the parliamentary form of government at the center. So especially these articles talks about the parliamentary form of government at the center. And these two articles, 163 and 164, they talk about the parliamentary form of government at the states. Never forget. Parliamentary form of government at state level. Did you understand? So these 5 articles are the basis of the existence of parliamentary system in India. More particularly, these 4 articles. Okay. Now, why did I make you write these articles? The first question which I asked to you was, in India, what is polity? Then you said, polity is a form of government. Then I asked, which form of government? You said parliamentary form of government. Then my third question was, what are the articles to suggest that in India we have parliamentary form of government? Then these 5 articles suggest that in India we have parliamentary form of government. Did you understood? Yes. So you until now you know, are there any other definitions of polity? Anyone? Polity is a form of government. Perfect. Each and everyone know that. Are there any other definitions of Indian polity? Just by looking at this, you can understand one thing. If you observe carefully these 5 articles, you will come to know that polity is the application of the constitutional provisions. Did you understand? Polity is a form of government. From that, we wrote 5 articles which says that in India we have parliamentary form of government. And from these 5 articles, again, we can conclude that polity is the application of the constitutional framework. From these 5 articles, what we can say? Polity is the practical application or application of constitutional provisions. Second definition of Indian polity. Did you understand? And from here we can derive one more thing. Polity is not only the form of government. Polity is not only the application of constitutional provisions. Polity also talks about the functioning of different organs of the state. Now may I please know what are the 3 different organs of the state? Legislature, executive and judiciary. So polity deals with what? The functioning of different organs of the state, and this is your third definition of Indian polity. So your polity also deals with what? Polity also deals with functioning. I did not write function. I am writing functioning. Polity also deals with the functioning of different organs of the state. And there, how many organs of state are there? There are 3 organs of state. They are legislature, executive and judiciary. Okay, are you understanding? Yes. Now, what is the relationship, what is the diagrammatic representation of parliamentary form of government? How should I represent these 3 organs of different organs? How should I represent in a parliamentary form of government? No, I am asking about the diagrammatic representation of legislature, executive and judiciary. If this is your legislature, this is your executive, and this is judiciary. This is the parliamentary, this is the diagrammatic representation of the parliamentary form of government. So what do you come to know from here? Executive is a part of legislature. Executive is derived from the legislature. Therefore, according to Article 75 Clause 3, your executive is collectively responsible to the legislature. And your collective responsibility is one of the bedrock principle of parliamentary form of government. Did you understand? Executive is collectively responsible to the Lok Sabha in particular and Parliament in general. Are you getting, my dear friends? Yes. Then, I told you polity deals with the functioning of different organs of the state. Now, we will enter our topic very soon. But if we take this legislature, which is the first organ of the state, what is the main function of legislature? The main function of legislature is to make laws. So the legislature consists of whom? Who are a part of legislature? Legislature consists of lawmakers. Are all the lawmakers elected? No. There are few lawmakers who are nominated also. So The main function of legislature is to make laws, and your legislature consists of lawmakers. The lawmakers might be mostly elected and few nominated. Why I should make you write few nominated? Because the president nominates 12 members to Rajya Sabha. The president nominates 12 members to Rajya Sabha from how many fields? 4 fields. 4 fields. Please understand. 4 fields. Arts, science, social service, and literature. Never forget arts, science, social service, and literature. Did you understand? Yes. So the main function of legislature is to make laws, and the legislature consists of lawmakers. That is the reason I am not writing. Now, what is the legislative organ at the union level called? What is the legislative organ at the union? Loudly, please, loudly. No? It's parliament. The legislative organ at the union level is the parliament. You can say union legislature. What is union legislature? It is the legislative organ at the union level. And at the union level, what is the most important legislative organ? Parliament. And which article of Indian Constitution talks about the parliament? Which article says that there shall be the Parliament of India? Which article talks about the very constitution of Indian Parliament? Who is saying 79? Yes, very good. Article 79 says there shall be a Parliament of India, and the Parliament shall consist of 3 components: upper house, lower house, and president. Very good. Yes, this parliament is dealt by article 79. Then which article talks about the upper house? Article 80. Very good. And lower house? 81. And which articles deals with the president of India? Article 52 to 62, Article 71, Article 72, Article 111, Article 123. All these articles are related to the President of India. Article 52 to 62, 71, 72, 78, 111, 123, and so on. Mainly, you should not forget Article 52 to 62. And out of these articles, the most important article is Article 52. What is Article 52? According to Article 52, there shall be the President of India. Wherever the word shall comes, you have to understand that that office, the existence of that office is compulsory. Did you understand? Yes. Now, my next question to you is, are these names, why didn't I make you write Rajya Sabha and Lok Sabha here? Yes, your constitution, the Constitution of India does not mention the 2 Hindi names, Lok Sabha and Rajya Sabha. The Constitution does not contain the 2 Hindi names, Lok Sabha and Rajya Sabha. The 2 Hindi names were coined by the first Speaker of India, Ganesh Vasudev Maulankar. Are you getting? Then what are the other names of Upper House? Upper House is also called as what? Council of States. Very good. Why is it called Council of States? It represents the states. Other than that, it protects the interest of the states. Are you getting? Yes. The upper house is also known as Elders House. It is also called as Council of States. It is also known as Rajya Sabha. It is also known as Second Chamber. Are you getting? Second Chamber. Please don't forget. I am not making you write, but you have to just remember. Now, what is your lower house called? What are the other names of lower house? Lower house is also known as House of People, or People's House, or Popular House, or First Chamber. Here we cannot write it as temporary house. Rather, in case of upper house, you can write it as permanent house. Did you understand? Yes. Now after this, now slowly come towards what is constitution. Until now, what have we discussed? What is Indian polity? So you came to know that polity is a form of government, point number 1. Which form of government? Parliamentary form of government. What are the articles which says that in India we have parliamentary form of government? 74, 75, 70, 79, 163, 164. Okay, yes. The polity also deals with what? Functioning of different organs of the state. So this is all about Indian polity. Then what do you mean by constitution? Okay, good. More. What do you mean by constitution, anyone? The constitution is the basic, fundamental, organic and supreme law of land. So how many adjectives did I use here? The constitution is the basic, fundamental, organic and supreme law of land. Five keywords I used here, please. Constitution is basic, fundamental, organic and supreme law of land. This basic and fundamental you can understand. Why? Because it was the first law of land, right? See, my dear friends, when I wrote constitution is the basic, fundamental, organic and supreme law of land, from here let me ask you a few questions. What do you mean by laws of land? First tell me, what are laws of land? In India we have how many laws of land? What do you mean by laws of land? See, when I know what is a law of land, only then I will come to know why constitution is basic, fundamental, organic and supreme law of land. Please tell me, what are laws of land? What do you mean by laws of land? Any law that is used for administration of a country is known as laws of land. Any law or any laws that are used for administration of a country are known as laws of land. So in India we have how many laws of land? In India we have 8 laws of land, my dear friends, 8. The first one is constitution. The second one is statutory laws. First one is constitution, second one is statutory laws. What do you mean by statutory laws? The laws made by the parliament and state legislature are known as statutory laws. Constitution, statutory laws. Third one is ordinances. What are ordinances? The temporary laws enacted by the executive. Who enacts the order? Who promulgates the ordinance? Your president promulgates an ordinance under Article 123 of the Constitution. And the governor promulgates ordinance under Article 213 of the Constitution. Now you tell me, is ordinance making power a legislative power of the president or executive power of the president? Legislative power. Ordinance making power is the legislative power of the president. Let me ask you one more question. Is ordinance making power a discretionary power of the president or not? No. Good. The ordinance making power is not the discretionary power of the president. Don't forget. So the main topic that we are discussing now is, what do you mean by laws of land? Any law that is used for administration of a country is known as law of land. In India we have 8 forms of law, 8 types of laws of land. 8 laws of land. The first one is constitution. Second is statutory laws. Third are ordinances. The fourth are judicial verdicts or judgments given by Supreme Court. Judicial verdicts or judgments given by Supreme Court. And the fifth one are bylaws. Bylaws, B-Y-L-A-W-S, bylaws, rules, regulations, notifications, orders, and so on. Did you understand? Constitution, statutory laws, ordinances, judicial verdicts or judgments, bylaws. The next one is rules, regulations, notifications, orders, and so on. Then what is the 7th law of land? Any international law that is applicable to India. All those international laws, international conventions which are relevant to India are also considered as laws of land. And thereafter we have the 8th law of land known as personal laws. The personal laws are placed at the bottom because they are made by non-state actors, the religious heads. Did you understand? Yes. Okay, just 1 minute, friends. Coconut water. This is coconut water actually. Right. Did you understand, friends? How many laws of land are there? 8 laws of land. Now you will come to know why I made you write supreme law of land. Out of these 8 laws of land, the most important law of land is your constitution. Out of these 8 laws of land which I told you just now, from 2 to 7, from 2 to 8, please listen to me carefully. Out of these 8 laws of land, from 2 to 8, if any law of land is against the constitution, then they can be struck down by the judiciary. That is the reason we call our constitution as supreme law of land. Why supreme law of land? Out of 8 laws of land, from 2 to 7, statutory laws, ordinances, notifications, bylaws, rules, regulations, personal laws, if anything goes against the constitutional provisions, all these laws of land can be struck down by the judiciary. Why? Because they are going against the constitution, which is a supreme law of land. Did you understand? Yes. Then let us come to here. Why should I call constitution as organic law of land? Anyone? Why constitution is a living document? Very good. The constitution evolves with time. Whatever changes are taking place in the society, they need to get reflected where? In your constitution. That is the reason we have till date, our Indian constitution was amended for more than 106 times. Why? Because Indian constitution is a living document. Indian constitution is an organic law of land. Now please tell me, what was the 99th Constitutional Amendment Act? What was the 99th Constitutional Amendment Act? 2014. National Judicial Appointments Commission. Okay. What was this National Judicial Appointments Commission? It tried to replace the collegium system with a body known as National Judicial Appointments Commission. Okay? Yes, 1 minute. Right? This is National Judicial Appointments Commission. Say I am making you write the latest constitutional amendment acts. If 99th Constitutional Amendment Act 2014 was NJAC, then what is 100th Constitutional Amendment Act? 100th Constitutional Amendment Act 2015? Land boundary agreement between India and Bangladesh. Berubari Union was in 1960. Okay? As he told Berubari Union, let me ask you one question, my dear friends. See, the Berubari Union case was dealt by the Supreme Court, and that case was known as Berubari versus Union of India. Very good. Yes, I understand. Yes. Right. Okay, friends. Please see, my class will be like this only, no problem. Berubari versus Union of India. Wherever in front of the case you come across this word re, please understand that case has been referred by the President to the Supreme Court of India under Article 143 of the Constitution. What is Article 143? Advisory jurisdiction of the Supreme Court. The President can ask the Supreme Court for an advice. Now you tell me, is the President's advice binding on the President? Yes. Is the Supreme Court's advice binding on the President under Article 143? No. Okay? Yes. Yes, you were saying something? Yes, very good. See, the President can ask the Supreme Court any advice on 2 issues. One is on any question of law or fact. The second one is on any question of pre-constitutional laws. Whenever the Supreme Court gives its advice on a question asked on the pre-constitutional law, the advice of the Supreme Court is binding on the President. Okay? Yes. No, the advice of Supreme Court is not binding on the President. The Supreme Court must give its advice to the President. Did you understand? Yes. Pre-constitutional laws, no, Supreme Court's advice. Supreme Court must give its advice. However, the President need not hear to the advice of Supreme Court. It is not binding on the President. Supreme Court's advice is not binding on the President. Yes. Then what is 100th Constitutional Amendment Act? Land boundary agreement. between India and Bangladesh. 100th Constitutional Amendment Act. Next, write down 101st Constitutional Amendment Act. It is related to what? Introduction of GST. 101st Constitutional Amendment Act is related to introduction of GST. Then what is 102nd Constitutional Amendment Act? 102nd Constitutional Amendment Act 2018. Constitutional status to National Commission for Backward Classes. Constitutional status to National Commission for Backward Classes. Okay, then what is 104th Constitutional Amendment Act? Did we write 103? Please write down 103. 10% reservation to economically weaker sections. Okay, yes. Then what is 104th Constitutional Amendment Act? What is 104th Constitutional Amendment Act? Yes. Okay, extension of SC/ST reservation for another 10 years up to 2030. This is the first provision. Extension of SC and ST reservations for another 10 years. Yes. This is one important provision. And another important provision is it deleted the provision of the president nominating Anglo-Indians to the Lok Sabha and the governors nominating Anglo-Indians to the State Legislative Assembly. It deleted the provision of president nominating Anglo-Indians. The president nominates how many Anglo-Indians to Lok Sabha earlier? 2. The president nominating 2 Anglo-Indians to Lok Sabha and the governor nominating 1 Anglo-Indian to State Legislative Assembly. Right? Yes. Then after, see, originally the reservation for SCs and STs was to be continued for how many years? Only up to 10 years. That too up to 1960 only. But this provision has been continuing continuously by various constitutional amendment acts. Okay, did you understood? Yes. Then how many SC seats are reserved for scheduled caste in Lok Sabha? 84. There are 84 seats reserved for scheduled caste in Lok Sabha. I am writing here. 84 seats are reserved for scheduled castes in Lok Sabha. And how many seats are reserved for scheduled tribes? 47. 47 seats are reserved for scheduled tribes in Lok Sabha. Don't forget as of now. Okay? Yes. The next is 105th Constitutional Amendment Act 2021. Please tell me what is 105th Constitutional Amendment Act 2021? Who identifies the socially and educationally backward classes? President. Okay, no, earlier it was President. But this Constitutional Amendment Act has empowered the states and union territories to identify socially and educationally backward classes. I am writing here for you. The states and union territories to identify the socially and educationally backward classes. The states and union territories to identify the socially and educationally backward classes in their states. Please write down one note point there. Earlier, the president used to identify. SCBCs. Okay, now last is 106th Constitutional Amendment Act, you know very well. 106th Constitutional Amendment Act 2023. It provides for reservation of 1/3 seats for women in Lok Sabha and state legislative assemblies. It provides for reservation of 1/3 seats for women in Lok Sabha state legislative assemblies. Yes.
States and UTs identify the president approval.
Later he must do that. Yes. Did you understand this? Okay, next. See, we were discussing still the constitution. I made you write the constitution is the basic, fundamental, organic and supreme law of land. And in that, why constitution is supreme? Already we discussed. Why constitution is organic? These are the examples of organic. Now, what are the other meanings of constitution? See, from here I am trying to derive our next topics. What do you mean by constitution other than that? Okay. Okay, good. See, the constitution lays down the basic framework of polity. The constitution contains the nature of Indian state and the objectives which it must have to achieve. What do you mean by the nature of Indian state? Please, see, already those who covered, let others answer. If they don't answer, you can answer. Please tell me, the constitution contains the nature of Indian state and the objectives which the Indian state must achieve. What do you mean by the nature of Indian state? Sovereign, socialist, secular, democratic and republic. This is the nature of our Indian state. These are the qualities which Indian state possess. Then what do you mean by objectives of the constitution or objectives which our Indian state should achieve? Justice, liberty, equality and fraternity. Therefore, what I mean to say, India by having this nature, sovereign, socialist, secular, democratic and republic, it must achieve justice, liberty, equality and fraternity. Did you understand? Yes. Then the constitution also defines the functions of various organs of the state and establishes the relationship between them. What are the different organs of the state? Legislature, executive and judiciary. The constitution lays down the functions of different organs of the state and also establishes the relationship between them. Now, what are the functions of each organ of the state? Which article talks about the functions of union executive? Which article talks about the function of union legislature? Which article talks about the functions of judiciary at the union level? That is the Supreme Court. First tell me the functions of union executive, please. See, I told you the constitution lays down the functions of different organs of the state. The constitution lays down the functions of different organs of the state. So my question to you was, what are different organs of the state? You told me legislature, executive, judiciary. Perfect. First one. Then the functions of the state are mentioned from which article to which article. If we take this union executive first. Second, union legislature. And third one, judiciary at union level. That is nothing but Supreme Court. So my question to you is, which article deals with the union executive, union legislature and the Supreme Court of India? Article 52 to 78, very good. Article 52 to 78 in part 5, never forget to mention part 5. Article 52 to 78 in part 5 deals with the union executive. And my dear friend, please respond. 79 to? Very good. Article 79 to 122 in part 5 of the constitution deals with union legislature. Why did I not write article 123? Article 123 deals with the ordinance making power of the president, and it is the legislative power of the president, and president is an executive. That is the reason I did not write article 79 to 123. Okay? Yes. Yes. Yes, president is an integral part of parliament. I am talking about union legislature, parliament, exclusively parliament. Which article deals with the parliament? Okay, right. And thereafter, what is the judiciary at the union level called? Supreme Court. And which article deals with the judiciary at the Supreme Court? Article 124 to 147. So, where are all these articles mentioned? They are mentioned in the Constitution. That is the reason we say the Constitution lays down the functions of different organs of the state. And the Constitution also establishes the relationship between each organ of the state. May I please know any articles which establishes the relationship between two organs of the state, union legislature and union executive? Any article which establishes the relationship between the two organs of the state, first two organs. You are saying something. Very good. 75. Which clause?
Clause 3.
Good. Very good. According to Article 75, Clause 3, the executive is collectively responsible. The executive is collectively responsible to the legislature. And what do you mean by executive? The Council of Ministers headed by Prime Minister. What do you mean by legislature? Parliament in general and Lok Sabha in particular. See, this is the first relationship. According to Article 75, Clause 3, the executive is collectively responsible to the legislature. Did you understand? Yes. Now, what is the relationship between these two? Sorry, here. These two. Who is saying separation of powers? Good. Which article deals with the separation of powers? 50. Here. Article 50. It deals with separation of powers. Separation of powers between judiciary. First write down judiciary. Judiciary and executive. Did you understand? So, the Constitution lays down not only the functions of different organs of the state, it also establishes the relationship between different organs of the state. Are you understanding? Yes. If you are writing, please write down. See, the Constitution also lays down the relationship between the state and the people. Now, will you please tell me what is the relationship between you and the state? State, what is the relationship between the people and the state? Loudly. Okay, elections, very good. Someone told fundamental rights. Fundamental rights, very good. More. Citizenship. Okay, never forget these three provisions, which are the relationship between the state and the people. The Constitution lays the relationship between the state and the people. And what is that relationship? The first one is elections. The second one is your fundamental rights. Third one is your citizenship. Who gave you this passport? The state, the Indian state. What is written on your passport? The Republic of India. The Republic of India, this word republic, you can find, as of now, what I have observed is, the word republic can be found in two cases. I have seen in two cases. The first one is, the word republic is mentioned on your passports, point number 1. And whenever the president's election takes place, on the ballot box of the president's election, it is written, the Republic of India. Did you understand? Yes, never forget. Now, by the friends, by the way, what do you mean by republic? When the head of the state is elected, it is known as republic. Then what do you mean by democracy? What is the difference between a democracy and a republic? Democracy means the head of the government is elected. I mean to say, though in India we have indirect democracy, even our Prime Minister is elected as a MP from Varanasi constituency. Never forget. Democracy means what? We elect our people's representatives. And in case of republic, the head of the state is elected. The only difference is, if he is elected directly, that we can see in case of America, an indirect election is in case of our India. Indian president is elected indirectly by PRSTV system. Did you get one basic idea about what is polity and what is constitution? There are so many points which I would have made you write, but at this point of time, this much is enough. Yes. Now, after this, the next thing which I want to discuss with you is the sources of Indian Constitution. Be ready, I will ask you a number of questions now. Right. Now, dear friends, now let us discuss the sources of Indian Constitution. See, our Constitution of India is a bag of borrowings, as many people criticize. No, they criticize. Okay. See, our Constitution contains the provisions that we have borrowed from not only different countries of the world, but we have also borrowed few provisions from the Government of India Act 1935, which is considered to be one of the bulkiest document. Okay. Yes. Now, what are the? Can you name me some of the provisions that we have borrowed from different countries of the world? First, let me write the British Constitution. From the British Constitution, what have we borrowed? Very good. Good. Wait. One by one. You told me parliamentary form of government, right? Parliamentary form of government, in reality, we have borrowed from Britain. The parliamentary form of government is also known as Westminster model of government, or cabinet form of government, or prime ministerial form of government. Yes or no? Why should I call the parliamentary form of government as the Westminster model of government? Yes? Yes. We call the parliamentary form of government as Westminster, W-E-S-T, Westminster model of government, because the British Parliament is located at a place known as Westminster. Are you getting? Right. And other than that, what have we borrowed from British Constitution? We borrowed equality before law. And your equality before law is mentioned in which article? Article 14. We have also borrowed the rule of law. What do you mean by rule of law? Who have given this concept of rule of law? Alexander Van Dicey. Okay. It was this after this rule of law, after A.V. Dicey gave this concept of rule of law, slowly we started believing that the rex is not lex, it is the lex which is rex. I mean to say, after the A.V. Dicey have given this concept of rule of law, people started believing from rex lex to lex rex. Now, what do you mean by rex? Rex means king and lex means law. Before rule of law, people started believing that king is law. But when A.V. Dicey gave this concept of rule of law, then slowly the people started believing that it is not the king who is law, it is the law which is the king. Did you understand? Rule of law. And thereafter, what have we borrowed? We borrowed the concept of bicameralism from Britain. Now, what do you mean by bicameralism? See, the presence of two houses is known as bicameralism. Bicameralism. And what do you mean by bi? Bi means two. Cameral means houses. The presence of two houses is known as bicameralism. You tell me, at the center, do we have bicameralism at present? Yes. At the center in the parliament, we have the two houses of parliament. One is Lok Sabha and second one is Rajya Sabha. That is the reason we can say in India at present, at the center, we have bicameralism. Then what about the states? See, my dear friends, okay, good. You have revised very well, very good. Out of 28 states in India, 6 states have bicameralism and the rest 22 states have unicameralism. Now, what do you mean by bicameralism in the states? When the if we have state legislative assembly and state legislative council, if these two houses are present, then in that state we say that there is bicameralism. And in any state, if there is only one house, state legislative assembly alone, that state is an example of unicameralism. Then what are the 6 states which are having bicameralism? Very good. There are 6 states in India which have bicameralism. AP Telangana, point number 1. Try to remember in bunches. AP Telangana, Maharashtra Karnataka, Uttar Pradesh Bihar. Did you understand? Yes, bicameralism. Now, let me ask you one question from historical background. Which which act of the historical background has provided for bicameral legislature at the center? Government of India Act 1919, never forget. It is the Government of India Act 1919 which provided for bicameral legislature at the center. Then which act of the historical background have provided for bicameral legislature at the provinces, at the states?
Mine, sir. Removed at the provincial level, introduced at the center. 1935.
Government of India Act 1935, never forget. See, bicameralism at the center. Bicameralism at center was introduced by Government of India Act 1919, and bicameralism at provinces was introduced by Government of India Act 1935. Don't forget this. Okay? Yes. And after bicameralism, let me, as we are discussing the historical background, let me ask you one question, but I expect you not to answer. When others don't answer, you can answer. Okay? Yes. Which act is the basis of the evolution of the parliamentary system in India? Which act of the historical background is the basis of, or which act of the historical background has sown the seeds of the parliamentary system in India, which exists today? See, we have so many acts, my dear friends. We have Regulating Act 1773, the Pitt's India Act 1784. We also have the Charter Acts, which were enacted for every 20 years, starting from 1793, 1813, 1833, 1853, Government of India Act 1858. Thereafter, we have Indian Councils Acts. We have Government of India Act 1919, 1935, and Indian Independence Act of 1947. Out of these many acts of the historical background, which act has sown the seeds of the parliament in India today? Which act? Charter Act 1853, don't forget. It is the Charter Act 1853 which has sown the seeds of the parliament which exists today. Why Charter Act 1833? See the Charter Act. See the Charter Act 1853. Charter Act 1853, what it did was, it separated. Charter Act 1853, it separated the executive functions and legislative functions of Governor General's Council. Did you understand? The Charter Act 1853 separated the executive functions of Governor General and legislative functions of Governor General, and these executive functions were looked after by a body known as Governor General's Executive Council, and these legislative functions were looked after by a new body that was created by the Charter Act 1853, and that was Governor General's Legislative Council, which was also known as Indian Legislative Council, which was also known as Central Legislative Council, and this ILC or CLC was also known as Central Legislature. And another name of this ILC, GLC, CLC and Central Legislature was Mini Parliament. Mini Parliament. And that Mini Parliament of that day has now become Parliament of India. Please don't forget. Right. And thereafter, what are the other provisions which we have borrowed from Britain? We have also borrowed the legislative procedure, the lawmaking procedure. We have also borrowed single citizenship from Britain. Which article deals with the single citizenship? Article 9 deals with the single citizenship. Don't forget Article 9. Okay? Then see, when I discuss with you single citizenship, it prompts me to ask one more question. Are you understanding? What are the similarities between the Indian Federation and the Canadian Federation? What are the similarities between the Federation of India and the Canadian Federation? What are the similarities between the Federation of India and the Canadian Federation? Anyone? Bhavya? No? See, Indian Federation resembles the Canadian Federation in 3 aspects. Rather, 4 aspects, I must say, 4 aspects. One is, right from starting I am saying, both the federations were formed by way of disintegration. Both the federations were formed by which mode? By way of disintegration, point number 1. Both the federations prefer the strong center. Both the federations have given preference to strong center. Both the federations have mentioned in their constitution the union of states rather than federation of the states, though both the countries are federal countries. Are you understanding? Though Canada and India are federal countries, both these countries have given preference to the term union of states rather than federation of states, point number 1. Both these federations were formed by way of integration, and both these federations have strong center. And the 4th point is, both these federations have single citizenship. Though they are federal countries, normally in a federal country we must have what? Dual citizenship. But in spite of being the federal countries, India and Canada have single citizenship. Yes, single constitution. Very good. Are you understanding? Yes. Thereafter, friends, after single citizenship, the next feature which we have borrowed from Britain is the cabinet system. Yes, writs also. The cabinet system or cabinet. Now, again, others try to tell, please. From where have we borrowed this word cabinet? You would say we have borrowed this word cabinet from Britain. Was this word cabinet mentioned in the original constitution?
No.
Then when was this word cabinet added? It was added by 44th Constitutional Amendment Act. To which article?
352 clause 3.
352. Yes, during emergency times. Did you understand? The word cabinet was not mentioned in the original constitution. The word cabinet was added to Article 352 by 44th Constitutional Amendment Act 1978. Okay? Yes. And after this cabinet system, see, if you want, I will make you write. The word cabinet was not mentioned in the original constitution. The word cabinet was added to Article 352. Article 352 by 44th Constitutional Amendment Act. 44th Constitutional Amendment Act 1978. Okay? Yes, don't forget. And after this, we have borrowed writs. We have borrowed the writs. From there in England, these writs were known as prerogative writs. Prerogative writs. Are you understanding? And who can issue writs in case of India? The Supreme Court under Article 32 and the High Courts under Article 226 can issue 5 types of writs. What are those? First one, habeas corpus, mandamus, prohibition, certiorari, and quo warranto. And out of these 5 types of writs, which writ is applicable to private individuals also? Only habeas corpus. Never forget. Out of these 5 types of writs, only habeas corpus is applicable to private individuals also. Okay? And the concept of writs or prerogative writs was borrowed from where? From British Constitution. Nice. And thereafter, we have also borrowed parliamentary privileges. See, in your Lakshmikant, 5 to 6 are given. I'll make you write 15. 15 sources from British, 15 from America. Whatever is there in polity, I will make you write. Are you getting? Please. Now the next feature which we have borrowed from Britain is parliamentary privileges. What do you mean by parliamentary privileges? Any one example of parliamentary privilege which you know? MPs have the freedom of speech inside the parliament. A member of parliament cannot be arrested 40 days before the session and 40 days after the session and during the session. This is one more privilege of the MPs. Which article deals with the parliamentary privileges or privileges of MPs? 105, 105. Parliamentary privileges, there you write down. Article 105 deals with the privileges of MPs. Article 105. And Article 194 deals with the privileges of MLAs. Okay? Until now we have discussed 9 features that we have borrowed from Britain. The 10th feature which we have borrowed from Britain is FPTP system. First past the post system. FPTP system. First past the post system. First past the post system. Okay? What do you mean by FPTP system? Or what are its applications? See, whenever elections takes place, the candidate who secures the highest number of votes will be declared elected. This system is known as FPTP system. And what are its applications? What are the applications of FPTP? Where have we used, or where are we using FPTP system? For electing MPs, for electing MLAs, for electing local body representatives. Are you getting? Please don't forget this. Right? Then when I discussed with you FPTP system, though I should not make you write here PRSTV system applications, may I please know what are the applications of PRSTV? Yeah, right? See, one by one. Anyone who knows all the applications of PRSTV, please raise your hand. Anyone who knows all the applications of proportional representation by means of single transferable vote? Yes, my dear friend. How many applications are there? How many applications you know?
MLCs. Some MLCs
Is it 3? See, my dear friend, there are 6 applications of PRSTV system. Proportional representation by means of single transferable vote has been used or is being used in 6 applications. The first one is for electing president. To elect the president, please write down. I am making you write the applications of PRSTV. The first application is for electing the president of India. Second, for electing vice president of India. Next one is to elect the Rajya Sabha MPs, members of Rajya Sabha. To elect the members of Rajya Sabha. After this, to elect MLCs, members of state legislative councils. To elect the members of state legislative councils. How many you wrote? 4. Everyone know these 4. Write down the 5th point. To elect the members of the parliamentary committees, especially financial committees. To elect members of some of the parliamentary committees. Some of the parliamentary committees. And do you know which committees? Financial committees. Financial committees. The 3 financial committees of Parliament. What are those? The first one is Public Accounts Committee. Public Accounts Committee. Second one is Estimates Committee. The first one is Public Accounts Committee. Second one is Estimates Committee. Third one is Committee on Public Undertakings, CPU. Committee on Public Undertakings. Committee on Public Undertakings. Here also we use the PRSTV system. Never forget. To elect the members of the 3 parliamentary committees which are known as the financial committees, we use which method? PRSTV method. And the 6th application is, already we have used this. To elect the members of the Constituent Assembly, please write down. To elect the members of Constituent Assembly, PRSTV system was used. To elect the members of Constituent Assembly. To elect the members of Constituent Assembly. Right? Did you understand first past the post and PRSTV? Okay, right. Then next write down. The next provision is here, 12th provision or 11th, civil services. civil services. We have also borrowed civil services. We borrowed civil services from Britain. And which article talks about the civil services or creation of civil services? Article 312. Okay. How many all India services do we have in India? 3. What are those? Very good. This IAS and IPS were created in which year? They were created in which year? The IAS was known as dash. Okay, for that matter, the Indian Forest Service was created in which year? You told me there are 3 All India services. I am happy with that. Very good. Please understand, the article which is related to creation of All India Service is Article 312. Never forget this. Article 312. It deals with creation of All India Services. Now, how many All India Services are there? You told me IAS, IPS, and Indian Forest Service. See, these 2 services were created or they existed from even before 1947. That is the reason I am writing 1947. And this Indian Forest Service was created in 1966. And this IAS was known as Indian Civil Service at the time. And Indian Police Service was known as Indian Police. Okay? Yes. Then other than civil services, what have we borrowed from Britain? We borrowed Indian Railways. Please write down there. The best features which we have borrowed from Britain are 3. The first one is parliamentary form of government. The second is the civil services. And third, and the best feature which we have borrowed from Britain is your Indian Railways. Okay? Yes, don't forget. Indian Railways. And not only this, we have also borrowed the Office of Speaker from Britain. Please write down Office of Speaker. We have also borrowed Office of Speaker from Britain. And which article talks about the Speaker of Lok Sabha? Article 93. Very good. Article 93. Speaker of Lok Sabha. And Article 178 talks about Speaker of State Legislative Assembly. Article 178. Speaker of State Legislative Assembly. Okay? Bhavya, why sad? Not feeling well? Yes. Right. And see, we have also borrowed the Office of CAG from Britain. Office of CAG, 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 Comptroller and Auditor General. Though we have borrowed the Office of CAG from Britain, in reality, the Indian CAG does which functions? Is it Comptroller and Auditor General or only Auditor General function? Only Auditor General functions. Our Indian CAG in reality performs only these functions and he does not perform these functions. Did you understand? Why? What is the difference between CAG and AG?
CAG is that before spending itself, we are going to give the report.
Yes. Good.
AG is that
See, though we have borrowed this Office of CAG from Britain, in Britain, the CAG performs both the functions, Comptroller and Auditor General. So what does this mean? Even before the expenditure is made, he will audit the accounts of both center and state there in case of Britain. But here in case of India, once the expenditure has been made, only then our CAG will audit the accounts of center and states. That is the reason in India, the CAG actually performs only Auditor General functions, but not Comptroller functions. Did you understand? Yes. And thereafter, we have also borrowed the concept of martial law. MARTIAL, martial law. We have also borrowed the concept of martial law from Britain. Okay? What do you mean by martial law? In which articles of the Indian Constitution you come across this word martial law? Article 34. Okay? Yes. Is martial law same as military law? No. Martial law is different from military law. Under martial law, the civilian administration will be under the control of military. Are you understanding? That much depth you need not go. martial law we have borrowed from Britain. In your constitution, which article contains the word martial law? 34. It's enough. So, this word is not mentioned, but this concept we have borrowed from Britain. Yes, what you said is right. Okay. Did you understand what we have borrowed from Britain? I made you write 15. 15. So please try to read or once go through before going to examination. Then you write down American Constitution. What have we borrowed from American Constitution? Let us be fast here, please. See, good. More. I need more. Independence of judiciary, perfect. Removal of Supreme Court and High Court judges, perfect. Okay. Impeachment of president, very good. See, yes. Right. What have we borrowed from Britain? Sorry, what have we borrowed from American Constitution? No one said written Constitution. I was looking for this. Written Constitution is the first important feature which we have borrowed from Britain. Now, please tell me, what is an example of written? What do you mean by unwritten Constitution? What is an unwritten Constitution? Yes, Amma, wait, please, you tell me. Okay, good. More? Anyone? Okay, I will show you what do you mean by unwritten Constitution. This is an example of unwritten Constitution. Are you getting? The Constitution which is not codified in the form of a single legal document. If your Constitution is not codified in a form of single legal document, it is known as unwritten Constitution. And this is an example of written Constitution. The Constitution which is codified into a single legal document is known as written Constitution. Did you understand the difference between written and unwritten? If the Constitution is not codified in the form of a written document, a single legal document, it is known as unwritten Constitution. Then which countries have unwritten constitutions? Is it only Britain? Which countries have unwritten constitutions? Never forget 3 popular countries. One is Britain, second one is New Zealand, third one is Israel. Britain, New Zealand, Israel. These 3 countries have unwritten constitution. Unwritten constitution is New Zealand, Israel, Britain. But what have we borrowed from American Constitution? Written Constitution. Okay, just to make you understand what is the difference between unwritten and written, I made you write that. We have borrowed the concept of written Constitution from America. We have also borrowed the concept of preamble. Please write down the concept of preamble. So what is preamble? Preamble is an introduction to any written document. When we talk about preamble of the Constitution, we are talking about the introduction to the written Constitution, introduction to the Constitution. When I talk about the preamble of Lakshmikant, it means I am talking about the index pages of Lakshmikant. So an introduction to any written document is known as preamble. And the concept of preamble we have borrowed from American Constitution. But they write down, please write down one note there. But the language of preamble was borrowed from Australian Constitution. The concept of preamble we have borrowed from American Constitution, but the language of preamble we have borrowed from Australian Constitution. Right? And the third feature is fundamental rights. Article 12 to Article 35. Fundamental rights from Article 12 to Article 35 in Part 3. Fundamental rights from Article 12 to Article 35 in Part 3. Fourth feature is separation of powers. Separation of powers. Separation of powers. In brackets you write down Article 50, Article 121, Article 122. These are examples of separation of powers. 50, 121, 122. After that, please write down the President as the Supreme Commander of Armed Forces. President as the Supreme Commander of Armed Forces. Which article of the Indian Constitution says that the President shall be the Supreme Commander of Armed Forces? No? Which article says the president shall be the supreme commander of armed forces? Article 53 clause 2. Please write down there. Article 53 clause 2. It says the president shall be the supreme commander of armed forces. The next feature which we have borrowed from American Constitution is impeachment of the President of India. Impeachment of the President of India. Impeachment of the President of India. And please note one point here. The word impeachment must be used only for the removal of President of India. Though in your textbooks it might be written, impeachment word might be written for others removal process also. But the word impeachment must be used only for the removal of the President of India. And which article talks about the impeachment of President? Article 61. Article 61. And what are the grounds for impeachment of President? What are the grounds? Violation of Constitution. And where is this word violation of Constitution mentioned? Which article of the Indian Constitution contains this word violation? See, Article 61 contains the procedure for impeachment of President. But what is the ground for impeachment? Violation of Constitution. And this word violation of Constitution is contained in which article? 56. Please write down there. Ground for impeachment of President is violation of Constitution. And the violation of Constitution is mentioned in Article 56. In Article 56. Next, please, we have borrowed the office of Vice President. In brackets, you write down Article 63. Office of Vice President. Office of Vice President, Article 63. Then, we have also borrowed Vice President to act as ex officio chairman of Rajya Sabha. Vice President to act as ex officio chairman of Rajya Sabha. Vice President to act as ex officio chairman of Rajya Sabha. Article 64. Vice President to act as ex officio chairman of Rajya Sabha. Article 64. Then judicial review. Which article talks about judicial review? Huh? Article 13, 32, 131 to 136. Please write down. Article 13, 32, 226, 131 to 136. Article 13, Article 32, 226, 131 to 136, and so on. Next one is independence of judiciary. Independence of judiciary. Is independence of judiciary a unitary feature or a federal feature? Huh? Independence of judiciary is a federal feature. Integrated judiciary is a unitary feature. Never forget. Okay? Yes. Next one, removal of Supreme Court and High Court judges. Removal of Supreme Court and High Court judges. Due process of law. Next one is due process of law. Equality before law. Due process of law. What do you mean by due process of law? What do you mean by due process of law? If the yes, you are saying something. Okay. What is the difference between procedure established by law and due process of law?
Due process of law works under natural justice.
Okay.
Even the procedure must be in accordance.
Okay. See, under due process or under procedure established by law, the judiciary or the judges will not check whether the law is fair, just, and reasonable. Please understand these three keywords. Under the procedure established by law, the judges will not question whether the law is fair, whether the law is just, whether the law is reasonable. But under due process of law, the judges will also check whether the law is fair, just, and reasonable. Okay? If the judiciary questions the law itself rather than what is mentioned in the law, is the law fair, is the law just, and is the law reasonable, then it is due process of law. Don't forget this. And we have borrowed this procedure established by law from where? From Japan. But the due process of law, this concept was borrowed from America. Right. And thereafter, equal protection of laws. Next one is public interest litigation, PIL, public interest litigation. Public interest litigation. Next one is electoral college. Electoral college. Electoral college. And we find this word electoral college in election of which constitutional offices? President, vice president, never forget. President and vice president. Then what is the difference between electoral college of president and electoral college of vice president? Right. My dear friends, please listen to me carefully. In case of electoral college of the president, who are included? The elected MPs of both the houses of parliament, the elected MLAs of the state legislative assemblies of the states, the elected MLAs of the union territories of Delhi, Puducherry, Jammu and Kashmir. Did you understand? Only these three categories of people are present in the electoral college of president. In the electoral college of president, we do not have the nominated MPs. We do not have the elected and nominated MLCs. We do not have the MLAs, even the elected MLAs of the dissolved state legislative assembly during president's rule. Did you understand? However, please pay attention here. The MLAs of the suspended state legislative assembly, the MLAs of the suspended state legislative assembly during president's rule are included in the electoral college of President of India. See, what do you mean by suspended state legislative assembly and dissolved state legislative assembly? Do you know this? Okay, I mean to say, I am asking you in the context of president's rule, what will happen when president's rule is imposed in a state?
First state assembly would be suspended.
Good.
Then there would be MLAs or MLAs.
And they cannot make laws. Perfect. See, my dear friends, please listen to me carefully. Whenever president's rule is imposed, three things will happen. The first thing which will happen is the state executive is dismissed. There is no more state government. The state government is dismissed. The second thing which will happen is the state legislative assembly is kept in suspended animation. MLAs are MLAs, but they cannot make laws. Once the parliament approves the president's rule, then the state legislative assembly will be dissolved within 2 months. The parliament has how many months to approve president's rule? 2 months. And by which majority? Simple majority. If parliament approves president's rule within 2 months by simple majority, then from that date itself, the state legislative assembly will be dissolved. So, I am telling you here, suppose if in any state, let us consider president's rule is imposed, and in the meantime, president's elections are taking place, the MLAs of the suspended state legislative assembly will participate in the president's election. But the MLAs of dissolved state legislative assembly will not participate in the president's election. Don't forget this. Did you understand? Yes. Which emergency is more dangerous for a state? President's rule. Why national emergency is not that much dangerous for a state? In case of national emergency, the state executive will remain as they are. The state government will remain as it is. The state legislative assembly will remain as it is. Even in national emergency, the state legislative assembly is not suspended, is not dissolved. The only thing is, some of the powers of the state legislative assembly may be assumed by the center. Are you understanding? Don't forget this. Did you get something? Yes, electoral college. And after this, please write down next constitution, speed. Let us be speed from now. Weimar Constitution of Germany. What have we borrowed from Weimar Constitution of Germany? Yes, from here we have borrowed the suspension of fundamental rights during emergency. Suspension of fundamental rights during emergency. My dear friends, please remember, out of the three types of emergencies, national emergency, president's rule, and financial emergency, only national emergency has impact on your fundamental rights. Only national emergency has impact on your fundamental rights. And your national emergency is imposed under which article? Article 352. But there are two more articles which are related to national emergency. What are those? 358 and 359. Never forget. Article 358 and Article 359. Then what is Article 358? When national emergency is imposed, okay, first I will tell you which fundamental rights gets violated or suspended. When 358 comes into operation, your Article 19 is suspended automatically. Whenever Article 358 comes into operation, your Article 19 gets suspended automatically. These two articles are like traffic signals. When one shows red, other will show green. Never forget. When this is shown green, Article 358 comes into operation, immediately Article 19 will be suspended automatically. Did you understand? Yes. Then what is Article 359? When Article 359 comes into operation, all the fundamental rights will be suspended except Article 20 and 21. Except Article 20 and 21. Okay? And this is not automatically. All the fundamental rights will be suspended, not automatically. They will be suspended by a separate presidential order. Suspended. All fundamental rights are suspended by a separate presidential order or president's order. Okay? However, in this case, the suspension is not automatic. And if you are convinced that whenever 359 comes into operation, all the fundamental rights will be suspended, let me add one word here. In Article 359, the enforceability of all the fundamental rights gets suspended. Even if the rights are available with you, you cannot approach the Supreme Court under Article 32. And you cannot approach the High Courts under Article 226 for enforcement of your fundamental rights. But in this case, Article 19 is suspended. That right is no more available with you in case of 358. Now let me make you understand what is the difference between 358 and 359. 358 is imposition of national emergency on the grounds of war and external aggression. Did you understand? 358 talks about the imposition of national emergency on the grounds of war and external aggression only. Imposition of national emergency on the grounds of war and external aggression. But Article 359 talks about imposition of national emergency on any grounds. There are three grounds of national emergency: war, external aggression, and armed rebellion. War, external aggression, and armed rebellion. If national emergency is imposed on any grounds, then all the fundamental rights will be suspended except Article 20 and 21. The only difference is there the suspension is automatic. Here, all the fundamental rights are suspended by a separate president's order and not automatically. Did you understand this? This concept we have borrowed from where? Weimar Constitution of Germany. Okay? Yes. Right. Then what have we borrowed from Canadian Constitution? We have borrowed federation with a strong center. Okay, federation with a strong center. All those features which empower the center that we have borrowed from Canadian Federation or Canadian Constitution. The first point is federation with a strong center. Second one is appointment of governors by the center. Okay, who is the governor? What is the governor doing in the states? He is an agent of the center. Are you getting? Who sends a report to the president to impose president's rule in a state? The governor. Okay. Are you getting? Yes. And third one is residuary powers to lie with the center. What are these residuary powers? Good. See, your Article 246 in 7th schedule. I repeat, Article 246 in 7th schedule deals with the distribution of legislative powers. Article 246 in 7th schedule deals with the distribution of legislative powers between center and states in terms of three lists: union list, state list, and concurrent list. Your union list consists items of national importance. Your union list consists items of those services which cuts across the states. Your union list also consists items of those subjects where regulation is required. You need not remember all this. Simply remember, union list consists items of national importance. Your state list consists items of local or regional importance. And your concurrent list consists those items which are of controversial in nature. Marriage, divorce, succession, property, inheritance. Are you getting? So, your residuary list contains those items which are not covered in the union list, state list, and concurrent list. What are those items which are now present in the residuary list? Artificial intelligence, digital currencies like cryptocurrencies, robotics, cyber laws. Are you getting? Any subject which is not mentioned in the union list, state list, and concurrent list is mentioned in the residuary list. And who can make laws on the residuary subjects? Center. And from where have we borrowed? Canadian Constitution. Right? Next one is advisory jurisdiction of Supreme Court, and that is Article 143. We already discussed Article 143. And the next is, our next country is Australian Constitution. What have we borrowed from Australia? Concurrent list. Concurrent list. Okay, please tell me, what do you mean by concurrent list? Yes, it contains those subjects where both center and the states can make laws. And in case of conflict between a central law and a state law, the central law will prevail over a state law. Now, this everyone know. Which article of the Indian Constitution says, in case of conflict between a central law and a state law, the central law will prevail over a state law?
Article 252.
Which article, please? Article 254, right down there. According to Article 254, the central law will prevail over the state's law. According to Article 254, the central law will prevail over the state's law in case of conflict between the central law and the state's law. Right? So from Australia we have borrowed concurrent list. From Australia we have borrowed the language of preamble. The language of preamble. May I please know, see, outsiders, I mean to say, please, others try to answer. How many words we have borrowed, sorry, what are the number, how many words are mentioned in preamble? Who is saying 86? Oh, I asked you not to answer, right. Initially in the original constitution, there were 83 words in the preamble, 83 words. But the 42nd Constitutional Amendment Act, 1976, has added 3 new words to the preamble: socialist, secular, and integrity. And with the addition of these 3 words, socialist, secular, and integrity, the total number of words in the preamble have now become 86. Never forget. If you count A also, then it is 86. If you don't count A as one word, then it is 85. 86 words are mentioned in your preamble, and the language of preamble we have borrowed from Australian Constitution. Don't forget. The concept of preamble from American Constitution. The language of preamble from Australian Constitution. Right? Next is the joint sitting of both the houses of Parliament. See, in case of a deadlock between 2 houses, there will be a joint sitting. And this joint sitting will be held under Article 108 of the Constitution. Okay? Article 108 provides for a joint sitting of both the houses of Parliament. Who will preside over the joint sitting? The Speaker will preside over the joint sitting. Who will call for joint sitting? President will call for the joint sitting. Is joint sitting possible in case of constitutional amendment bills? The joint sitting cannot be held to pass a constitutional amendment bill. Is joint sitting possible in case of money bills? No. Please understand. Okay? Yes. Good. Very good. Next feature which we have borrowed from Australian Constitution is freedom of trade, commerce, and intercourse. Freedom of trade, commerce, and intercourse. Freedom of TCI, trade, commerce, and intercourse. And article from 301 to 307. Article 301 to 307 deals with the freedom of trade, commerce, and intercourse. And we have also borrowed the principle of cooperative federalism from Australia. Principle of cooperative federalism. Right? This is about Australian Constitution. Now let us come to USSR. What do you mean by USSR? Union of Soviet Socialist Republics. How many countries were there in as a part of USSR? Okay, that is up to you. Okay, please write down what we have borrowed from USSR. First one is fundamental duties. Fundamental duties. Which article talks about fundamental duties? Article 51, capital A. How many fundamental duties were mentioned in the original constitution? 0. The concept of fundamental duties, the list of fundamental duties was not mentioned in the original constitution. Your 42nd Constitutional Amendment Act 1976 has added how many fundamental duties? 10 fundamental duties, 10. The 11th fundamental duty, Article 51, capital A, clause K. See, the 42nd Constitutional Amendment Act 1976 has added 10 fundamental duties. The 86th Constitutional Amendment Act 2002 has added 11th fundamental duty, and that is Article 51, capital A, clause K. Did you understand? And today we have 11 fundamental duties in our Indian Constitution, right? And thereafter, ideals of justice, social justice, economic justice, and political justice. We have borrowed from where? USSR, ideal of justice. Ideal of justice. And third one is planning commission. Erstwhile planning commission we have borrowed from USSR. Erstwhile planning commission. And what we have borrowed from France? Ideals of liberty, equality, and fraternity. Ideals of liberty, equality, and fraternity. Next, what have we borrowed from Japanese constitution? Procedure established by law, and there is one more feature which we have borrowed from Japan. The process of working of Supreme Court, please write down. The process of working of Supreme Court. We have borrowed the process of working of Supreme Court also from Japan, Japanese constitution. Right. The next is Irish constitution, Ireland. Just write down one by one. Directive principles of state policy we have borrowed from Ireland, Irish constitution. And the concept of citizenship. The concept of citizenship. Single citizenship we have borrowed from Britain. The concept of citizenship for a country. Concept of citizenship. Next one, method of election of president. Method of election of president. And the fourth feature which we have borrowed is the nomination of 12 members to Rajya Sabha. The nomination of members to Rajya Sabha. You know very well, the president nominates 12 members to Rajya Sabha from 4 fields: arts, science, social service, and literature. Okay? Yes. Right. And then what have we borrowed from South Africa? These many countries are there. South African Constitution, amendment of the Constitution, Article 368. 368. Yes. Amendment of the Constitution, Article 368. Next one is election of members to Rajya Sabha. Election of members to Rajya Sabha. And from Switzerland Constitution, right to recall. This is under this is yet to be adopted. Right to recall. Right to recall from Switzerland Constitution. Right to recall from Switzerland Constitution. And next one is from Government of India Act 1919. Please keep side heading Government of India Act 1919. Not mentioned in your textbook, but please write down. What have we borrowed from Government of India Act 1919? Anyone? Okay, good. Bicameralism, very good. It is 1935. What I am asking is Government of India Act 1919. We have borrowed the concept of bicameralism. We borrowed the concept of parliamentary committees. We also borrowed the very institution for which you are writing examinations. UPSC. I mean to say at that time it was Central Public Service Commission. CPSC, Central Public Service Commission, Government of India Act 1919. And your CPSC was formed on the recommendations of the Lee Commission on Superior Civil Services. Your UPSC, which was at that time known as CPSC, was formed on the recommendations of Lee Commission, LEE, Lee Commission on Superior Civil Services, 1923-24, Lee Commission on Superior Civil Services. Then who was the first chairman of your CPSE? Sir Ross Barker. Okay, the first chairman of CPSE was Sir, 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 ROSS, Ross Barker. Did you understand? Yes. Now, what have you borrowed from Government of India Act 1935? We have borrowed more than 250 provisions from Government of India Act 1935. More than 250 provisions. Rather, I would say the structural part of the Constitution we have borrowed from Government of India Act 1935. Please write down what we have borrowed. The first one is the federal structure. We have borrowed the federal structure. Second one, judiciary. Office of Governor. Third is Office of Governor. Office of Governor. Article 153 to 162. Article 153 to 162. Next one is emergency provisions. Emergency provisions from Article 352 to Article 360. Emergency provisions from Article 352 to 360 in Part 18 of the Constitution. In Part 18. 352 to 360 in Part 18. Next one is Public Service Commissions. Public Service Commissions. UPSC, State Public Service Commissions, Joint Public Service Commissions. Okay, Public Service Commissions. Next one, which is the most important one, is your 7th schedule. Article 246 in 7th schedule. Very, very important among all these. Article 246 in 7th schedule. What is Article 246? It deals with the distribution of legislative powers between center and states. It deals with the distribution of legislative powers between center and states in terms of 3 lists, you know very well. Union list, state list, concurrent list. Then how many subjects were there in the union list? Initially, when the Constitution came into force. When the Constitution came into force, how many subjects were there in the union list? 97. And presently, how many subjects are there in the union list? 98. Are you understanding? And how many subjects were there in the state list? Initially, there were 66 subjects, and now we have 59 subjects. 59. Okay? Yes. And in the concurrent list, initially there were 47, and today we have 52. Now, may I please know how these 5 subjects increased in the concurrent list? The 5 subjects were transferred from the state list to the concurrent list. By which Constitutional Amendment Act? 42nd Constitutional Amendment Act 1976. And what are those 5 subjects? Education, forest, wildlife, weights and measures, administration of justice. Okay, and one more? Everything completely, no? Forest, education, wildlife, weights and measures, administration of justice. Okay, these 5 subjects were transferred from concurrent subject state list to the concurrent list. Okay, yes. And next one, from what we have borrowed from Government of India Act 1935 is ordinance making powers of the President and the Governor. Ordinance making powers of the President and the Governor. Ordinance making powers of the President and the Governor. Right. And my dear friends, what do you mean by schedules? What are schedules? How many schedules were there in original Constitution? And how many are do we have now? 12. Okay, initially there were 8 schedules of the Indian Constitution, and presently we have 12 schedules of Indian Constitution. Now, what do you mean by a schedule? A schedule is an explanatory note or addendum to the Constitution. Explanatory note or addendum to the Constitution. It is a list that was enacted at the end of Constitution. You need not know this, but a schedule is an addendum or explanatory note addendum or explanatory note to the constitution. What is the schedule? It is a list or table that was added at the end of constitution. It is a list or table that was added at the end of constitution. Okay? Yes. And I should not ask this, but what is first schedule? What is first schedule? What does first schedule contains? Nikhil? Yes. The first schedule contains the names of states, union territories and their territorial extent, and from article 1 to 4. So what is the significance of first schedule? First schedule, names of states, union territories and their territorial extent. It's okay. Everyone will say. What is the importance or significance of first schedule? No. I mean to say, what you can find in first schedule? You can find the names of 28 states and 8 union territories. And the significance of first schedule is, whenever any new state is formed, whenever any changes takes place in the names, area, boundary of any state, they will get reflected where? In the first schedule. For example, in your first schedule before 2014, the name Telangana was not there. As Telangana was formed in 2014, now if you see your first schedule, the name will get reflected here. So any changes which takes place in the states, that will get reflected in your first schedule. Did you understand? Then what are the 8 union territories from north to south? From north to south, first one is Ladakh, second Jammu and Kashmir, third is Chandigarh, fourth is Delhi, Daman and Diu, Dadra and Nagar Haveli, and after that we have Lakshadweep. After that we have Puducherry, and the last one is, did you understand? Yes, this is all about first schedule. The first schedule deals with the names of states, union territories and their territorial extent. Then what is second schedule? It talks about the emoluments, allowances and privileges of some of the important constitutional functionaries like president, vice president, governor, speaker and deputy speaker of Lok Sabha, state legislative assemblies. Are you getting? Chairman of Rajya Sabha and deputy chairman of Rajya Sabha, CAG and so on. Now comes the third schedule. What is third schedule? It deals with the oath or affirmations of whom? Oath or affirmations of whom? Huh? Okay. Yes. See, third schedule deals with the forms of oath and affirmations of union ministers, state ministers, Supreme Court and High Court judges, MPs and MLAs, CAG and so on. Now my question to you is, what is the difference between an oath and affirmation?
Oath is taken in the presence of
What is a moral?
affirmation is taken with the normal, without taking the God secularism.
Good. Good. Oath means taking pledge or promise in the name of God. If you have seen Bahubali movie, Bhallala Dev has taken oath. Why? He took pledge or promise in the name of Lord Shiva. But what did Bahubali do? Did he take pledge or promise in the God's name? He took affirmation in the name of his mother name. Are you understanding? Please understand. But what is important from examination perspective is, the oath of which constitutional functionary is equal to whom? Are you getting? The oath of Chief Justice of India is equal to the oath of Supreme Court judges. And that is almost equal to the oath of Attorney General of India. Please write down about oath. We are discussing about the third schedule, the oath of CJI. The oath of CJI is equal to oath of Supreme Court judges is equal to Attorney General of CAG. We can write this one. Please write down. Oath of CJI is equal to oath of Supreme Court judges is equal to oath of CAG. CAG. Attorney General has same qualifications as that of Supreme Court judge. Next, write down. The oath of MPs is equal to oath of MLAs. Oath of MPs is equal to oath of MLAs is equal to oath of MLCs. MPs is equal to MLAs is equal to MLCs. Next, the oath of union ministers is equal to oath of state ministers. But please remember, the oath of president and the governor and vice president are not mentioned in third schedule. Okay, the oath of president, vice president and governor are not mentioned in third schedule. They are mentioned in different articles. Yes, please write down there. If it is president, it is article 60. For president's oath, it is article 60. It is not mentioned in third schedule. And if it is vice president's oath, it is article 69. And governor's oath, article 159. Oath of president, article 60. Vice president's oath, 69. And governor's oath, 159. Don't forget. Yes. Now next is important. Fourth schedule, allocation of seats to the states and union territories in Rajya Sabha.
The oath of union minister is not equal to the oath of state minister.
Almost equal, just union minister will say, I am taking oath as union minister. Only that word changes. Union minister, state minister. Except that everything is same.
So,
Huh?
what else is the union minister?
State ministers iskora? No, almost same. The only thing is union ministers, they take oath as union ministers. They say, I am a union minister. He will say, I am a state minister. That's all. Okay. Thereafter, what is the fourth schedule? Allocation of seats to the states and union territories in Rajya Sabha. Allocation of seats to the states and union territories in Rajya Sabha. Now, if we take as you are aware, how Rajya Sabha, how the members of Rajya Sabha are represented on the basis of what? Population. If we take representation of states in Rajya Sabha from states, representation of states now if I write here maximum representation and here minimum representation, maximum representation and minimum representation, what are the first four states which I should write here in case of maximum representation? First is UP. UP has how many seats? 31 seats. Representation of states in Rajya Sabha. In Rajya Sabha. UP has 31 seats. Next, the second state is Maharashtra. It has 19 seats. Maharashtra has 19 seats. Okay. Yes. Third one is Tamil Nadu has 18 seats. And your West Bengal and Bihar has 16 seats. West Bengal and Bihar 16. And your Tamil Nadu has 18 seats. Then what about minimum representation? Minimum representation. Please remember one keyword here. Rather than writing all the northeastern states names except Assam, please write down there all northeast states except Assam plus Sikkim plus Goa has one MP seat in Rajya Sabha. All northeastern states except Assam plus Sikkim and Goa each has one MP seat in Rajya Sabha. Right? Then I wrote here except Assam. Good. Assam has 7 seats. Your Telangana has 7 seats. And what is the other state which has 7 seats? Punjab. Never forget, Telangana is equal to Assam is equal to Punjab has 7 seats in Rajya Sabha. Don't forget this. And AP has 11 seats, my dear friends. From Andhra Pradesh, we have how many seats in Rajya Sabha? 11. What are the other states which have 11 MP seats in Rajya Sabha as that of Andhra Pradesh? I am not asking this question as like this only. If you go to interview, for suppose, if an examiner wants to know about your state, how much you are aware, what would be your answer? If AP has 11 seats, then there are 2 more states which has 11 seats as that of AP. Our students, anyone? Please write down here, Andhra Pradesh is equal to Gujarat is equal to Madhya Pradesh has 11 seats. in Rajya Sabha. Don't forget these two. Okay? Yes. Then what is the representation of union territories? Until now what you have seen is the representation of states in Rajya Sabha. Then what is the representation of union territories in Rajya Sabha? First let me check. How, according to you, out of 8 union territories, how many union territories will have their representatives in the Rajya Sabha? Only 3? Why only 3?
They have elected us.
Very good. Who elects the MPs of Rajya Sabha? Your MLAs. And out of 8 union territories, how many union territories have MPs in Rajya Sabha? How many union territories have state legislative assemblies? Only 3. One is Jammu and Kashmir, second is Delhi, third is Puducherry. Okay, are you getting? Now, Jammu and Kashmir has how many MP seats in Rajya Sabha? Jammu and Kashmir, Delhi and Puducherry, please. Jammu and Kashmir has how many? Jammu and Kashmir has 4. Delhi has 3. Delhi has 3 and Puducherry has 1. Jammu and Kashmir has 4. Delhi has 3 and Puducherry has 1 MP seat in Rajya Sabha. Then what about the rest 5 union territories? Ladakh, Daman and Diu, Dadra and Nagar Haveli, Chandigarh, yes, Lakshadweep and Andaman and Nicobar, they have 0 MP seats in Rajya Sabha. Rest 5 union territories, they don't have MP seats because the first reason is their population is less, okay, they don't have state legislative assemblies. Who should elect the MPs of Rajya Sabha? MLAs. They don't have state legislative assemblies. How will they represent? They get represented in Rajya Sabha? Yes. The rest 5 union territories have 0 MP seats because of less population, and second one, B, they don't have state legislative assemblies. They don't have state legislative assemblies. These 3 union territories have state legislative assemblies. Therefore, they got represented in Rajya Sabha. Okay? Yes. Now, which commission have recommended for equal representation of central states in Rajya Sabha? Which commission has recommended for the equal representation of states in Rajya Sabha? The Punchi Commission on Center-State Relations. Don't forget this. The Punchi Commission on Center-State Relations have recommended. The Punchi Commission on Center-State Relations have recommended for equal representation of states in the Rajya Sabha. Equal representation of states in the Rajya Sabha. Equal representation of states in Rajya Sabha. Now, what is the American Parliament called? What is the American Parliament called? No, it's not Senate. You are saying something? Congress. The American Parliament is known as Congress. What is the upper house of American Congress called? Senate. Okay? Senate. And the lower house of American Congress is known as House of Representatives. So in Senate, in America, how many states are there? 50 states. And each state has 2 members in American Senate. Never forget. In America, we have equal representation of states in Rajya Sabha, in Senate. So, Punchi Commission has said, in India also, there must be equal representation of states in Rajya Sabha rather than on the basis of population. Don't forget this. And what is the specialty of Rajya Sabha? There is no reservation in case of Rajya Sabha. You can find reservation in almost all the institutions of India. You cannot find reservations in 2 places. One is Rajya Sabha, second is state legislative councils. Don't forget this. Rajya Sabha, in Rajya Sabha, we don't have any provision for providing reservations. Are you getting, my dear friends? Yes. Then what is 5th schedule? It deals with the control and administration of scheduled areas and tribes. Scheduled areas and scheduled tribes in any state of India except ATM square. Now, except ATM square. What is this ATM square? Assam, Tripura, Meghalaya and Mizoram. This ATM square, these states are covered in which schedule? Sixth schedule. Okay, are you getting? And how many states in India have scheduled areas? 10. What are those? At least you must know Andhra Pradesh and Telangana have scheduled areas. That much is enough. Now, who declares a scheduled area? The President of India declares an area as scheduled area. Don't forget. The President of India declares an area as scheduled area. Now, which are more autonomous? Are fifth schedule areas more autonomous or sixth schedule areas are more autonomous? Your sixth schedule areas are more autonomous than fifth schedule areas. Please don't forget. Right? And sixth schedule, I already told you, it deals with control and administration of tribal areas in 4 states. ATM square. Assam, Tripura, Meghalaya and Mizoram. And which article deals with the sixth schedule? Which articles deals with the fifth schedule? First tell me about fifth schedule. Article 244 clause 1. If you did not write, please write down. Article 244 clause 1. Article 244 clause 1. And about the sixth schedule you write down 244 clause 2. 244 clause 2 and Article 275. 244 clause 2 and Article 275. Did you write? In case of sixth schedule, write down one note point. The governor determines, the governor of a state determines autonomous regions. The governor of a state determines autonomous regions and autonomous districts. The governor of a state determines the autonomous regions and autonomous districts in the sixth schedule areas. In the sixth schedule areas. Now, what is the difference between autonomous region and an autonomous district? If within one district, if there are a number of tribes, different tribes, then the governor will divide that autonomous district into autonomous regions. Did you understand? Fifth schedule area, who has the power to declare an area as fifth schedule area? President. Who has the power to declare sixth schedule areas? Governor. Don't forget, right? Now about seventh schedule already we discussed, no? Article 246 in seventh schedule deals with the distribution of legislative powers between center and states in terms of 3 lists: union list, state list, concurrent list. Union list consists items of national importance. Initially 97, presently we have 98. Okay, sir, no? In state list initially 66, now we have 59. In concurrent list initially we had 47. Now we have 52 subjects. Perfect. Now, who make laws on the subjects mentioned in the union list? Parliament. Parliament alone. Only Parliament can make laws on the subjects mentioned in the union list. Then who can make laws on the subjects mentioned in the state list? Please understand here, during normal conditions. During normal conditions. Please listen to me carefully. With respect to state list subjects, I am saying, during normal conditions, only states can make laws on the state subjects. During normal conditions. But your constitution contains 5 extraordinary circumstances where the parliament will make a law on the state subjects. I repeat, during normal conditions, the state legislatures can make laws on the state subjects. But there are 5 extraordinary circumstances, 5 situations where the parliament will make a law on the state subjects. What are those?
49, 250, 252, 253.
Yes. Very good. I am happy that you remembered even after 4 to 5 months. Very good. Good. Article 249, 250, 252, 253, 356. Never forget these 5 articles, these 5 circumstances where the parliament can make a law on state subjects. 249, 250, 252, 253, 356. Now what is 249? What is Article 249, Nikhil? Neha? That is good, but I need one more keyword there. One keyword. What you are saying is half answer. I need more. No? Anyone in this class? Bhavya, what is Article 249? Manoj? Rakesh? On the grounds of national interest. On the grounds of national interest. If Rajya Sabha passes a resolution by special majority type 1, special majority type 1, on the grounds of national interest, if Rajya Sabha passes a resolution by special majority type 1, then the parliament can make a law on the state subject. This is common. Parliament can make a law on the state subject. This is common for all these 5. And here what you have to write? 249. On the grounds of what? National interest. Never forget this word. Or in national interest also you can write. On grounds of national interest. If Rajya Sabha passes a resolution by special majority type 1. If Rajya Sabha passes a resolution by special majority type 1. If Rajya Sabha passes a resolution by special majority type 1. Now what is this type 1, type 2? Wait for a few more minutes. On the grounds of national interest, first keyword. Second keyword, if Rajya Sabha passes a resolution by special majority type 1, then the parliament can make a law on the state subject. Then what is this? What is Article 250? Very good. During national emergency. During national emergency, the parliament can make a law on the state subject. Then what is Article 252? You said something? When 2 or more states request the parliament. Yes. When 2 or more states request the parliament to make laws on state subject. To make laws on state subjects, then the parliament can make laws on the state subjects. Never forget. Then what is 253? Others please. Anyone? What is Article 253? To implement any international treaty, agreement or convention. To implement any international treaty, agreement or convention, international treaty, international agreement or convention, the parliament can make a law on the state subjects. Then what is Article 356? Yes, Article 356. During President's rule, the parliament can make a law on state subjects. Now may I please know why during President's rule the parliament will make a law on state subjects? Because the state legislative assembly is dissolved. Initially the state legislative assembly will be kept in suspension or suspended animation. But once the parliament approves the President's rule, the state legislative assembly is dissolved. Then who should make laws for the states? Parliament will make laws for the states. Did you understand? So never forget these 5 articles: 249, 250, 252, 253, 356. But for your kind information, I will add one more point here. Under Article 249 and under Article 250, Parliament has concurrent powers of lawmaking. Under Article 252, 253 and 356, Parliament has exclusive powers of lawmaking. And under Article 249 and under Article 250, Parliament has concurrent powers of lawmaking. Now, who will explain me why Parliament has concurrent powers of lawmaking under Article 249 and 250, and why the Parliament has exclusive powers of lawmaking under Article 252, 253, and 356?
State laws can override parliamentary laws. State laws can override parliamentary laws.
Here,
Center law prevails over state.
you ma?
Surrendering of powers by state.
Please understand, in this case, the state legislative assembly exists as it is. During national emergency, I told you, the state legislative assembly will not be suspended, will not be dissolved. At that time also, the state legislative assembly can make laws. Are you understanding? In this case, the state legislative assembly can make laws. In this case, the parliament can also make laws. As both parliament and the state legislative assembly are able to make laws, that is the reason I made you write, Parliament has concurrent powers of lawmaking. But in this case, the state legislative assembly will not make laws. In these three cases, only the Parliament will make laws on the state subjects. That is the reason I made you write, Parliament has exclusive powers of lawmaking. Did you understand? Yes.
So consent of states is required.
No.
Under 253 article, what if state is not agreed?
See, you tell me one thing. Who will represent in international forums? President or Prime Minister? Is it center or states? Center. Who understands international treaties in better manner? Center or states? Center. That is the reason the states will not make laws on international treaty or agreement or convention. Are you understanding? Yes. In this case, see, in this case, the states themselves are asking the center, asking the parliament to make laws. So here, the state will not make law. In this case, under Article 356, there is no state legislative assembly. They will not make law. And under Article 253, the states will not make law because it is not they who have participated in international treaties, forums, conventions. So who has participated? The center. Who represented India? It might be president or the prime minister or any other diplomats. So who will make law? Center. Did you understand now? Okay. Don't forget this. There are 5 articles which under 5 articles the parliament can make laws on the state subjects during extraordinary circumstances. During normal conditions, who can make laws? States. During extraordinary circumstances, who can make laws? Parliament. Don't forget this. Yes. The next is 8th schedule. This is all about, see, I can make you write more, but this is not the correct time to make you write. There are so many points which I can make you write otherwise. Then, what is 8th schedule? 8th schedule deals with what? The languages recognized by Constitution. Initially, how many languages were recognized by the Constitution? 14. But presently, how many languages are recognized by Constitution? 22. But out of these 22 languages, please remember, our Hindi and Urdu have been recognized by the Constitution, but the languages which are mostly spoken like English and Bhojpuri, Biharis speak Bhojpuri language. These 2 languages are not yet recognized by the Constitution. Are you getting? English and Bhojpuri are not yet recognized by the Constitution. They are not mentioned in 8th schedule. Okay, never forget. Then which articles are related with 8th schedule? Article 344 clause 1. 8th schedule, please write down there. Article 344 clause 1 and Article 351. Right? And which languages were added by 21st Constitutional Amendment Act 1967? Sindhi. By 21st Constitutional Amendment Act 1967, Sindhi was added to the 8th schedule. By 71st Constitutional Amendment Act 1992. Next one is 71st Constitutional Amendment Act 1992. There you write down Konkani, Manipuri, Nepali. Konkani, Manipuri, Nepali. Next, 92nd Constitutional Amendment Act. 2003, 92nd Constitutional Amendment Act. Bodo, Dongiri, Maithili and Santali. Bodo, Dongiri, Maithili, Santali. Right? Next one is 96th Constitutional Amendment Act 2011. Yes, Oriya was renamed as Odia. Oriya was renamed as Odia. And does India have a national language? No. Is Hindi a national language? No. Hindi is not a national language. Don't forget it. Hindi is an official language. Good. Hindi and English are official languages of the Union. Okay? Yes. Next, what is 9th schedule? Which article deals with the 9th schedule? What is 9th schedule? The laws placed under the 9th schedule are immune from judicial review. If any law is placed under the 9th schedule, even if that law violates your fundamental rights, those laws cannot be questioned by the judiciary. And your Article 31 clause 31 capital B, which talks about 9th schedule, was added to the Constitution by first Constitutional Amendment Act 1951. 9th schedule deals with what? The laws placed in the 9th schedule are immune from judicial review. Normally, which laws were placed under the 9th schedule? The laws related to land reforms, the laws related to acquisition of estates. Okay? Right. And which article? Article 31 capital B. And see, the Supreme Court in ARK versus the state of Tamil Nadu case 2007. The Supreme Court in ARK versus the state of Tamil Nadu case 2007 has said that if any law is placed after 24th April 1973, what is this date? 24th April 1973? It is the date of Keshavananda Bharati case judgment. Any laws which are placed after 24th April 1973, they are not immune from judicial review. Okay? Yes, don't forget this. And after that we have 10th schedule, which deals with anti-defection laws. Yes, what do you mean by defection? When a person wins from one political party and he jumps into another political party, it is known as defection. And to stop this defection, the government of India has brought the anti-defection laws. And which schedule deals with anti-defection laws? 10th schedule. And this 10th schedule was added to the Constitution by which Constitutional Amendment Act? 52nd Constitutional Amendment Act 1985. And is the 10th schedule also applicable to local bodies?
No.
No, please understand. The 10th schedule is not applicable to Panchayati Raj institutions and urban local bodies. Please write down, this point is not mentioned in your books. Anti-defection law is not applicable to Panchayati Raj institutions and urban local bodies. And then what is 11th schedule? It talks about what? The panchayats. Which article is related to 11th schedule or mentioned in 11th schedule? 243? 243? It is G, 243G. Okay? 11th schedule, it is article 243G. It talks about the panchayats. And how many matters are included in 11th schedule? 29 matters. Good. Then the 12th schedule deals with the municipalities, article 243W. 243W. Article 243W, the municipalities, the 12th schedule consists of 18 matters. 18 matters. And your 11th schedule was added to the Constitution by 73rd Constitutional Amendment Act 1992. And your 12th schedule was added to the Constitution by 74th Constitutional Amendment Act 1992. Don't forget. Right. How many types of majorities are mentioned in Indian Constitution? What do you mean by majority? Is the word major? Did the Constitution classify the types of majorities in the Indian Constitution? Then how do you come to know that there are 4 types of majorities in the Indian Constitution? No? Good. See, my dear friends, the next topic which I am going to discuss with you is the applications of majorities or different types of majorities in the Indian Constitution. See, though the Constitution did not specify, did not classify the types of majorities of Indian Constitution, when you read different articles of the Indian Constitution carefully, you come to know that there are basically 4 types of majorities. How many types? 4 types of majorities in the Indian Constitution. First one is simple majority. The simple majority is also known as working majority or functional majority. Why is it called simple or functional majority? Because it contains the maximum number of applications in the parliamentary business. First, write down simple majority. Second one is absolute majority. First one is simple, second one is absolute, third one is effective majority, and fourth one is special majority. Right? Now let me discuss just for 5 minutes about simple majority. Simple majority is also known as working majority or functional majority. The simple majority is also known as working or functional majority. And what do you mean by simple majority? The majority which is not less than 50% of members present and voting. For example, see, if this class strength is, actually the capacity of this class is 200 members, let us assume. If 100 members are present now, then what is the simple majority? Simple majority is the majority not less than. Not less than means more than 50% of members present and voting. So your simple majority is 51. Did you understand? Simple majority is the majority not less than 50% of members present and voting. And your simple majority is also known as working majority or functional majority. Why? It has maximum number of applications in the parliamentary business. We have more than 25 applications of simple majority in the parliamentary business. Are you getting? Okay, and when your constitution does not classify, does not mention the type of majority, it must be understood as simple majority. And it is not a fixed majority. Why? It depends on number of members present and voting. Today 100 members are present, tomorrow 120 might be present. So your simple majority is not a fixed majority. Then what are the applications of simple majority? Okay. At least see, I need two examples from each one of you. Why? Because see, these are now by now you must be in a position to tell at least two examples, please.
Formation of states and normal bills.
Formation of states and okay, you
Normal bills.
no ordinary bills. Okay, ordinary bills. Yes, more.
Role of president.
Yes. Okay, I got. Come on, more, Rakesh. What are the applications of simple majority? Lok Sabha has special powers to withdraw national emergency by simple majority. Perfect. More. Okay, to amend second, fifth, and sixth schedules. Good. Quorum. Very good.
Judges, using judges.
Puny judges. What do you mean by puny judges?
Other than CJI.
Very good. The number of judges other than the Chief Justice of India are known as puny judges. At present, if there are 34 judges, one is Chief Justice of India. So Chief Justice of India plus 33 judges we have as of now. These 33 judges who are other than the CJI are known as puny judges. And tomorrow, if you want to increase the number of puny judges, the number of judges in the Supreme Court, then the Parliament must pass the bill by simple majority. Okay, now let me tell you the applications of simple majority one by one, my dear friends. To pass ordinary bills, money bills, financial bills. To pass ordinary bills, money bills, financial bills, point number 1. Ordinary bills, money bills, financial bills. Second one. Okay, they are writing. To pass ordinary bills, money bills, and financial bills. Second point. To pass no confidence motion, confidence motion, adjournment motion, To pass, no confidence motion, confidence motion, adjournment motion, motion of thanks, and censure motion. We need which majority? Simple majority. Friend, do you have any doubt? Any doubt? To pass ordinary bills, money bills, financial bills, to pass confidence motion, no confidence motion, censure motion, adjournment motion, motion of thanks. Next, write down the next applications. To approve president's rule. To approve president's rule. Next, to approve financial emergency. To approve president's rule, financial emergency. Next is for election of speaker and deputy speaker of Lok Sabha and state legislative assemblies. For election of speaker and deputy speaker of Lok Sabha and state legislative assemblies. Did you write? Next point. To remove the chairman of Rajya Sabha. To remove the chairman of Rajya Sabha. To remove the chairman of Rajya Sabha, that is vice president, friends. To remove the vice president, please write down vice president so that you can get one clarity. To remove the vice president, the Lok Sabha requires simple majority. To remove the vice president, the Lok Sabha requires simple majority. There you write, yes? Rajya Sabha. In Rajya Sabha, we need effective majority. In Lok Sabha, to pass a resolution to remove the vice president, we need simple majority. Huh?
Vice President, while Lok Sabha is chairman of Rajya Sabha, Lok Sabha like passed.
Vice president, see, whenever the president is not there, who acts as the president? Vice president. Vice president occupies second highest position in this country. Okay, are you getting? That is the reason in Rajya Sabha, we pass a resolution by effective majority, but the same resolution is passed in Lok Sabha by simple majority. Only then the vice president can be removed. Did you understand? Yes. Okay, where are we? Yes, to remove the chairman, Lok Sabha requires simple majority. Then you write down to amend the 2nd, 5th and 6th schedules. To amend 2nd, 5th and 6th schedules. To amend 2nd, 5th and 6th schedules, we require which majority? Simple majority. Next. The constitutional amendment bills, CABs. The constitutional amendment bills. The constitutional amendment bills which affects the federal provisions. The constitutional amendment bills which affects the federal provisions need to be ratified by half of the state. The constitutional amendment bills which affects the federal provisions need to be ratified by half of the states by simple majority. The constitutional amendment bills which affects the federal provisions needs to be ratified by half of the states by simple majority. Don't forget this. Any doubts? Is everything fine? Yes. Next, please write down other applications. Article 2, admission or establishment of new states. Article 2, rather than writing admission or establishment of new states. If you know this, please write down just Article 2. And if you don't know, please write down admission or establishment of new states. Next is Article 3, to form a new state. Article 3, to form a new state or to form a new state or alteration of areas, names and boundaries of existing states. To form new states, alteration of areas, names and boundaries of existing states. Next one, salaries and allowances of MPs. Salaries and allowances of MPs. Do you know which act? The Salary and Allowances of MPs Act, 1954. This act was passed by Parliament by simple majority. The Salary and Allowances of MPs Act 1954. That is the reason I made you write salaries and allowances of MPs. Next one, next application is quorum, Article 100. Quorum, quorum. In brackets you write down Article 100. Article 100. Next you write down privileges of Parliament. Privileges of Parliament, comma, its members and its committees. Privileges of Parliament, comma, its members and its committees. Privileges of Parliament, comma, its members and its committees. So immediately, now already you know which articles to write. Again, I should not tell you. Article 105 for MPs, Article 194 for MLAs and MLCs. Next one, use of English language in the Parliament. Use of English language in the Parliament. Use of English language in the Parliament. Which article, please? Use of English language in Parliament. Article 120. Article 120. Okay? See, actually, this English language was to be used in the Parliament only up to 15 years from the commencement of Constitution. When did the Constitution commence, or when was the Constitution implemented? From 26 January 1950. So, your English language was to be used in the Parliament until 1965 only. But even today, we are using English language. May I please know by what provision we are using English language along with Hindi even today? The Official Languages Act 1963. Okay, the Official Languages Act 1963 allowed the use of both Hindi language and English language. The Official Languages Act 1963. The Official Languages Act 1963. It allowed the use of both English as well as Hindi in the Parliament. Right? Next one, official languages. Next application. Official Languages Part 17. Official Languages Part 17. And do you know what are official languages of the Union? Hindi and English. No, never forget, Hindi and English are official languages of the Union. How many applications did you write? Only 13? Okay. Did you mix all applications, earlier ones? Okay, got it. Next, write down puisne judges, P-U-I-S-N-E, puisne judges, number of judges in Supreme Court. P-U-I-S-N-E, puisne judges. If you want to increase the number of judges in Supreme Court, puisne judges means number of judges other than Chief Justice of India. For example, as today we have 34 judges in Supreme Court. We have one Chief Justice of India plus 33. These 33 judges are known as puisne judges. And how to increase the number of judges? The Supreme Court Number of Judges Amendment Act 2019 has increased the number of judges in the Supreme Court from 1 to 33. Which is that act? Supreme Court Number of Judges. This is the actual act, 1956. And this will get amended every time. And recently, the Supreme Court Number of Judges Amendment Act 2019. And this has increased this number to this one, 1 plus 33. The Supreme Court Number of Judges Amendment Act 2019. And now again, if the number of judges have to be increased, for example, in 2028, example, then it will be Supreme Court Number of Judges Amendment Act 2028, 1 plus 37, 38, whatever it is. Did you understand? But the parent act is Supreme Court Number of Judges Act 1956. And the Parliament has enacted this act by which majority? Simple majority. Did you understand? Yes. Next, write down. to create or abolish a state legislative council. To create or abolish a state legislative council. To create or abolish a state legislative council, the parliament requires simple majority. The parliament requires simple majority. Next one, how many did you write, please? Next, write down conferment of more jurisdiction onto the Supreme Court. Conferment of more jurisdiction onto the Supreme Court. Conferment of more jurisdiction onto the Supreme Court. In brackets, you write down Article 138. Article 138. Will someone give me example of how the parliament can confer or can give more powers to the Supreme Court? One example which you know. Anyone?
Ban on crackers.
Conferment of more jurisdiction onto the Supreme Court by the parliament.
Prohibition.
See, for example, please listen to me. The parliament enacted the Presidential and the Vice Presidential Elections Act 1952. I repeat, the parliament enacted the Presidential and the Vice Presidential Elections Act 1952, and according to this act, the election disputes related to President and Vice President can be heard only by the Supreme Court. Now you tell me, did the power of Supreme Court increase or decrease? Increased. Did the parliament confer more powers onto the Supreme Court or not? Yes. The Presidential and Vice Presidential Elections Act 1952. It conferred more powers onto the Supreme Court. This act has said any election disputes related to the President and Vice President will be determined or decided by the Supreme Court only. That is, the Supreme Court has exclusive jurisdiction to deal with the election disputes of President and Vice President. That is how the Parliament increased the powers of Supreme Court by simple majority, by passing that law by simple majority. Next, write down few more applications. To withdraw national emergency, your point. To withdraw national emergency, the Lok Sabha must pass a resolution by special majority. To withdraw national emergency, the Lok Sabha must pass a resolution by simple majority. Next one is acquisition. Next point is related to citizenship. Acquisition and termination of citizenship. Acquisition and termination of citizenship. For example, the Citizenship Act 1955. This act was passed by the parliament by which majority? Simple majority. And this act contains the matters related to the acquisition and termination of the Indian citizenship. Are you getting? Yes. I think I have made you write down few more. The rules of procedure in the parliament. The rules of procedure in the parliament. The rules of procedure in the parliament. And which article deals with the rules of procedure in the parliament? Article 118. Article 118. It deals with the rules of procedure in the parliament. Right? Yes. At least there are number of applications now in your book. Okay. Those applications I have made you write from different textbooks. Please understand. I have 5 more, but yes. Huh? Yes. Please now. This is all about simple majority. Right? Then what is the second type of majority? Absolute majority. What do you mean by absolute majority? Absolute majority is the majority not less than 50% of total membership of the house. Absolute majority is the majority not less than 50% of total membership of the house. So let me make you understand, my dear friends. Just before I made you write more than 20 to 25 applications of simple majority, here let me tell you, absolute majority has 0 applications in the parliamentary business. Absolute majority has no applications in the parliamentary business. Did you understand? Then what is the use of absolute majority? It is used only to form the governments after the general elections to Lok Sabha and state legislative assemblies. To know that magic figure, huh? Yes. Absolute majority, if you want I will explain. Absolute majority is the majority not less than 50% of total membership of the house. For example, we are talking about the second type of majority, that is absolute majority. Not less than 50% of total membership of the house. See, 50% means how much? 1/2 into what is the present membership of Lok Sabha? 543, and if you calculate it will be around 271.5. I am writing 272, and this is the magic figure to form the government at the center. This is the magic figure, required number to form government at the center. This is the magic figure to form the government at the center, and your absolute majority has no applications in the parliamentary business, right? Yes. Now, the third type of emergency after this simple absolute majority is effective majority. But you don't find this word effective majority in the constitution. Rather than effective majority, what you find is all the then members. In your constitution, you find this word all the then members. You find this word all the then members. Wherever in the constitution you find these words all the then members, you have to understand the constitution is talking about effective majority. Okay? Yes. Then what do you mean by effective majority? Effective majority is the majority not less than 50% of effective strength. See, in simple majority I told majority not less than 50% of members present and voting in case of simple majority. In case of absolute majority, I told you majority not less than 50% of total membership of the house. Now in case of effective majority, I am saying not less than 50% of effective strength of the house. Effective strength of the house. Now comes the question, what do you mean by effective strength of the house? Yes. Effective strength is equal to total membership minus vacancies. Total membership minus vacancies. Now how can a vacancy be created? A vacancy can be created. Yes. A vacancy can be created by death of a MP, by resignation of a MP, by removal of a MP. Don't forget this. A vacancy can be created by death of a MP, member of parliament, by removal or by resignation of a member of parliament. And please tell me, is effective majority a fixed majority? Why? Can you guess vacancies? Can you guess tomorrow which MP will die? Are you getting? I mean to say, effective majority is also not a fixed majority like the simple majority. Then is absolute majority a fixed majority? Yes. It depends on 50% of total membership of the house, which is fixed. Okay. Then what are the applications of effective majority? Please remember one universal application. To remove the presiding officers of any house, we need effective majority. For example, to remove the vice president, who is also the chairman of Rajya Sabha, the Rajya Sabha must pass a resolution by effective majority. Did you understand? Please write down some applications of effective majority. Removal of chairman of Rajya Sabha or vice president. Yes. Removal of chairman of Rajya Sabha. A resolution must be passed in Rajya Sabha by effective majority. Point number 1. In brackets, please write down Article 67, Clause P. Removal of chairman of Rajya Sabha. That article is Article 67, Clause B. Next, second application, please. Removal of deputy chairman of Rajya Sabha. Removal of deputy chairman of Rajya Sabha. Article 90, Clause C. Article 90, Clause C. These articles, if you remember, well and good. If you don't remember, nothing will happen. But if you write in mains answer, if you write articles, at least half mark you will get extra. That much I can say. Are you getting? Are we all in polity papers? What we find? Subject matter. No articles will be mentioned. Even in your textbooks, you see, articles will not be mentioned. But right from morning, what you are writing? Articles. Never forget. Then removal of chairman of Rajya Sabha, Article 90, Clause C. Next, write down next application. Removal of deputy chairman, speaker and deputy speaker of Lok Sabha. Removal of speaker and deputy speaker of Lok Sabha. Removal of speaker and deputy speaker of, see like this, Lok Sabha and state legislative assemblies. In one point I am making you write. Removal of speaker and deputy speaker of Lok Sabha and state legislative assemblies. So in brackets you write down Article 94, Clause C. Article 94, Clause C. And in this case, Article 179 here. State legislative assemblies, there you write down Article 179, Clause C. Article 179, Clause C. Okay, next write down one more application. The removal of chairman and deputy chairman. Removal of chairman and deputy chairman of state legislative councils. Removal of chairman and deputy chairman of state legislative councils. Article 183, Clause C. Article 183, Clause C. So thereafter write down one note point, one universal application. If you don't have time in mains, I mean to say if you write mains, then you can write one point there. Note, to remove the presiding officer of any house, to remove the presiding officer of any house, the majority required is effective majority. To remove the presiding officer of any house, the majority required is effective majority. Right. How many majorities did we complete until now? 3. Simple, absolute, effective. Now comes the very important majority, that is special majority type 1. Huh? Do you want to go for break or shall I complete in 15 minutes? Quick. Okay, let me complete this, no? Majorities. I will leave, no problem. Break also I will give more time only. Right. Your patience. If you want until night 10 o'clock also I am available. Right. But I will make you write so many things which you will not find in textbooks. That much is for sure, guarantee. Right. Huh? Right. Let me be quick, my dear friends. Special majority. Okay. See, the special majority for the convenience of students. Normally in the constitution we do not classify it as 4 types. For convenience, for user friendly, we divide the special majority into 4 types. Special majority type 1, special majority type 2, type 3 and type 4. Special majority type 1, type 2, type 3 and type 4. Right. Wherever special majority comes, please understand, it is the majority not less than 2/3. Earlier I made you write majority not less than 50% of members present and voting. Here I will make you write special majority is the majority not less than 2/3 of members present and voting. What is the keyword here? 2/3 of members present and voting. That is your type 1. Special majority type 1 is the majority not less than 2/3 of members present and voting. This is your special majority type 1. Then what are the applications of special majority type 1? In your constitution, you have 2 applications of special majority type 1. How many? 2 applications. One is Article 249 is your first application. Second application is Article 312. Did you understand? What is Article 249? I made you write just before. Article 249. On the grounds of national interest, if Rajya Sabha passes a resolution by special majority type 1, then the parliament can make laws on the state subject. Article 249. Don't forget. What is Article 312? Creation of All India Service. To create a new All India Service, who should pass a resolution? The Rajya Sabha must pass a resolution to create a new All India Service. Then the parliament can create a new All India Service. Don't forget. So your special majority type 1 applications are only 2. 249, 250. 312. Don't forget. Now what is special majority type 2? See, special majority type 2 is same. Not less than 2/3 of members present and voting, plus that number should be more than absolute majority. Same. Not less than 2/3 of members present and voting, plus absolute majority. Plus absolute majority. I will explain how you need to write this. For example, friends, in the earlier case, suppose let us consider only 300 members came. Only 300 members came to Lok Sabha. Let us consider. Then when 300 members came to Lok Sabha, special majority type 1 is 2/3 into 300 plus 1. So special majority type 1 was 201. Is this number more than 272? No. It is less than 272. Are you getting? But in case of special majority type 2, the number which you get here, it must be more than 272. That is the reason I wrote plus absolute majority. For example, let us consider 450 MPs came to the Lok Sabha. 2/3 into 450. Then what is the number? 301. Is this number more than, greater than 272 or not? Why I am making you write 272? This number. See, in case of special majority type 2, special majority type 2 is the majority. Not less than 2/3 of members present and voting, and that number should be more than your absolute majority. Did you understand? Yes. Then what are the applications of special majority type 2? Very good. Removal of Supreme Court and High Court judges. Point number 1. Removal of UPSC chairman. Removal of CAG. Perfect. 2 examples you told. More. I need more.
Chief Election Commissioner.
Completed. You, Nikhil? Anyone? What are the applications of special majority type 2? 4. That is 4. Type 4. See, please. Bhavya, you are saying something? Please understand. There are 6 applications of special majority type 2. The first one is to amend the fundamental rights. To amend the fundamental rights, which majority is required? Special majority type 2. To amend fundamental rights. Second, to amend the DPSPs and fundamental duties. To amend fundamental rights, DPSPs and fundamental duties. To amend fundamental rights, DPSPs and fundamental duties. Third application, to approve national emergency. To approve national emergency, you must have told this. Everyone, okay, to approve national emergency. Next one, did you write? To approve national emergency, to amend fundamental rights, to amend DPSPs, to amend fundamental duties. Next application, to pass the constitutional amendment bills, to pass CABs, constitutional amendment bills, which do not affect federal provisions, which do not affect the federal provisions. To pass the constitutional amendment bills which do not affect the federal provisions. Next application, for removal of Supreme Court and High Court judges. removal of Supreme Court and High Court judges. Next, removal of CAG and Chief Election Commissioner. Removal of CAG and Chief Election Commissioner. To pass constitutional amendment bills which do not affect federal provisions. Huh?
Simple majority is rejected, sir.
To pass ordinary bills, money bills and financial bills, not constitutional amendment bills. Did you understand? Yes. Hello?
There is nothing to do with simple majority.
Yes. There, see, states need to ratify the constitutional amendment bills by simple majority. Okay? Yes. How many points did you write, please? 6. What was the last point? To remove or removal of CAG and Chief Election Commissioner. Thereafter, please write down. For creation or abolition of state legislative councils. For creation or abolition of state legislative councils. For creation or abolition of state legislative councils, comma, the state legislative assembly must pass a resolution. The state legislative assembly must pass a resolution. Must pass a resolution by special majority type 2. By special majority type 2. By special majority type 2. In brackets you write down Article 169. This is mentioned in which article? Article 169. Article 169. Did you write? Write down one note point thereafter. Note. The Parliament can create or abolish. The Parliament can create or abolish a state legislative council. The Parliament can create or abolish a state legislative council by simple majority. Did you understand? But for Parliament to create or abolish a state legislative council, initially the state legislative assembly must pass a resolution by special majority type 2, requesting the Parliament to either create a state legislative council or to abolish a state legislative council. When the state legislative assembly requests the Parliament can create or abolish a state legislative council by simple majority. Did you understand? What difference? Initially, state legislative assembly must pass a resolution. For example, see, Telangana is having state legislative council. Now, tomorrow, if CM decides that, or if MLAs decides that, no, we should not have state legislative council. Then what will the state legislative assembly of Telangana do? It must pass a resolution requesting the Parliament to abolish the state legislative council. And this resolution must be passed by which majority? Special majority type 2. When this resolution is passed by special majority type 2, then the Parliament can abolish the Telangana state legislative council by simple majority. Did you understand? Yes. Did everyone understood? Yes. Next, write down. Next about. Hello friends, please concentrate. Same, special majority type 3. What is special majority type 3? As it is, same. Rather than what we have to write is special majority, yes, ratification. Special majority type 2 plus ratification by half of the states. Plus ratification by half of the states by simple majority. Ratification by half of the states by simple majority. If you combine these two, it is special majority type 3. Did you understand?
Yes, sir.
If you combine special majority type 2, that is special majority type 3 is the majority not less than 2/3 of members present and voting, plus this number should be more than absolute majority, plus then after the special majority type 3 also requires the ratification by half of the states. And now do you know, my dear friends, why the ratification is required? Because it contains, or because it amends the federal provisions. By using this majority, we can amend the federal provisions. When federal provisions are affected, don't you think the state's approval is also needed? That is the reason ratification by half of the states. When I am writing here states, states means states only, not union territories. The union territories does not participate. The union territories does not participate in the constitutional amendment process. Don't forget. Approval of union territories of Delhi, Puducherry and Jammu and Kashmir state legislative assemblies is not required. Are you getting? Yes. Now what are the applications of special majority type 3? Special majority type 3 applications, anyone?
Election method of president.
Good, I got to you. To pass the constitutional amendment bills which affects the federal provisions is the first application. Write down one by one.
Sir, constitutional amendment states की affect చేస్తున్నా కూడా వాటి అవసరం లేదు సార్. అంటే like జమ్మూ కాశ్మీర్ ఢిల్లీ వీటికి affect చేస్తున్నా కూడా అవసరం లేదు.
Nothing will happen. If Parliament decides, and if these people pass, that to 14 states, if they pass out of 28, that will apply to all. Okay? Only half of the states is required. Out of 28, if 14 state legislatures approve these constitutional amendments by simple majority, then it will apply to all the states. Right? Please write down first application. To pass the constitutional amendment bills which affects the federal provisions. To pass the CABs which affects the federal provisions, point number 1. The second application is your Article 54. What is Article 54? Anyone? The second application is election of president. Very good. Very good. Election of president. Yes. Election of president. Article 54 is your second application. To make changes in Article 54, we need which majority? Special majority type 3. Next, Article 55. Third application is Article 55. Manner of election of president. Article 55. Manner of election of president. Manner of election of president. Next is Article 73. See, I am focusing only on articles. Subject matter you can find anywhere. But article, please write down Article 73. Extent of executive powers of the union. Extent of executive powers of the union. That is mentioned in Article 73. Article 73, extent of executive powers of the union. Next, write down extent of executive powers of the states. Extent of executive powers of the states. I will ask one question here, be ready. Extent of executive powers of the states, Article 162. Article 162. My dear friends, what do you mean by extent of executive powers of the union? Extent of executive powers of the states. What does this word means?
According to the article,
No?
definition of state, Article 12 లో ఉన్నదే దీని.
No. What does the term extent of executive powers of the union under Article 73 signify? You are close. There they can implement laws. Very good. Article 73 says extent of executive powers of the union. What does this mean? Wherever the parliament has the power to make laws, there the union government has the power to implement the laws. If parliament makes the laws, who should implement? The central government. The president of India being the executive head of the Indian state, he should implement the laws. Extent of executive powers of the union. Then what is Article 162? Extent of executive powers of the states. Wherever the states can make laws, there the state government or the governor should implement the laws. Did you understand? Article 162. Don't forget. Extent of executive powers of the union and extent of executive powers of the states. How many applications did you write? 5. Next, write down the next application. Article 124 to 147. Article 124 to 147. What am I talking about? Supreme Court. Very good. Judiciary at the union level. Article 124 to 147. Article 124 to 147. See, sometimes he might not give this Article 124 to 147. He will give like this, Chapter 4 of Part 5. See, what is Part 5? The Union. Do you know this Part 5 has 5 chapters? How many of you know Part 5 has 5 chapters? Okay, this Part 5 has 5 chapters, my dear friends. What is Chapter 1? What is Chapter 2? Chapter 1 talks about the Union Executive. Okay, Executive at the Union level. Executive at Union level. That is Union Executive, Chapter 1. And this one, Legislature at Union level. That is Union Legislature. What is Chapter 3? Anyone? Very good. Very good. Ordinance making power of President. Sometimes rather than giving this, he might give like this. Chapter 3 of Part 5 means ordinance making power of President. Okay. Then what is Chapter 4 of Part 5? I made you right now. Good. Chapter 4 of Part 5 means Supreme Court. The judiciary at the Union level, that is the Supreme Court. Then what is Chapter 5 of Part 6? Chapter 5 of Part 5, sorry, CAG. Please write down. Rather than giving other things, he might give like this, Chapter 4 of Part 5. It means you have to understand he is talking about Supreme Court. So if you want to make changes in Chapter 4 of Part 5, which majority is required? Special majority type 3, never forget. Right? Next one. Yes, last, only 5 minutes more. Next. Right. For us it is marathon, but see, everyone. Please write down next. Article 214. Next application, please. Article 214 to 237. Next application is Article 204 to 237. It talks about high courts. High courts. It talks about high courts. That is nothing but Chapter 5 of Part 6. High courts can also be written as Chapter 5 of Part 6. Chapter 5 of Part 6. Right? And thereafter, please write down one important article, Article 241. It talks about, anyone? Article 241 deals with what? Rakesh? Article 241? Manoj? High courts for union territories. High courts for union territories. And there you write down one note point. Delhi is the only union territory which has high court for itself. Delhi is the only union territory which has a high court for itself. Delhi is the only union territory which has a high court for itself. Next, 9th or 10th application? 10th? 9th, please write down Article 246 in 7th schedule. Article 246 in 7th schedule. Next application, Article 246 in 7th schedule. So you know very well, it deals with legislative powers, distribution of legislative powers between center and states. It talks about distribution of legislative powers between center and states. Next application, please. Yes, we came to end. Fourth schedule, next application. Fourth schedule Fourth schedule. Just write down fourth schedule. Next, Article 368 itself. If you want to make changes in the title of Article 368, if you want to make changes in the procedure of amendment under Article 368, special majority type 3 is required. Fourth schedule, Article 368. Next one, Article 279 capital A, GST Council. Article 279 capital A, GST Council. And the last and important application of special majority type 3, chapter 1 of part 11, that is, please write down, chapter 1 of part 11. What is chapter 1? Legislative relations. What is part 11? Center state. So, legislative relations between center and states. Chapter 1 of part 11 is nothing but legislative relations between center and states. Tomorrow, if you want to make changes in legislative relations between center and states, then special majority type 3 is required. Okay, this is all about special majority type 3. In special majority type 4, you have only one application, that is impeachment of President of India. But before that, you need to know what is special majority type 4. What is special majority type 4? There you write down, it is a majority not less than 50% of, it is the majority, sorry, 2/3 of, it is the majority not less than 2/3 of total membership of the house. Yes, majority not less than 2/3 of total membership of the house. It is the majority not less than 2/3 of total membership of the house, and that majority is 2/3 into 543. It will go to 362. 362. Okay, 2/3 into 3 plus 1, that is 362, and it is a fixed majority, my dear friends. In all these type of majorities, there are only two fixed majorities. One is absolute majority and second one is special majority type 4. These are the only two fixed majorities, and it has only one application, which requires the highest number of numbers, that is impeachment of the President of India. It has only one application, impeachment of President of India. Impeachment of President of India, Article 61, right? Article 61, and this is highest majority in the parliamentary business. Special majority type 4 is the highest majority in the parliamentary business. It is the highest majority in the parliamentary business. Now, how much time do you want to come after the break? Okay, yes. Okay, I will try to start after 2:15 or 2:20. Okay, then is it okay now? Yes. Have you learned something? Yes. Okay, friends, we will meet again after the lunch. Okay. You can go for break now. And return back.
మనం నైట్ 11-10 వరకు చేద్దాం, కానీ ఫాస్ట్ చేద్దాం సార్. మనం కవర్ చేయలేదు.
వాళ్ళకి అసలు ఏం తెలియదు.
ఎవరికి
కొత్తగా రాస్తారు
వాళ్ళు మ్యారథాన్ నెక్స్ట్ వీక్ రాస్తారు సార్ వాళ్ళు ఎగ్జామ్. యూఆర్ నాట్ రెడీ. మరి మ్యారథాన్ సార్ అవ్వదు సార్.
ఓకే ఐ విల్ ట్రై. కొంచెం అమ్మా వాట్స్ యువర్ నేమ్? That you ask. ఇవన్నీ వస్తారు అంటే ఇది కొంచెం ఎక్కువ
అందుకే ఫాస్ట్
స్కిప్ అయిపోతుంది.
రేపు తీసుకుంటారా?
ఏం కాదండి, ఐ విల్ బి హియర్ ఓన్లీ. ఐ యామ్ పార్ట్ ఆఫ్ ARK Reflections. Even afterwards also you can come. I will try to complete as much as possible. Otherwise you can once look their notes, each and everything you can take. Rakesh notes.
వెళ్తారా ముందుకి?
ఇక్కడే
ఇలాగే ఉంచుతాను, మీరు కంటిన్యూ అయిపోవాలి.
అంతే ఎమ్మటేస్తాం.
అదే
Neha, I can see you are tired today.
No, sir, it was cold.
Cold? Okay. No problem. Take rest, Amma. Bhavya, bye. రాకేష్, అవునమ్మా. ఆయన ఈశ్వరరావు గారు ఉన్నారా? ఓకే ఓకే. You understand? Right. Shall we start, friends, from where we have left? Okay. Now, after coming in the afternoon session, let me start with the concept known as preamble. Okay. And after preamble, I will try to cover as much as early as possible other chapters like federal system, fundamental rights. Okay. DPSP's fundamental duties. Right. Online students, am I audible? Visible? Online students, am I audible, visible? Yes. So, now, what is preamble of Indian Constitution? Preamble is an introduction or preface to the Constitution. It contains the summary or essence of the Constitution. Okay, and the concept of preamble we have borrowed from American Constitution, but the language of preamble we have borrowed from Australian Constitution. Now, what were the views of our Constitution makers on the preamble? Who called preamble as identity card of the Constitution? Huh? N.A. Palkiwala. Then what were the other experts, views of other experts on the preamble? One minute, friends. See, N.A. Palkiwala called preamble as identity card of the Constitution, and Durgadas Basu called preamble as it contains the philosophy or theme of the Constitution. And Durgadas Basu has also said that the preamble is the key to open, to read, to unravel the minds of Constitution makers. What is the first initial form of preamble? What was the initial form of preamble? Objectives resolution. Who moved the objectives resolution? Jawaharlal Nehru. On which date? Jawaharlal Nehru moved the historic objective resolution on which date? On 13th December 1946. And this objectives resolution was adopted by the Constituent Assembly on 22nd January 1947. So your preamble is a modified version of objectives resolution. Okay, and what does your preamble reveal to you? When you read the preamble, what do you come to know about the preamble? Okay. Yes, and see, when you read preamble, it reveals to you four things. The first one is the source of power of the Constitution. Who is the source of power of the Constitution? The people of India. The second thing which the preamble reveals to you is the nature of Indian state. What is the nature of Indian state? Sovereign, socialist, secular, democratic, and republic. Then the third thing which preamble reveals to you is the objectives of the Constitution. What are the objectives? Justice, liberty, equality, and fraternity are the objectives mentioned in the preamble of the Constitution. And the fourth thing which the preamble reveals to you is the date of commencement, the date of adoption of the Constitution. Okay, never forget, the preamble does not reveal you the date of implementation or commencement of the Constitution. Okay, what date is mentioned in your preamble? 26th November 1949, but you do not find the date of implementation, that is 26th January 1950. Okay, please. Then thereafter, what is the nature of Indian state as we have discussed? Sovereign, socialist, secular, democratic, and republic. Now please tell me, what do you mean by sovereign? What do you mean by sovereign? Okay, what do you mean by sovereign? I want one perfect definition of sovereign. No external influence. Good.
Externally independent.
You need to remember four keywords, my dear friends. 4 words. When you are internally supreme and externally independent. When you are internally supreme and externally independent, you are considered to be a sovereign. Okay? Never forget these 4 words. Internally supreme and externally independent. When you are able to take decisions on your own, you are not being influenced by others, then you are considered to be a sovereign person or a sovereign country. Was India a sovereign country right from beginning? Was India a sovereign country after India's independence? After India's independence?
Dominion and British until 50.
No. Please understand, from 1757 till 14th August 1947, what was the position of India? India was a British dependency. India was a British colony. From 1757 till 14th August 1947, India was a British colony. From 15th August 1947 till 25th Jan 1950, India was a dominion state of British. India was a dominion. Then what do you mean by a dominion country? Dominions are self-governing units which recognize the foreign head of the state as their head of the state. Are you getting? If any country recognizes the foreign head of the state as their head of the state, then those countries are known as the dominion countries. Now, here comes the question. Why did we not declare ourselves as sovereign at the time? Very good. We did not have a constitution at that time. What do you mean by a republic country? The head of the state should be elected. Your Article 52 says there shall be the President of India. Are you getting? When the constitution did not come into existence, who is the head of the Indian state at that time? It was not our Indian president. It was Lord Mountbatten. Are you getting? As the constitution of India did not come into force before 26 January 1950, our country continued to remain as a dominion country. We still recognized the British crown as the head of the Indian state. Then what happened on or from 26th January 1950 onwards? From 26th January 1950 or on 26th January, India declared itself as a sovereign, democratic and republican nation. India declared itself as a sovereign, democratic and republic. I am not using the two words socialist and secular. Why? In the original preamble of the Indian Constitution, we did not have those two words there. Okay? On 26 January 1950, India declared itself as sovereign, democratic and republican country and republican nation or republican state. Therefore, in 2021 UPSC paper, what was the status of India when the constitution came into force? Then he gave these three words. He also gave those five words. He gave mixture of words: sovereign, socialist, secular, democratic, republic. So the answer is sovereign, democratic and republican state. Are you understanding? Yes. Now, after this, please tell me one thing. Being a sovereign state, India can acquire other countries' territories or not? Did India acquire any other country's territory? Or did India cede a part of its territory to a foreign state? Yes. If yes, then please tell me examples. Give me examples of those territories that we have acquired from other countries.
Given territories to Bangladesh.
First, tell me examples of acquired territories. What we have acquired territories? Puducherry, Goa.
Hyderabad.
No, they were already existing in India. Dadra and Nagar Haveli, Daman and Diu, Goa, Puducherry, Karaikal, Yanam, Mahe. Are you getting? Dadra and Nagar Haveli, Daman and Diu, Goa, Puducherry, Karaikal, Yanam and Mahe. All these are examples of acquired territories. Never forget. These are examples of acquired territories. From whom did we acquire Dadra and Nagar Haveli? From Portuguese. From whom did we acquire the Daman and Diu, Goa? Again from Portuguese. From whom did we acquire Puducherry, Karaikal, Yanam, Mahe? From French. These are French establishments in India. Never forget. Then when I am telling you, why am I telling you about this? India being a sovereign state, it can acquire any other country's territory or cede a part of its territory to a foreign state. Examples of acquired territories are, I already told you. Okay, Dadra and Nagar Haveli, Daman and Diu, Puducherry, Yanam, Karaikal, Mahe. Right? Then out of this Puducherry, Karaikal, Yanam and Mahe, which units are located on the east coast? Mahe is located on the west coast. Never forget. Okay? Puducherry, Karaikal, Yanam. These three are located on the east coast and Mahe is located on the west coast. Then can you give me examples of ceded territories which we have given to other countries? Berubari Union, very good. We have given to East Pakistan. Good. More? Ceded territories which we have given our territories to a foreign state. One is Berubari Union. See, the second best example is your enclaves, exchange of enclaves. Recently, 100th Constitutional Amendment Act. And one more example is your Palk Strait. Yes, those islands are called Kachativo Islands. Kachativo Islands in Palk Strait, those islands we have given to Sri Lanka. These are some of the examples of ceded territories. Never forget. Okay? Yes. Then when did India become the member of Commonwealth? India became a member of Commonwealth nations in which country?
1934.
Commonwealth in 1949. And India became a member of United Nations organizations in which country? In which year? 1945. Don't forget. This is all about the sovereign nature of Indian state. So, having discussed about the sovereign nature, the next nature of Indian state is socialist. Okay? The second nature of Indian state is socialist. Now please tell me, is the word socialist mentioned in the original constitution? No. The word socialist was added to the preamble of the Indian constitution by 42nd Constitutional Amendment Act 1976. Don't forget. The word socialist was added to the preamble of Indian Constitution by 42nd Constitutional Amendment Act 1976. And what does the word socialism in your preamble indicate? What does the word socialist in the preamble reflect?
Economic and political.
Huh?
Economic and political.
You are saying economic and political justice? How economic and political justice is ensured? Prevention of concentration of wealth. Which article? Please, yes. What you have said, all of you, what you have said is right. Please understand. In case of preamble, the socialism which we refer is the democratic socialism. What is democratic socialism? Coexistence of both coexistence of both public and private players. Okay. In case of democratic socialism, we are based on mixed economy model. What is the mixed economy model? Coexistence of both public and private players. Now, what are public players? Give me some examples of public players. Yes, public sector units. One is, for example, if we have in case of airways, we have Air India on one hand. If we consider it to be a public sector, we also have private sectors like Indigo, Vistara, SpiceJet. Is there? Do you have choices or not? Either you can go with public or with private player. The second example is you have TGS RTC buses on one hand. You also have other private travels, Casinelli Travels, Orange Travels, Rapido, Uber. I mean to say, in India we have the democratic socialist model, which is based on mixed economy model. In Indian brand of socialism is democratic socialism. Okay, what do you mean by mixed economy model? Coexistence of both public and private players. Don't forget this. Then which articles of the Indian Constitution emphasizes on democratic socialism? What are the examples of, what are the articles which emphasizes on the democratic socialist model? Article 39 clause B and Article 39 clause C. What is 39 clause B? Prevention of concentration of 39 clause B is equitable distribution of material resources. And 39 clause C is prevention of concentration of wealth in few hands. Are you getting? See, on one hand we had the democratic socialist model, on the other hand we have the communist model or socialist, the Marxist socialism. What do you mean by Marxian socialism? Yes.
Extreme form of socialism.
Okay. Yes, please tell me, what do you mean by Marxian socialism?
Complete absence of private players.
Yes, they talk about abolition of private property. They talk about nationalization of all the means of production and distribution. Are you getting? But in case of democratic socialism, did we go for abolition of private property? No. Please understand that. And there are two articles which emphasizes on the democratic socialism: Article 39 Clause B and Article 39 Clause C. Right? Secular. Right. What do you mean by secular?
Keeping the religion out of the state.
Okay. No, that is Western concept of secularism. What you are saying?
Giving equal importance to every religion.
Okay.
And interfering in the religious
Did we contain the word secular right from beginning? The word secular was also not mentioned like socialism in the preamble of original constitution. The word secular was added to the constitution by 42nd Constitutional Amendment Act 1976. Now what does the word secular means? When a state does not officially declare, when a state does not uphold, when a state does not recognize any particular religion as official religion, it is known as a secular state. What are the conditions of a secular state? There are two conditions of a secular state. When a state promotes all the religions equally, then also it is considered to be a secular state. And if the state does not interfere in any religious affairs, even then it is a secular state. What is the example of first model of secularism? India and Nepal. India and Nepal. Then what is the example of that secular state which does not interfere in religious affairs? Western concept of secularism. There we have USA, France, Germany. Okay, then what do you mean by a non-secular state? What are examples of non-secular states?
They believe in Sharia.
Okay. Non-secular states are those states which declare any particular religion as official religion of a state. For example, you take Pakistan, Saudi Arabia, Iran, Iraq, and all the Gulf countries. They have declared Islam as their official religion. Are you getting? If you take Vatican City in Ireland, they have declared Christianity as their official religion. And if you take other countries like Bhutan, Myanmar, Sri Lanka, Cambodia, these countries have declared Buddhism as their official religion. So all these countries which I told you just now are examples of non-secular states. Did you understand? Non-secular states. And see, the secularism we can divide into two concepts. One is Western concept of secularism and second one is Indian concept of secularism. What do you mean by Western concept of secularism? Okay, you? No interference in religion. Okay. When the state and religion are completely separate, they are not dependent on each other, then that model of secularism is known as Western concept of secularism. Example, as I just before told you, American secularism, USA, Germany, France, all these countries are examples of Western concept of secularism. And regarding this Indian concept of secularism, when the state interferes in religious affairs, when the state promotes all the religions equally, then that model of secularism is known as the Indian concept of secularism or negative concept of secularism, positive concept of secularism. Did you understand? Never forget this. And is India the only example of positive concept of secularism? No. We also have Nepal, right? India believes in this principle of Sarva Dharma Sambhavana. What do you mean by Sarva Dharma Sambhavana? Coexistence of all the religions. Okay? Yes. Yes, 1 minute. Right. Is there any other thing that we need to discuss in secularism? Anything which you know?
State can interfere into religious matter only.
Yes, the state can interfere. It can introduce religious, social reforms in religion. Can you give me some examples of the state interfering in religion and introducing social reforms? Yes. Abolition of sati. Okay. Abolition of this triple talaq. Okay. All these are examples of what? State interfering in religious affairs and bringing social reforms. Okay. Right. We completed how many natures of Indian state? Sovereign, uniform civil code. Very good. Sovereign, socialist, secular. Now the fourth nature of Indian state is democratic. Please tell me, what do you mean by democracy? First tell me about democracy. What do you mean by democracy?
People's rule.
People's rule. Demos means people.
No, please tell me about democracy.
People's rule.
Okay. The word democracy is derived from the two Greek words, demos and kratos. Demos means people, kratos means rule. Therefore, democracy means what? People's rule. And there was former US president known as Abraham Lincoln. He defined democracy as a system of government of the people, by the people, and for the people. Okay? Is democracy the best form of government? Is democracy the best form of government?
No, sir.
Democracy is the least dangerous form of government.
No, sir. It's not the best.
It's not the best, but democracy is the least dangerous form of government. Why? If you don't like any government, you can change the government after every 5 years. While compared to dictatorship or any other authoritarian regimes, democracy is considered to be the best form of government. Rather than writing that, what we would be writing is democracy is least dangerous form of government. Is voting democracy? When you vote, do you consider it as a democracy or not? Voting is not democracy. Voting is just a tool to ensure that democratic process is going on. Are you getting? Yes. Then what do you mean by a true democracy? When can you call that a country is said to be a true democracy? Very good. Periodic elections is one of the criteria to call any country as a true democracy. More? In a true democracy, every individual's voice will be heard. In a true democracy, people will have the power to decide what to do, when to do, and how to do. The leader of that country will not decide what to do, when to do, how to do. Are you getting? In a true democracy, the people will have the power to decide what to do, when to do, and how to do. Right? Then how to strengthen democracy? What are the tools to strengthen democracy? How can a democracy be strengthened?
Unbiased journalism.
Unbiased media. Good.
Electoral reforms.
Electoral reforms. Very good. How can democracy be strengthened? See, its application I will make you write what are democratic and what are republican countries. I am asking you how to strengthen democracy. Please loudly. Accountability, very good. To strong tools of accountability. RTI, yes, he told me that only. Huh? Yes, please understand, there must be a rule of law in a country. First point is rule of law. Second is universal adult franchise. Anyone who has crossed 18 years of age should be eligible to vote. First one is rule of law. Second one is universal adult franchise. Electoral reforms. Electoral reforms. Timely conduct of elections. Next one is timely conduct of elections. Thereafter, unbiased and responsible media. There must be unbiased and responsible media. Are you writing? Unbiased and responsible media. Next one is there must be constructive opposition. Constructive opposition. Rather than just criticizing the government, the opposition should come up with solutions also. Then it is known as constructive opposition. And there must also be active civil society. Active civil society. The people should be aware of their rights. Active civil society. And there must be multi-party politics. If there are multiple political parties, the political parties will start questioning the government. If there are only two parties, then the level of questioning will be less. Are you getting? And better tools of accountability like RTI, e-governance, social audit, all these tools will strengthen what? Your democracy. Are you getting? I repeat for those who want to write, or for one last time. Rule of law. Second one is universal adult franchise. Electoral reforms. Periodic and timely conduct of elections, responsible and unbiased media, okay, and thereafter constructive opposition, active civil society, better tools of accountability like RTI, e-governance, social audit, and so on. So all these will strengthen your democracy. Okay, then what are the tools that weakens democracy? What will weaken your democracy? Corruption, very good. One party system, very good. Biased media, good. More. Voting on the basis of religion, race, caste. Yes, voting on the basis of popularity, good. More. Weak tools of accountability. All these will weaken your democracy. Never forget. One is biased media, criminalization of politics, corruption, voting on the basis of religion, race, caste, and weak tools of accountability. Yes, weak tools of accountability. If there is only one or two political party system,
Anti-defection.
okay, if there are defections, political defections, all these will weaken what? Your democracy. Don't forget. Right? Now, how can the democracy be classified? Direct democracy and indirect democracy. Now, what do you mean by direct democracy? In a direct democracy, the head of the government will be elected directly by the people. I repeat, the democracy can be of two types, the direct democracy and indirect democracy. In a direct democracy, the head of the government will be elected directly by the people. But in case of indirect democracy, the head of the government is not elected directly. Rather, the people's representatives are elected directly by the people. Then how the head of the government will be, is he an elected person or appointed person? Appointed. In case of India, if you take, your prime minister is an appointed person. Who appoints the prime minister of India? President. Which article says that the prime minister shall be appointed by the president of India? 75. Which clause? Clause 1. 75 clause 1 says the prime minister shall be appointed by the president of India. Never forget. Right? And tell something about direct democracy. Give me examples of direct democracy. See, in direct democracy, please. Switzerland, very good. What are the examples of direct democracy? Switzerland. Did India have direct democracy? Does India have any direct democracy? Local bodies, we have direct democracy. Did India had direct democracy in ancient Indian history time? During the times of ancient history, 16 Mahajanapadas. At that time also we had direct democracy. The ancient Greek city-states are also examples of direct democracy. Are you getting? Yes. Then what is an indirect democracy? In case of indirect democracy, the people's representatives are elected by the people. In case of direct democracy, the people themselves takes the important decisions, but through 4 devices. What are those 4 devices? Those 4 devices are referendum. Second one is initiative. Third one is recall, and fourth one is plebiscite. Are you getting? We need not discuss these 4 devices of direct democracy, not required for us. However, in case of indirect democracy, who takes important decisions? The people's representatives takes important decisions on behalf of people. Therefore, the indirect democracy is also known as representative democracy, and your representative democracy can be divided into 2 types. What are those? The representative democracy can be divided into 2 types. What are those? Parliamentary democracy and presidential system. The parliamentary system and presidential system. Never forget, from indirect democracy you can divide, the indirect democracy can be divided into 2 types. The indirect democracy is also called representative democracy, and it can be divided into 2 types. One is the parliamentary system and second one is the presidential system. Now, what is the basic difference between a parliamentary system and a presidential system? Yes, in case of presidential system, let me tell you about presidential system. The 3 organs of the government are separate from each other. But in case of parliamentary system, the executive is a part of legislature. The executive is derived from the legislature. Are you getting? The executive is a part of legislature, and as the executive is derived from the legislature, the executive is collectively responsible to the parliament in general and Lok Sabha in particular. So that is the reason I told you that according to Article 75 Clause 3, the principle of collective responsibility is the bedrock principle of the parliamentary form of government. Did you understand? Yes. Then what are the features of parliamentary form of government? What are the features of parliamentary form of government? Here, though we are discussing preamble, I want to bring some of the aspects of parliamentary form of government here itself. Huh? What are the features of parliamentary form of government? The presence of dual executive. Are you getting? In a parliamentary form of government, there will be dual executive. One is the real executive and second is the nominal executive. Who is the nominal executive here? The president. The nominal executive can also be called as de jure executive or titular executive. The real executive can also be called as de facto executive. This is one of the important feature of parliamentary form of government. Then what is the second important feature? Majority party rule. The party which secures more number of seats in Lok Sabha will form the government. Majority party rule is one more second important feature of parliamentary form of government. Then what are the other features of parliamentary form of government? Leadership of the Prime Minister. Are you getting? The leader of the majority party is appointed as the Prime Minister, and he is the leader of the House. He is the leader of the party in power. He is the leader of the Council of Ministers. He is the head of the government. That is the reason we call, in case of parliamentary system, leadership of the Prime Minister. Is there any other things? Fourth one is collective responsibility. Your Article 75 Clause 3 says the executive means here Council of Ministers headed by Chief Minister, headed by Prime Minister. The Council of Ministers headed by Prime Minister is collectively responsible to the Parliament in general and Lok Sabha in particular. 75 Clause 3. Then, other than this, in a parliamentary system, can only the MPs become the ministers? Yes. Any MP? Anyone? Yes. According to which article any person can become a minister? According to which article? According to Article 75 Clause 6. Any person who is not a MP, member of parliament, he can also become a minister for a maximum period of 6 months. However, if he wants to continue as a minister beyond 6 months, he has to become a member of parliament. And he can become a member of parliament in how many ways? There are two ways of becoming a member of parliament. One is either getting elected to any house of the parliament or getting nominated to Rajya Sabha. Did you understand? Then what are the other features of parliamentary form of government? The parliamentary form of governments are usually unstable governments. Why they are unstable governments? Due to political defections, due to passage of the no confidence motion, due to any other reasons? Due to coalition governments. At any time, if the Prime Minister wants, he can advise the President of India to dissolve the government, to dissolve the legislature and go for fresh elections. Atal Bihari Vajpayee did this in 2003 at the end of 2003. In the similar manner, our KCR did this in 2018. Are you understanding? And he went for fresh elections even 6 months before only. Are you getting? Yes. Other than this, please tell me, what do you know about the democracy? Yes, this is all about the democracy. Now, what is the fifth nature of Indian state? Republic. Please tell me, what do you mean by republic? When the head of the state is elected, then that country is known to be a republic country. Any democracy can be divided into two types. Any democratic country can be divided into two types. One is it might be a monarchy or it might be a republic country. Can you give me examples of monarchies? Countries which are monarchies? Britain? One good example, please. Japan. We have the Emperor of Japan. We have the British monarch. Are you getting? In these countries, for example, in Britain, the head of the state is not elected by the people. He assumes that office by succession. He enjoys the hereditary position. Are you getting? There are no elections held to the head of the state in Britain. So British is an example of monarchy. You take India, for example, let us take other countries like India and America. In case of these countries, America, India, these countries are said to be republic countries because the head of the state is elected. If the head of the state is elected directly by the people, America is an example of the head of the state being elected directly by the people. And in case of India, the Indian president is elected indirectly. Are you getting? Yes. And what do you mean by republic? When you say that the head of the state is republic, it is only one way of defining the republic. Republic also means vesting of political sovereignty in the people of India. What does this mean? Vesting of political sovereignty in the people of India? The ultimate political power lies with the people of India. You can become the president of India. He can become the president of India. Why? You are citizens of India. Any person in this country can become the president of India. Why? We are a republic country and any citizen of India can become the president of India. Republic also means throwing away all the public offices to all categories of people, all the citizens of country. Okay, that is absence of special privileges to any class of people. Are you getting? Yes. Now, after this, we need to discuss examples of some republic countries which are both republic and democratic. Please tell me some of the examples of countries which are both democratic and republic. India, good. First tell me those countries which are both democratic and republic. The first one is, see, India is a democratic country and USA is also a democratic country and both these are republics also. India, America. Other than these, Ireland. Okay. For example, India, USA, Ireland. Democratic republic. So India is a democratic and republican country. USA is a both democratic and republic, and Ireland is also both democratic and republic. Now tell me that country which is democratic but not republic. Tell me about those countries which are democratic but not republic. Britain and Japan. Good. Can you also say Commonwealth countries? What do you mean by Commonwealth countries? Those countries that were ruled by the British are known as Commonwealth countries. Okay? Yes. Japan and Commonwealth countries. Most of the Commonwealth countries. Now please tell me that country which is not democratic but a republican country. Which is not democratic but it is a republic country. Republic because the members of that political party will elect the head of the state. That is the reason I am saying republic. China, very good. China is not a democratic country but it is a republic country. China is not a democratic country but a republic country. Thereafter, see, now can you give me examples of those countries which are not democratic and which are not republic also? Yes, North Korea. Arab states, very good. Good. Yes, please write down there if you want, if you are writing, just only for this. Write down Saudi Arabia. See, Saudi Arabia, Brunei, Oman, Vatican City, Qatar, all these countries which I told you, Saudi, Brunei, Oman, Vatican City, and these are not democratic and these are not republics also. Okay, yes, there we have kingdom. That is the reason the name of that country Saudi is KSA. What do you mean by KSA? Kingdom of Saudi Arabia. Never forget, Kingdom of Saudi Arabia, right? Yes. Australia is an example of democratic but not republic. Australia still recognizes the British crown as the head of the state. Australia is a dominion state, right? By the way, I forgot to ask you, out of this word state, nation, nation state, and a country, in the constitution and laws of parliament, which word do you find the most? State. Why do you find the word state the most? Why not any nation, nation state, or a country? Huh? Why not nation? Yes.
Population, defined territory, rule,
What are the four components of a state?
sovereign,
Sovereign. First tell me, what are the four components of a state? General definition of state.
government and sovereign.
A state is a legal entity. A state is a legal entity which consists of four basic components. The first one is there must be a defined territory. Point number one. And in that defined territory, there must be population. A defined territory is the first component. Population is the second component. The third component is there must be a government. And the fourth component is that particular state must be a sovereign state. The government of that state must be in a position to take decisions on its own. Therefore, the four basic components to call any entity as a state is there must be a defined territory, point number one. Second is there must be population residing in that territory. The third one is there must be a government and that government must be a sovereign. Are you getting? Yes. Which articles of the Indian Constitution defines the state?
12.
Article 12 and Article 36. 12 defines the state for the purpose of? Okay. 36 defines the state? DPSP. Then what is the definition of the state according to you? What is the definition of the state? The state includes what according to you? What you told is right. Article 12 defines the state for the purpose of Part 3. Article 36 defines the state for the purpose of Part 4. Then what is the definition of the state?
Which consists of every organ.
State. See, just before what we have discussed is general definition of a state. Now I am asking you from constitutional perspective, what is the definition of the state in Article 12 and Article 36? A state, please, please.
Anything in which state has
government.
Huh?
state has
Okay, please listen to me carefully. A state includes the legislative organ at the union and the executive organ at the union. Point number one. Listen to me. The state also includes the legislative organs at the state level and the executive organ at the state level. The state also includes within its ambit the local authorities, which include all the local governments. The state also includes other authorities which are of statutory and non-statutory nature. The state also includes the private agencies working as an instrument of the state. So from this what you can learn? The state includes the parliament, the union government, central government. The state includes the state legislature or state legislative assembly and the state government. The state includes all the local governments. The state includes other authorities like LIC, GAIL, SAIL, BHEL. Are you getting? The state also includes the private agencies or private institutions working as an instrument of the state, working for the state. So all these things are included in the definition of the state. And out of these many things which I discussed with you, if anything violates your fundamental rights, immediately you can approach the Supreme Court of India. Are you understanding? This is the constitutional definition of a state. Earlier what we have discussed, the state includes four basic components: a defined territory, population, government, and sovereign. That is general definition of a state. State is a legal entity. That is the reason we find the word state in the constitution as well as various laws of parliament and state legislatures. A nation is a psychological concept. It is a feeling of belonging to one common identity. That one common identity might be land, language, culture, custom, and so on. A nation is not a legal concept. Are you getting? In the similar manner, country is also not a legal concept. It is just a geographical term. That is the reason in your constitution as well as laws of parliament, you come across this word, the states. Did you understand? Yes. By the way, you got it? Which countries are both democratic and republic? Which countries are democratic but not republic? Which countries are republic but not democratic? And which countries are not democratic and not republic also? Right? Now come to objectives of Indian constitution. Now I expect some answers from you. Be ready. I will ask few questions. Yes. So the first objective of the Indian constitution is justice. What do you mean by justice? What do you mean by justice? What do you mean by justice? Anyone from this side? Okay. See, please understand, justice means fair treatment of people. Fair treatment of people. Justice means what? Fair treatment of people. Now, the justice mentioned in your preamble embraces three different forms of justice. One is social justice, economic justice, and political justice. And this justice we have borrowed from which constitution? From USSR or Russian Revolution or Russia. Okay. And I told you the preamble in the Indian constitution talks about the three forms of justice. One is social justice, economic justice, and political justice. Please tell me, what do you mean by social justice? So, correct words are needed. Huh? No discrimination, absence of privileges. Okay, good. One more. Okay. Please understand, whenever someone asks you social justice, try to tell in this manner. Social justice means non-discrimination on the basis of social factors. Please try to include social factors there. Now, what are the social factors? Race, religion, caste, color, sex, place of birth. All these are social factors. So, social justice means non-discrimination on the basis of social factors like race, religion, caste, sex, place of birth are known as social factors. And if someone is discriminating you on the basis of race, religion, caste, sex, and place of birth, he is practicing their social justice, untouchability. Are you getting? Your social justice also means absence of privileges to any particular section of society. I am telling you different definitions of social justice. Social justice means non-discrimination on the basis of social factors. I told you what are those social factors: race, religion, caste, sex, and place of birth. Social justice also means absence of privileges to any particular section of society. Your social justice also means improvement in the conditions of SCs, STs, OBCs. Yes, underprivileged classes. SCs, STs, and OBCs. Now, please tell me, what are the articles in the Indian Constitution which ensures social justice? Which articles of the Indian Constitution ensures social justice? Who is saying 15? Good. Yes. 17 also. Very good. Yes. More? Huh? No, not abolition of titles. It is related to equality. It is related more to. Article 16 is economic equality, economic justice. Right. Please understand, the social justice can be ensured by Article 14, Article 15, Article 17, Article 38, Clause 1, and Article 46. I was seeing whether someone will say Article 46. Okay, I repeat, social justice is ensured by 14, 15, 17, 14, 15, 17, Article 38, Clause 1, and Article 46. Are you understanding? Now, what is Article 14? See, social justice is ensured by these articles. Now, what is Article 14? The state shall not deny equality before law and equal protection of laws. Are you getting? That is Article 14. What is Article 15? Prohibition of discrimination on the grounds of race, religion, caste, sex, and place of birth. That is why Article 15. Then what is Article 17? Abolition of untouchability. Please understand, your Article 17 abolishes untouchability directly. There is one more article which is abolishing untouchability indirectly. Which is that article? Rakesh, you know that? No?
19(1).
Which, see, while Article 17 is directly prohibiting untouchability, there is one more article which is indirectly prohibiting untouchability. Please tell me which article indirectly prohibits untouchability. Which article indirectly prohibits untouchability? Anyone? You, ma? 15 class 2. Never forget. Article 17 directly prohibits untouchability, but Article 15 clause 2 indirectly prohibits untouchability. Don't forget. Okay? Yes. Then for 14, 15, 17, then what is Article 38 clause 1? What is 38 clause 1? First tell me what is Article 38. You leave about clause 1. Article 38, it deals with what? To promote people's welfare. To promote welfare of people. And in Article 38, we have 38 clause 1. To promote welfare of people by securing a social order. How will you secure a social order? By promoting social economic justice. So 38 clause 1 is to promote the welfare of people by securing a social order. Had it been 38 clause 2, you should have told to promote welfare of people by minimizing inequalities in income, status, and opportunities. So 38 clause 1 talks about to promote the welfare of people by securing a social order. Are you getting? Now, what is Article 46? Is it reservations directly, or it is because of this the government of India has promoted reservations? What is Article 46? Very good. Article 46 talks about the promotion of educational and economic interest of SCs, STs, and other weaker sections. Are you getting? In Article 46, you contain the words other weaker sections. Other weaker sections. Article 46 deals with what? Promotion of educational and economic interest of SCs, STs, and other weaker sections. Don't forget. Right? All these articles will ensure what? Your social justice. Don't forget. And if you want, you can write reservations also. Reservations for SCs and STs. Right. This is all about one form of justice known as social justice. Then what is economic justice? Same. When social justice is non-discrimination on the basis of social factors like race, religion, caste, sex, and place of birth. Economic justice is non-discrimination on the basis of economic factors. Now, what are economic factors? Income, wealth, opportunities, status. These four, yes, property. All these are economic factors. Non-discrimination on the basis of economic factors like income, wealth, status, property, and so on is known as economic equality. Now please tell me, how will economic equality be ensured? Economic equality also means the removal of economic inequalities. Like social inequality means, social justice means removal of social inequalities. Your economic justice means removal of economic inequalities. Now tell me, which articles of the Indian Constitution promote economic justice? Wait, one by one. Okay, economic justice. Good. You? 39 clause D. Perfect. Okay. No problem. Right. More articles, please. 16 clause 4. Reservations. Okay. How economic equality can be ensured? Yes, they told already. Article 39 clause D. Please understand. Article 14. Article 14 promotes all justice in all forms. Never forget. Article 14. Second one is Article 16. Equality of opportunity in matters of public employment. What is Article 16? Equality of opportunity in matters of public employment. Next is Article 19 clause 1 subclause G. What is Article 19 clause 1 subclause G? Right to practice any profession or to carry on any occupation, trade, or business. Are you getting? Article 14, Article 16, Article 19, Clause 1, Subclause G. Right to practice any profession or to carry on any occupation, trade or business. 19 Clause 1, Subclause G. The next article is Article 39 Clause B. What is Article 39 Clause B? Equitable distribution of material resources. Then what is Article 39 Clause C? Prevention of concentration of wealth in few hands. What is Article 39 Clause D? Equal pay for equal work for men and women. Then what is 39 capital A? Last constitutional provision to ensure economic justice. Free legal aid to the poor. Never forget. These many articles of the Constitution ensure economic justice. Article 14, Article 16, 19 Clause 1, Subclause G, 39 Clause B, 39 Clause C, 39 Clause D, and 39 capital A. If you want, you can write more. If you know, you can write more. However, these articles of the Indian Constitution ensure economic justice. Right? And a combination of social justice and economic justice is known as distributive justice. What do you mean by distributive justice? A combination of social justice and economic justice is known as distributive justice. Never forget. Right? Then how to ensure economic justice in real life? How did the government? Please give me some examples of economic justice. Okay, MG Narega. Land reforms, progressive taxation, the one who earns more, he should pay more. All these are examples of what? Abolition of monopoly. All these are examples of what? Economic justice, right? Now tell me how to ensure political justice. What do you mean by political justice? When all the citizens have equal access to political offices, when all the citizens are eligible to vote, when all the citizens have the rights to contest elections, if we have that freedom, then it is known as political justice. How to ensure political justice? Which articles of the Indian Constitution ensures political justice? Anyone? 14 is for all, good. 325, 326, Representation of Peoples Act 1951, Article 58, Article 58, Article 84, Article 19, Clause 1, Subclause A. What is Article 325? 325 talks about no person can be excluded from the electoral list. Are you getting? And your Article 326 talks about the right to vote. Your Representation of Peoples Act 1951 also talks about the right to vote. Then, what is Article 58? Qualifications to become the President of India. Yes, even by naturalization, if you are a citizen, you can become the President of India. Then what is Article 19, Clause 1, Subclause A? Right to freedom of speech and expression. And using this right, you can even criticize the government. Never forget, right? Article 325. Yes, 106. Yes, that also you can write. 326, Representation of Peoples Act 1951. Thereafter, Article 58, Article 84. These are examples of what? Ensuring economic justice. Article 19, Clause 1, Subclause A. See, your justice, though it is written, these many articles you need to remember and you need to write. At least you need to remember. If you see your Lakshmikant, it is simply written social justice, economic justice, political justice. You will not find even a single article there. One definition you will find there. Are you getting? Right. Then, can you give me real life examples of how this political justice was ensured? Okay. Yes. 106th Constitutional Amendment Act 2023 you can say. And another example is universal adult franchise. What do you mean by universal adult franchise? Okay, right. Any person who have crossed 18 years of age is eligible to vote. Thereafter, your voting age was reduced from 21 years to 18 years. By which Constitutional Amendment Act? 61st Constitutional Amendment Act, 1988. So you can write these as examples, right? Then this is all about justice. Then what do you mean by liberty? What is liberty? Yes, liberty, please. Absence of restrictions. Arbitrary restrictions is known as liberty. Then liberty also means what? Did the preamble of Indian Constitution ensure absolute liberty, absolute freedom? No. Our Constitution as well as preamble has ensured freedom with reasonable restrictions. Freedom with reasonable restrictions. Yes. What do you mean by reasonable restrictions here? What are the reasonable restrictions that can be imposed on liberty? Public order, morality, health, and national interest. Okay, public order, morality, health, and national interest. On these 4 grounds, your liberty can be curtailed. Never forget, right? And in the preamble, liberty of what is ensured? Yes, liberty of thought, expression, belief, faith, and worship. Your preamble talks about the liberty of thought, expression, belief, faith, and worship. In this, liberty of thought and expression is ensured by which article? Article 19, clause 1. Article 19, clause 1. Liberty of thought and expression, 19, clause 1, subclause A. Then liberty of belief, faith, and worship is ensured by Article 25 to 28. Liberty of belief, faith, and worship. Right. Now, in objectives of Indian Constitution, we completed liberty, justice, and liberty. Then what is the third objective of Indian Constitution? Equality. Now, please tell me, what does the preamble of Indian Constitution? In the preamble of Indian Constitution, equality of what is mentioned? Equality of status and equality of opportunity is mentioned there. Then equality can be of how many types? Equality can be of how many types? 3 or 4?
4 types.
4 types. What are those? Equality can be of 4 types. What are those? Political equality, socio-economic equality, civic equality, and gender equality. You should never forget nowadays gender equality. Then what do you mean by civic equality? How to ensure this civic equality? Equality is of 4 types: civic equality, political equality, socio-economic equality, yes, socio-economic equality, and gender equality. How to ensure civic equality? See, it can be ensured by the basic fundamental rights: 14, 15, 16, 17, and 18. You know what is 14? The state shall not deny equality before law and equal protection of laws. What is Article 15? Prohibition of discrimination on the grounds of race, religion, caste, sex, and place of birth. Then what is 16? Equality of opportunity in matters of public employment. 17, abolition of untouchability. Then what is 18? Abolition of titles. Our Indian Constitution abolishes which titles? Titles of hereditary. Okay. Huh? Yes. Indian Constitution abolishes the titles of heredity like Maharaja, Raja di Raja. These type of titles are prohibited. However, Article 18 or Indian Constitution does not prohibit academic or military distinctions. What do you mean by academic distinctions? Academic distinctions, please. Your BA, BTech, MA, MTech, doctor, engineer, all these professions which you can write are examples of academic distinctions. Then what are examples of military distinctions? Mahavir Chakra, Paramvir Chakra, Veer Chakra, and all those which we find in case of military ranks. They are not titles, they are awards. Okay, and awards are not titles. And these awards are given by the state, recognizing your special talent in various fields. Okay. No, anything other than that? Right. See, they are awards and they are not titles. Okay. Yes. Next one. Civic equality, I already told you. Article 14, 15, 16, 17, and 18. Then what do you mean by political equality? Again, the articles which you have wrote just before, 325, 326, Representation of People's Act 1951, 19 clause 1 subclause A, Article 58, Article 84. Huh? Anyone can become a member of parliament. Right. Then what do you mean by socio-economic equality? How to ensure socio-economic equality? Socio-economic equality. Again, you need to remember Article 46 here. Okay. Again, you need to remember Article 330 and 332, which deals with the reservation of seats. 330, 332, Article 46. They deal with the political equality. Then, how can the gender equality be ensured? Huh? Yes, 39D is there. There are many articles related to gender equality. How to ensure gender equality? See, in case of economic equality, if you want, you can add one more article. Article 38 clause 2, economic equality. To minimize inequalities in income, status, wealth and opportunities. It is economic inequality. Economic, you are saying something? Maternity, very good. Please tell me which article is related to maternity? 42, yes. See, now, after discussing about different types of equalities, civic, political and economic, now it is time for us to discuss provisions which ensure gender equality. Here, please try to remember Article 38 clause, Article 15 clause 1, 15 clause 3. What is Article 15 clause 1? What is Article 15 clause 1? Prohibition of discrimination on the basis of caste, sex, place of birth, religion. So as here there is no gender discrimination, 15 clause 1 is ensuring what? Your gender equality. 15 clause 1. The second article is 15 clause 3. What is 15 clause 3? No. What is Article 15 clause 3?
Women and children.
Very good. Women and children. Special provisions for women and children. Which article is included? Article 15 clause 3. 15 clause 3 talks about the state enabling special provisions for women and children. One is 15 clause 1. Second is Article 15 clause 3. The third one is Article 16. What is Article 16? Equality of opportunities in matters of public employment. Please remember, these are articles which ensure gender equality. 15 clause 1, 15 clause 3, Article 16, Article 39 clause D. What is Article 39 clause D? Equal pay for equal work for men and women. Equal pay for equal work for men and women. Next one is Article 42. Provisions of just and humane conditions at workplace and maternity relief. Please write down Article 42. Provisions of or provisions for just and humane conditions. Provisions for just and humane conditions of work and maternity relief. Provisions for just and humane conditions of work and maternity relief. The last one is the recent Constitutional Amendment Act, 106th Constitutional Amendment Act 2023, which provides for, okay, you can write free buses, okay. 106th Constitutional Amendment Act 2023 also provides for reservation of 1/3 seats for women in Lok Sabha and state legislative assemblies. And the last objective, you know very well, fraternity. What do you mean by fraternity? Promoting the sense of brotherhood is known as, yes, bhaichara is known as fraternity. Now, how will you ensure fraternity? Fraternity, is it only fundamental duty? Article? Then more, I need more articles. Single citizenship, how the sense of brotherhood can be promoted? Single citizenship, that is Article 9. Next, please, if you are writing, please write down fundamental duty, Article 51 capital A clause E. 51 capital A clause E. It talks about promoting the sense of brotherhood. Article 51 capital A clause E. And which articles of the fundamental rights ensures fraternity? Article 19 clause 1 subclause D. Article 19 clause 1 subclause D. Right to move freely throughout the territory of India. Okay? When you move freely throughout the territory of India, you will come to know your fellow citizens. Right? Next is Article 19 Clause 1 Subclause E.
Reside.
Right to reside in any part of India. 19 Clause 1 Subclause E. Next, write down directive principles of state policy which promotes fraternity is 38 Clause 2. 38 Clause 2. Now what is 38 Clause 2? To promote welfare of people. To promote welfare of people by minimizing inequalities in income, status, opportunities, wealth and opportunities. 38 Clause 2. Okay? Yes. Now please tell me how fraternity can be ensured. Anyone? How fraternity can be ensured? Without looking into your notes, which articles ensures fraternity? Article 9.
38 clause 2.
38 Clause 2. 19 Clause 1 Subclause D. 19 Clause 1 Subclause E. Never forget. 51 capital A Clause E. Fundamental duty. I made you write 5 articles how to ensure fraternity. Huh? Okay. Obviously that is there. Did you understand? Yes. And the last thing which we need to discuss from preamble is preamble a part of Indian Constitution or not? Yes. So this was discussed in 3 cases. The first case is Re Berubari versus Union of India case 1960. Re Berubari versus Union of India case 1960. I told you already, whenever in front of case Re, the word Re comes. Re Berubari versus Union of India case 1960. And as I told you, whenever you come across this word Re in front of a case, then you have to understand that this case was referred by the President to the Supreme Court under Article 143 of the Constitution. Never forget Re. Right, Re Berubari versus Union of India case 1960. Then what happened in this case? Why did the Supreme Court say that preamble is not a part of Constitution in this case? The Supreme Court has taken the traditional view that even if this preamble is taken off from the Constitution, even then the Constitution would continue to exist and nothing will happen to the Constitution. This is like if you are having Lakshmikant with you, if I tear starting pages of index page, if I tear that page, will anything happen to your textbook? It will still remain as it is. In the similar manner, the Supreme Court has said, even in the Constitution, if I remove the preamble which is mentioned in second page of the Constitution, even then nothing or no changes will happen to the Constitution. Therefore, the Supreme Court said preamble is not a part of Constitution in this case, in Re Berubari versus Union of India case. Then the second case which we must know is the Keshavananda Bharati versus the state of Kerala case. Keshavananda Bharati versus the state of Kerala case 1973. In this case, the Supreme Court reversed its earlier decision and said that the preamble is a part of Indian Constitution. The preamble is a part of Indian Constitution. And again, the same thing the Supreme Court reiterated in LIC of India versus Consumer Education and Research Center case 1995. LIC of India versus Consumer Education and Research Center case. And in this case, the Supreme Court said the preamble is an integral part of the Constitution. I repeat, in Re Berubari versus Union of India case, the Supreme Court said preamble is not a part of Constitution. In Keshavananda Bharati case 1973, the Supreme Court said preamble is a part of Constitution. And in LIC of India versus Consumer Education and Research Center case 1995, the Supreme Court said preamble is an integral part of the Constitution. Did you understand? This is all about preamble. Okay? Yes. 1 minute, friends. Golaknath?
Golaknath case is also related to preamble.
There are so many cases. I made you write the crux of what Supreme Court has said. See, from the morning we completed initially what is polity, what is constitution. Then I made you write schedules. After schedules we completed majorities, sources of Indian constitution, and thereafter we completed preamble. Since morning we completed 6 different concepts, though you might call it or not, I don't know. But next is the DPSPs. Okay, no, I did not discuss with you just one source or 2 sources. I made you write so many extra points. Please understand that, right? Thereafter, the directive principles of state policy. Please tell me, what do you mean by a directive principle of state policy?
Instructions to the state.
Instructions to the state. Very good. Yes, good, very good. So the directive principles of state policy are the constitutional recommendations, the constitutional instructions, the guidelines given by the constitution to the states. Are you understanding? Yes. So what are DPSPs? Constitutional recommendations or instructions. Given to whom? To the state. Right. What are the constitutional provisions related to directive principles of state policy? Article 36 to 51. Article 36 to 51 in part 4 deals with directive principles of state policy. And from where have we borrowed this concept of directive principles? Irish Constitution. From where did Ireland borrow this concept of directive principles? From Spain. Very good. We have borrowed the concept of directive principles from Ireland. And Ireland borrowed it from Spain. Yes. Then our Dr. B.R. Ambedkar has said few things about the directive principles of state policy. See, he said the DPSPs are like the novel features of the Indian Constitution. What do you mean by novel feature? Novel means unique features of Indian Constitution. He also said the directive principles of state policy are nothing but the instrument of instructions. Now, what are these instrument of instructions? The instrument of instructions were mentioned in the Government of India Act 1935. And these instrument of instructions were meant for whom? Given by whom? And they were given to whom? The instrument of instructions were given by the British government. And they were given to whom? Given to the Governor General of India and the British governors. So he said, our DPSPs which you are seeing today, their earlier form was Instrument of Instructions, IOIs. He said few things about pure DPSPs and fundamental rights and DPSPs. About directive principles of state policy, he said DPSPs are novel features of Indian Constitution. He also said DPSPs are like instrument of instructions, IOIs. And these IOIs, instrument of instructions, are mentioned in the Government of India Act. Mentioned in where? Government of India Act 1935. They were given by the British government, and given to whom? Given by the British government to the Governor General of India and the British governors. And regarding this, he also said, Dr. B.R. Ambedkar also said, fundamental rights combined with directive principles of state policy. According to Dr. B.R. Ambedkar, according to B.R. Ambedkar, they are philosophy and soul of Indian Constitution. Philosophy and soul of Indian Constitution. According to whom? According to Ambedkar. And according to Granville-Austin, conscience of the Constitution. According to Granville-Austin, the fundamental rights combined with DPSPs are known as conscience of the Constitution. Conscience of the Constitution. Okay? Yes. Now, though Article 36 to Article 51 deals with the directive principles of state policy, The real content of directive principles of state policy starts from Article 38 and ends with Article 51. Then what are these Article 36 and 37 here? 36 deals with the definition of the state for the purpose of Part 4. Then what is Article 37? Yes, Article 37 deals with the nature and significance of directive principles of state policy. I repeat. See, actually Article 36 to 51 in Part 4 deals with the directive principles. But this real content 37, 36 and 37. This is not the real content of DPSPs. The real content of DPSP starts from 38. Then what is Article 36? Article 36 deals with the definition of the state. Article 36 deals with the definition of state. And your 37 deals with the nature and significance of DPSPs. Now, what is the nature and significance of DPSPs? Though the DPSPs are non-justiciable in nature, it shall be the duty of the state. It is the responsibility of the state to keep in mind these directive principles while making laws and formulating policies. This is mentioned in Article 37. 36 deals with the definition of the state, and I already told you what is the definition of the state. I am just writing here. Parliament, union government, state legislature, state government, local authorities, other authorities, and private agencies working for the state. Good. Huh? Any private agencies working for the state. If they perform governmental functions, they will fall within the definition of the state. Who is funding them? That is also important, no? Right. Did you understand this? Try to remember until here. Other authorities, because this in your constitution it is mentioned only up to here. Right. Yes. Where were we? Yes. Definition of the state. Nature and significance of DPSPs. Please listen to me carefully. Though, according to Article 37, the DPSPs are non-justiciable in nature, though they cannot be enforced by the courts to implement the DPSPs. Article 37 says the DPSPs are fundamental in the governance of country. The DPSPs are fundamental in the governance of country, and it shall be the duty of the state. It is the duty of the state to apply these principles while making laws and formulating policies. This is pure Article 37. What I told you, discussed with you is Article 37. Then your real content of DPSP starts from 38 to 51. Do you think that the Constitution has classified the DPSPs into 3 categories? Then who classified the DPSPs into 3 categories? Obviously, very good. Who classified the DPSPs into 3 categories? On the basis of their content. On the basis of their content, the political thinkers have classified the DPSPs into 3 categories. What are the first category of directive principles? The socialist principles. Second is the Gandhian principles. And third one is the liberal intellectual principles. Then how many socialist principles are there, and they reflect what? The socialist principles reflect the ideology of socialism. And how many socialist principles are there? Who is saying 8? Good. We have 8 socialist principles. Then, what are those 8 socialist principles, ma'am? Please tell me. 38, 39, 41, 42, 43, 43A. Perfect. Very good. She told all the 8 socialist principles. First one is 38. Second, 38, 39. 39 capital A, 41, 42, 43, 43 capital A, and 47. How many? 8. Please understand. No, compulsory, no. Huh? Write for 2 times, you will remember. That's all. Right. As I told you, there are 8 socialist principles. 8 socialist principles. Please, if someone is writing, please write down only 8 socialist principles. 8 socialist principles which reflect the ideology of socialism. Article 38, 39, 39 capital A, 41, 42, 43, 43 capital A. That's all. Did you get? First try to remember this. 38, 39, 39 capital A, 41, 42, 43, 43 capital A and 47. Right? Then what are the Gandhian directive principles? 6. We have 6 Gandhian directive principles. What are the 6 Gandhian directive principles? 40, 43, 43 capital B. That's all. Good. I will make you right. 40, 43, 43 capital B. 40, 43, 43 capital B, 46, 47, 48. Yes. How many liberal intellectual principles are there? How many liberal intellectual principles? 7. What are those? 44, 45, 48. Very good. Perfect. So we have 7 liberal intellectual principles, 6 Gandhian principles and 8 socialist principles. First try to remember these. Okay? Yes. Then thereafter, now all these articles are the real content of DPSPs. I did not make you write 36, 37 here. Okay? Right. Then what is Article 38? What is Article 38? It talks about the promotion of people's welfare. 38 deals with the promotion of people's welfare. The title of Article 38 is to promote the people's welfare. How will you promote the people's welfare? Then it is 38 clause 1 and 38 clause 2. 38 clause 1 talks about by securing social order. 38 clause 2 talks about to minimize inequalities in income, status, wealth and opportunities. I am writing Article 38 to promote dictator. Just only this has division. To promote people's welfare. To promote people's welfare by securing social order. This is 38 clause 1. By minimizing inequalities in income, wealth, status and so on. This is 38 clause 2. By minimizing inequalities in income, status and opportunities. Income, status and opportunities. One is 38 clause 1, other is 38 clause 2. By securing social order. How will you secure a social order? By ensuring social, economic and political justice. Okay, right. And out of these two articles, Article 38 Clause 1 and Article 38 Clause 2, your 38 Clause 2 was added by 44th Constitutional Amendment Act 1978. Added by 44th Constitutional Amendment Act 1978. 38 Clause 2 was added by 44th Constitutional Amendment Act 1978. This is all about Article 38. Right. Then what is Article 39? Article 39 has how many clauses? Article 39. Article 39 has 6 clauses. What is 39 Clause A, 39 Clause B, 39 Clause C, D, E, F? What is Article 39 Clause A?
Equal livelihood affordable.
Okay, adequate means of livelihood. That is the only keyword which you must remember in 39 Clause A. See, Article 39, and I told you it has 6 clauses. Article 39 had 6 clauses, and 39 Clause A. What is the keyword which you must remember? Adequate means of livelihood for all citizens. Only adequate means of livelihood. Try to remember adequate means of livelihood. Adequate means of livelihood. Now, how these adequate means of livelihood can be ensured? By NREGA, by rural livelihood missions. Okay, right. Then what is 39 Clause B? Equitable distribution of material resources. If you want, you can write, otherwise I will just go like this. 39 Clause B talks about equitable distribution of material resources. How will you distribute resources equally? Land reforms. Are you getting? The first one is land reforms. Second one is land redistribution, progressive taxation. You are taxing the rich and you are distributing the money among the poor people in the form of pensions. Yes. Then Article 38 Clause A, adequate means of livelihood. 39 Clause B, equitable distribution of material resources. Don't write equal distribution. Please write down equitable distribution of material resources. Equitable distribution of material resources. Then what is Article 39 Clause C? Prevention of concentration of wealth in few hands. 39 Clause C talks about prevention of concentration of wealth in few hands. Prevention of concentration of wealth in few hands. There, how this can be ensured? Through progressive taxation. And second one is through land reforms. Okay, prevention of concentration of wealth. At that time, land was the asset through which wealth can be assumed. Right? Right. Then, yes. Then Article 39 Clause D. What is Article 39 Clause D? Equal pay for equal work for men and women. Equal pay for equal work for men and women. What are the how to ensure equal pay for equal work? Equal Remuneration Act 1976. Equal Remuneration Act 1976. You have ARK material with you? ARK material. No? Earlier one's material which you got. Equal Remuneration Act 1976. Equal Remuneration Act 1976 talks about equal pay for equal work for men and women. Then what is 39 Clause E? Very good. There you write down protection of health and strength. Protection of health and strength of workers, women and children. Their example of an act is Child Labor Prohibition Act. Child Labor Prohibition Act 1986. Child Labor Prohibition Act 1986. Next one is Child and Adolescent Labor. It's the latest form I am making you write. Child and Adolescent Labor. Child and Adolescent Labor in brackets. Prohibition and Regulation Act, Prohibition and Regulation Act 2016. Right? How many did we write? How many clauses did you write? 5. Write down the last clause, 39 clause F. What is 39 clause F? Healthy development of children, opportunities for healthy development of children. Healthy development of children. Only keywords I am writing. Healthy development of children. How to ensure healthy development of children? How will you ensure? Midday meal scheme. Very good. Integrated child development scheme through immunization drives. Yes, Rakesh? Yes, right to education. Good. Healthy development of children. There you write down some examples. How to ensure healthy development of children? Midday meal scheme. Midday meal scheme. Integrated child development scheme, ICDS. And for children, when he is born or when a child is born, we give him so many injections like rotavirus, polio. Are you getting? All these are part of immunization drive for children. Immunization drives for children. Right? And here you need to remember this 39 clause F was added by. This 39 clause F was added by 42nd Constitutional Amendment Act 1976. Don't forget this. Until now we completed how many socialist principles? 2. One is 38, second is 39. What is 38? To promote people's welfare. What is 39? It includes all these basic things. Okay, 39 clause A to 39 clause F. Now, next is Article 39 capital A, free legal aid to the poor. 39 capital A, free legal aid to the poor. And this 39 capital A was also added by 42nd Constitutional Amendment Act 1976. 39 capital A, free legal aid to the poor. And who will provide this free legal aid to the poor? NALSA, National Legal Services Authority. NALSA, National Legal Services Authority, NALSA. Getting? Yes. And thereafter, write down what is the next socialist principle which I made you write?
41.
Article 41. Article 41 talks about the right to work, education, and public assistance. Right to work, education, and public assistance. Right to work, right to work, education, and public assistance. In case of old age, unemployment. In case of old age, unemployment, sickness and disableness. Sickness and disableness. Sickness and disableness. Right? So, there you write down which scheme ensured right to work in 2005? Narega. Write down MG Narega 2005. MG Narega 2005. Next one is unemployment allowance, Nirudyoga Bhruti. Okay, unemployment allowance, old age pensions. All these are being given under which article? 41. See, the state is keeping in mind the basic directive principles or not while implementing laws and formulating policies. Then old age homes, last one is old age homes run by the state governments. Old age homes run by the state governments. The next one is old age homes run by the state governments. So how many socialist principles did we complete until now? 4. One is 38, 39, 39 capital A and 41. Next, write down the next directive principle, Article 42, just and humane conditions. Article 42, just and humane conditions of work and maternity relief. Just and humane conditions of work and maternity relief. Now, according to the recent Maternity Benefit Act 2017, what is the maternity leave that is being given? 26 weeks. Okay, please write down there. Maternity Benefit Act, Maternity Benefit Amendment Act 2017. Maternity Benefit Amendment Act 2017. According to this, 26 weeks maternity leave is provided for first 2 children. 26 weeks maternity leave is provided for first 2 children. Next is 43, to secure a living wage. To secure a living wage and decent standard of life. Just you need to, if you are writing, if you are not writing, it's okay. And if you are writing only keywords, living wage. To secure a living wage and decent standard of life. There what you will write is, as an example, Minimum Wages Act 1948. Minimum Wages Act 1948. Minimum Wages Act 1948. Article 43 capital A. How many did we complete socialist principles? Till how many are left?
247.
Only 43 capital A and 47. Please write down 43 capital A. Participation of workers in the management of industries. Participation of workers in the management of industries. And there, please write down, it was added by 42nd Constitutional Amendment Act 1976. It was added by 42nd Constitutional Amendment Act 1976. And example, what will you write? The Industrial Disputes Act 1946. The Industrial Disputes Act 1947. Industrial Disputes Act 1947. Trade Union Act 1927. Trade Union Act 1927. Okay? Yes. And thereafter we have 47. To increase the level of nutrition, to raise the level of nutrition and standard of living of people. To raise the level of nutrition. To raise the level of nutrition and standard of living of people. How will you raise the level of nutrition?
Providing 45 days in
PDS, National Food Security Act 2013. Okay? Whatever you know, please write down there. First write down National Health Mission. Examples. First example is National Health Mission. Second one, NFSA, National Food Security Act 2013. National Food Security Act 2013. Midday meal schemes. Next is PDS, Public Distribution System. And if you want to write, you can write 5 rupees Bhojanam. Yes, you can write that. Right? This is all about socialist principles. Now, please, someone without seeing in your notes, tell me the 8 socialist principles without looking into your notes. 38.
Forty-seven.
47. Perfect. Very good. I understood. Right. Next, write down Gandhian principles. I mean to say, just here to Gandhian principles. We'll complete this and fundamental duties. We'll complete now. I will give break. I will give. Please wait for 2 minutes. Right. See, the next principles which we have to discuss is the 6 Gandhian principles. The 6 Gandhian principles. Then what are the 6 Gandhian principles? 40, 43 capital B, 46, 47, 48. Now what is 40? To organize village panchayats. To organize village panchayats. How this Article 40 was implemented? By 73rd Constitutional Amendment Act 1992 and 74th Constitutional Amendment Act 1992. But out of these, try to write for 73rd Constitutional Amendment Act 1992. Urban local bodies, municipalities. Please write down Article 40 to organize village panchayats. To organize village panchayats, Article 40. Article 43 to promote cottage industries. Article 43 to promote cottage industries in rural areas. And for this we have KVIC, Khadi and Village Industries Commission. To promote cottage industries we have KVIC, Khadi and Village Industries Commission. Khadi and Village Industries Commission. Next, what is 43 capital B? To promote cooperative societies. To promote cooperative societies. To promote cooperative societies. Yes, it was added by 97th Constitutional Amendment Act 2011. 97th Constitutional Amendment Act, 97th CAA 2011 added 43 capital B, which talks about to promote cooperative societies. Okay? What are cooperative societies? When a group of people come together and they set up one best example of cooperative society, Amul Dairy. Okay? Housing cooperatives. They gather resources, they pool money, and they will start any cooperative. Okay? Self-help groups, I don't think so. Okay? Yes. Right, friends. Then, and thereafter we know the next Gandhian principle after 40, 43 and 43 capital B is 46. What is Article 46? Promotion of educational and economic interest of scheduled caste, scheduled tribes and other weaker sections. Please write down promotion of educational and economic interest of scheduled caste, scheduled tribes and other weaker sections. Promotion of educational and economic interest of SCs, STs and other weaker sections. And example is nothing but reservations for SCs, STs and OBCs. Yes. Thereafter, you can write model schools for STs. Enough. Right. Then the next is Article 47 to prohibit the consumption of intoxicating drinks. What is Article 47? Prohibiting the consumption of intoxicating drinks. Prohibiting the consumption of intoxicating drinks and drugs. Okay? See, what are the examples of acts that were enacted by the government of India to prohibit the consumption of intoxicating drinks and drugs? We have NDPS Act, okay, Narcotic Drugs and Psychotropic Substances Act 1985. Just you write down NDPS Act 1985. NDPS Act 1985. NDPS Act 1985 prohibits the consumption of intoxicating drinks and drugs. And second one is Food Safety and Standards Act. Food Safety and Standards Act 2006. Food Safety and Standards Act 2006. Food Safety and Standards Act 2006. Now, did we complete all? 48. Article 48. Yes, please write down Article 48 to prohibit the cow slaughter. To prohibit the slaughter of cows, calves and other cattle. To prohibit the slaughter of cows, calves and other cattle. And you know very well, livestock is a state subject. Therefore, different states have enacted the laws banning cow slaughter. Okay? One note point if you want, you can write there. Livestock is a state subject. LIVE, live, STOCK, stock. Livestock is a state subject. State subject. Therefore, different states like Gujarat, Uttar Pradesh, Madhya Pradesh. Yes. Different states like Gujarat, Uttar Pradesh, Madhya Pradesh, Himachal Pradesh, Karnataka, so on. Himachal, Uttar Pradesh, Madhya Pradesh, Himachal Pradesh, Karnataka and so on have enacted the laws banning cow slaughter. Right. This is all about Gandhian principles. Now the next principles which we have to discuss in very crisp manner is the liberal intellectual principles, that is from Article 44 to Article 51. Liberal intellectual principles, we have 7 liberal intellectual principles, 7. First one is 44, second 45, third 48 capital A, fifth, 49, 50, 51. Article 44, Article 45, 48, 48 capital A, 49, 50 and 51. Now out of these articles, which article talks about separation of judiciary from executive? 50. Which article talks about promotion of international peace? 51. Okay. Which article talks about protection of natural environment? 48 capital A. Perfect. Which article talks about uniform civil code? 44. What is uniform civil code? What is uniform civil code? In matters, in personal matters. Okay, good. Uniform civil code. In India, do we have uniform criminal code? Yes, but we don't have uniform civil code. Which state was the first state after India's independence? Uttarakhand. Why you are not saying Goa? Goa enacted UCC, or Goa implemented UCC way back before India's independence. Okay, that is the reason we call Uttarakhand as the first state to implement UCC after India's independence. Okay, however, what do you mean by uniform civil code? Uniform civil code is a proposal to replace the personal laws of different communities, to replace the personal laws of different communities with one law, with one personal law that is applicable to, with one law that is applicable to all the communities. I repeat, UCC is a proposal to replace the personal laws of different communities with one common law which is applicable to all the communities. Did you understand? Yes. And Uttarakhand is the first state in India to implement UCC. And Goa implemented UCC in 1867. Goa implemented UCC in 1867, and Uttarakhand was the first state in India to implement UCC after India's independence. Never forget. This is all about Article 44. Now, what is Article 45? Very interesting. What is Article 45? Yes, education. Yes, very good. Yes. Very good. Change in age. It changed the subject matter of Article 45. Which Constitutional Amendment Act changed the subject matter of Article 45? 86th Constitutional Amendment Act 2002. Please remember, my dear friends, Article 45 today reads to provide early childhood care for education. Early childhood care and education for all children below 6 years of age. Now today, your 45 is talking about to provide early childhood care and education to all children below 6 years of age. But this was not the criteria before. Before 86th Constitutional Amendment Act 2011, 2002, what was Article 45? It spoke about, yes, Amma? 14 years of age. It spoke about the right to education. Education of children up to 14 years of age. The 86th Constitutional Amendment Act 2002 has changed the subject matter of Article 45, and today your Article 45 reads to provide early childhood care and education to children below 6 years of age. So your Anganwadi schools have been established under Article 45 today. And regarding this 86th Constitutional Amendment Act 2002, it is very, very important Constitutional Amendment Act because it made changes in 3 provisions of the Constitution. One is it made changes in fundamental rights. It made Article 21 capital A fundamental right, right to education. It changed the DPSP's Article 45. It also introduced the 11th fundamental duty. It also introduced the 11th fundamental duty, Article 51 capital A clause K. As 86th Constitutional Amendment Act 2002 has made changes in 3 provisions of the Constitution, it is very important for you to remember. Okay, it introduced Article 21 capital A, right to education is a fundamental right now. It changed the subject matter of Article 45 and it introduced or added the 11th fundamental duty, Article 51 capital A clause K. Now what is 51 capital A clause K? It is a duty of the parent to provide opportunities for education of his children. Duty of the parent or guardian to provide opportunities for education of his child. Okay? Yes. 45 you understood? To provide early childhood care and education to all children below 6 years of age. What happened? I did not get it.
Early childhood.
Okay. Yes. Right. Next one. Okay. See, really I did not get it. Okay. Next is 48. What is Article 48? To organize agriculture and animal husbandry on modern and scientific lines. Here I made them write so many revolutions. Okay, green revolution, milk, whatever revolutions are there, all those you can write here as examples. What is Article 48? To organize agriculture and animal husbandry on modern and scientific lines. For example, Green Revolution 1966 to 1967. Next is White Revolution 1970 to 1996, and so on. So many revolutions you can write from here. Whatever revolutions are there, you can write. And if you want to see, you can see someone's notes in ARK Reflection IAS. You can find each and every revolution, who was the father of that revolution, from which year to which year it spanned, each and everything you can find there. The 49th, next is Article 49, to protect the monuments, objects and places of national importance. To protect the monuments, objects and places of national importance. Okay? To protect monuments, objects and places of national importance. And to ensure this Article 49, the government of India has introduced two schemes. One is Prasad scheme, PRASAD, Prasad scheme. Second is Hriday, HRIDAY, Hriday scheme, Prasad scheme and Hriday scheme. Do you want abbreviation? Full? Hriday scheme and Prasad scheme, right? The next is Article 50, separation of judiciary from executive. Separation of judiciary from executive. Please tell me one example of how the judiciary is separate from executive.
India was
Example, I want one perfect example to show that, see, there is separation of executive from judiciary from executive.
Appointment of Chief Election Commission.
What is that known as?
Collegium.
Collegium. Immediately, so if someone asks you what is an example of Article 50, separation of judiciary from executive, you can say collegium. Why? Today judges are being appointed by judges only. There is no interference of executive there. But earlier NJSC when NJSC was brought, there at least 3 members were executives in that body, in NJSC. The Supreme Court has struck down NJSC because it was against the independence of judiciary. And independence of judiciary is a part of basic structure of the Constitution. Did you understand? Yes. And next one is Article 51, promotion of international peace and security, respect for international laws, and so on. Promotion of international peace, treaties, security, respect for international laws, and whatever you want to write, treaties, organizations, you can write there. Right. 48A, I did not make you write. Please write down Article 48 capital A, to protect natural environment. Yes. There you write down to protect environment and safeguard forest and wildlife. To protect environment and safeguard forest and wildlife. It was added by, next point, it was added by 42nd Constitutional Amendment Act 1976. Okay, there you write down one more if you want, one more point. Article 48 capital A is synonymous to Article 51 capital A clause E. Article 48 capital A, Article 51 capital A, Clause E. This is your fundamental duty. This is your DPSPs. It's G, no? Article 51 capital A, Clause G. Now, what were the steps taken to promote natural environment? What were the laws that were enacted? Wildlife Protection Act 1972, the National Biodiversity Act 2002, and very good. Write down these three acts there. If someone is writing, you can write. Otherwise, you can skip. The first one is Environment Protection Act 1986. Environment Protection Act 1986. The second one is Wildlife Protection Act 1972. And third one is National Biodiversity Act 2002. National Forest Policy 1988. National Forest Policy 1988. Yes. Now friends, what are the directives outside part 4? What are the directive principles which are mentioned outside part 4 of the Constitution? There are 3 directives that are mentioned outside part 4 of the Constitution. What are those? Article 355 or 335? Article 335. Please write down. Just 3 directives which are outside part 4 of the Constitution. Yes, 330. Write down there. Directives that are outside part 4 of the Constitution. Why? Because see, there are few directives which are mentioned not in part 4. They are mentioned in other parts. There, please write down. Article 335 in part 16 of the Constitution. Article 335 in part 16 of the Constitution. The claims of SCs and STs to public service. This talks about the claims of SCs and STs. Claims of SCs and STs to services of government. Okay. Now what does this mean? The claims of SCs and STs shall be taken into consideration along with maintaining administrative efficiency. This is mentioned there. You should provide reservation to SCs and STs, but this does not mean that you compromise administrative efficiency. Are you getting? There must be some minimum qualification mark. You cannot keep on reducing this qualification mark. Some minimum standard of mark should be there. Are you getting? Claims of SCs and STs to public services of government, right? Next one is Article 350 capital A in part 17, instructions in mother tongue. Article 350 capital A in part 17. 350 capital A in part 17. There you write down. Instructions in mother tongue to children belonging to linguistic minorities. Instructions in mother tongue to children belonging to linguistic minorities. The next article is 351 in part 17. Development and spread of Hindi language. 351 in part 17. Article 351 in part 17 of the Constitution. It talks about development and spread of Hindi language. Development and spread of Hindi language. Enough. Now, I will start fundamental duties. I will complete in 5 to 10 minutes, fundamental duties. Thereafter, I will start emergency provisions. Very, very important. Why? Because this year, it marks 50 years of national emergency. And thereafter, see, I will keep on going like this, okay? Yes. Okay, we will go for part 5. After this, emergency provisions, okay? Right. See, as you are aware, new directive principles were added by 4 constitutional amendment acts. Shall I make you write, or is it okay for you? Already questions have been questions came from this area. By 42nd Constitutional Amendment Act, 4 new directive principles were added. By 42nd Constitutional Amendment Act, you need not write, just listen to me. By 42nd Constitutional Amendment Act, 4 new directive principles were added. One is Article 39 Clause F. Second is 39 capital A. Third one is 43 capital A. And fourth one is 48 capital A. So 42nd Constitutional Amendment Act 1976 has added 4 directive principles. Okay, 39 Clause F, 39 capital A, 43 capital A, and last one 48 capital A. Next, 44th Constitutional Amendment Act 1978. It added one directive principle, that is 38 Clause 2. 38 Clause 2. Next, 97th Constitutional Amendment Act 2011. It added one directive principle, 43 capital B. Yes, cooperative societies. And 86th Constitutional Amendment Act 2002 has changed the subject matter of Article 45. It changed the subject matter of Article 45. Yes. Right, friends? Now, we will try to complete fundamental duty in just 5 to 10 minutes. What is a duty, my dear friends? Before starting fundamental duty, what is a duty? As I discussed with you before directive principles of state policy, we asked ourselves one question. What is a directive principle, or what are DPSPs? In the manner, what is a fundamental duty, or what is a duty? Okay, very good. A duty is a responsibility or an obligation. Yes, a duty is a responsibility or an obligation. Therefore, if we go by this logic, fundamental duties are the constitutional obligations. What are fundamental duties? Fundamental duties are the moral and constitutional obligations imposed on the citizens of India. These fundamental duties are applicable only to the citizens of India. Don't forget, they are applicable only to the citizens of India. And your part, Article 51 capital A, in part 4 capital A of the Constitution, deals with 11 fundamental duties. Are you getting? 11 fundamental duties. And out of these, I would like to inform you that the list of fundamental duties was not mentioned in the original Constitution. For that matter, no democratic country in the world except Japan. Japan was the only democratic country in the world to contain a list of fundamental duties in their original Constitution. Other democratic countries like America, Canada, Germany, India also did not contain the fundamental duties in their Constitution. Did you understand? Yes. And the 42nd Constitutional Amendment Act 1976 has added a new part 4 capital A, a new Article 51 capital A to the Constitution. And your Article 51 capital A contained 10 fundamental duties. And these fundamental duties were incorporated on the recommendations of Swaran Singh Committee. Did you understand? Swaran Singh Committee, which was constituted by the government of India during the times of internal emergency. Okay. Yes. Swaran Singh Committee actually gave 8 recommendations, but only 5 recommendations of Swaran Singh Committee were incorporated in the 10 fundamental duties. We find only 5 recommendations of Swaran Singh Committee in the list of 10 fundamental duties that were added by 42nd Constitutional Amendment Act 1976. Then when was this 11th fundamental duty added? By 86th Constitutional Amendment Act 2002. So as of today, we are having 11 fundamental duties. So your fundamental duties start from Article 51 capital A clause A. Article 51 capital A clause A. They end with Article 51 capital A clause K. Then what is Article 51 capital A clause A? To follow the constitution and respect national flag, national anthem, national song. The national anthem is mentioned in Article 51 capital A clause A, but national song is not mentioned in Article 51 capital A clause A. I mean to say, what is national anthem? Who wrote national anthem? Rabindranath Tagore. Who wrote this national song? Bankim Chandra Chatterjee. When were these national anthem and national songs incorporated in our Indian constitution? I mean to say, when they became a part of Indian constitution. On 24th January 1975. Don't forget. So your Article 51 capital A clause A talks about to abide by the constitution, to respect national flag, national anthem. Okay. Then see how this Article 51 capital A clause A is ensured. There is one law, and that law is Prevention of Insults to National Honors Act. Which year? 1971. Never forget. Okay, I will make you write those if you want. 51 capital A clause A talks about to abide by the constitution, respect national anthem, national flag, and so on. Next is Article 51 capital A clause B, to cherish and follow the noble ideals. Okay, please write down there. Prevention of insults to National Honor Act. Prevention of Insults to National Honor Act, 1971. It was implemented to implement duty, Article 51 capital A clause A. Next is 51 capital A clause B, to cherish and follow the noble ideas that inspired freedom struggle. May I please know some of the noble ideas that inspired freedom struggle? Non-violence, satyagraha, okay, and some other, these. To cherish and follow the noble ideas that inspired the freedom struggle. Next one is Article 51 capital A clause C, to uphold and protect the sovereignty, unity, and integrity of India. Next, 51 capital A clause D, to defend the country and render national service. To defend the country and render national service. There, do you want to write one act? Please write down Disaster Management Act. Disaster Management Act 2005. Disaster Management Act 2005. It is also suitable for Article 51 capital A clause C also. Right? Thereafter, 51 capital A clause E, to promote harmony and spirit of common brotherhood. To promote harmony and spirit of common brotherhood. Now, please tell me some of the articles related to secularism. While I was explaining secularism, I forgot to mention articles which ensure secularism in India, or what are the constitutional provisions which ensure secularism in India. First is the preamble. In preamble, what can I make you write? Liberty of thought, expression, belief, faith, and worship. In that, the liberty of belief, faith, and worship ensures secularism. Point number one. Which fundamental rights are examples of ensuring secularism? Article 14, 15, 16, 25, 26, 27, 28, 29, 30. Which directive principle? 44. Article 44 also ensures secularism. Uniform Civil Code. And after that, we have one fundamental duty, and that is Article 51 capital A clause E, to promote the sense of brotherhood. If you want, I will make you write. Otherwise, no need. Yes. 51 capital A clause E. Next one is 51 capital A clause F, to value and preserve the rich heritage and composite culture of India. 51 capital A clause F talks about to value and preserve the rich heritage and composite culture. 51 capital A clause G, to protect the natural environment. This one, to protect the natural environment, forest, lakes and rivers. Next one is 51 capital A clause H, to develop scientific temper. What do you mean by developing scientific temper?
Rationalism.
To promote rational thinking, to promote questioning, okay, right, to promote logic, reasoning, all these falls under to promotion of scientific temper. Next one is Article 51 capital A clause I, to safeguard public property and avoid violence. To safeguard public property, this is important. How will you say which article ensures safeguarding public property? 51 capital A clause I. Next one is 51 capital A clause J. That is not that much important. If everyone strives towards excellence, then automatically nation will grow. This is mentioned in Article 51 capital A clause J, not required. Next is very, very important, Article 51 capital A clause K. What is, yes, what is Article 51 capital A clause K? Responsibility of a parent to provide opportunities for education of his children. And this 51 capital A clause K was added by 86th Constitutional Amendment Act 2002. Never forget. Okay, right. Other than this, do you want to know some acts which enforce fundamental duties? Right. See, we have Representation of Peoples Act 1951. Then we have UAPA Act 1967, the Forest Conservation Act 1980, the Prevention of Insults to National Honors Act 1971. We also have Wildlife Protection Act 1972, Disaster Management Act 2005, and thereafter I read all, the Protection of Civil Rights Act 1955. All these acts will ensure what? Your fundamental duties. They are enforcing fundamental duties in one way or the other way, right? No, 1 minute. Do you want break for 5 to 10 minutes? Okay, then go for break and we will come back fast. I will start emergency provisions, which is very, very important chapter. Thereafter, we will go for part 5. Okay? Yes. It is 16:40. It is 4:45 now. Please come back in just 5 minutes, 5 to 7 minutes. Okay? Yes. Location class in తర్వాత లేదు పాలిటీ ఇంత పెద్ద సబ్జెక్ట్ ఇది 75 క్లాసెస్ తీసుకోవాలి అంతే.
అంటే ఈ రోజు
రోజు తెలుసు నేను ఆల్రెడీ నాకు 2 క్లాసెస్ ఉన్నాయి వేరే చెప్పాలి క్యాన్సిల్ చేసి
ఓకే
అంటే నేను ఇన్ఫార్మ్ చేశాను. నేను ఆల్రెడీ ఆర్కి 2 బ్యాచెస్ తీసుకున్నాను.
మరి ఈరోజు మొత్తం
అయినంత ఎంత ట్రై చేస్తాను. I will try to do something. Okay, shall we start? After this, we'll be quick. Right. Hello, friends. Shall we start?
Yes, sir.
Right. Now let us start emergency provisions. As you are aware, what do you mean by an emergency? What is an emergency? Anyone in this class?
Situation where
What is an emergency? Or the concept of emergency provisions we have borrowed from which? From where? Very good. The concept of emergency provisions was borrowed from Government of India Act 1935. And what do you mean by emergency? An emergency is a sudden or serious situation which we have not dreamt of. An emergency is a serious situation which requires immediate action is known as emergency. Are you understanding? Any serious situation which requires immediate action, it is known as emergency. And the concept of emergency provisions we have borrowed from Government of India Act 1935. But the concept of suspension of fundamental rights during emergency, this was borrowed from Weimar Constitution of Germany. From Weimar Constitution of Germany. Okay, concept of emergency provisions from Government of India Act. Concept of suspension of fundamental rights during emergency from Weimar Constitution of Germany. And thereafter, as I told you, article, if you see the constitutional provisions, article 352 to 360. Article 352 to 360. In part 18, never forget to write part 18. Okay, 352 to 316, part 18 of the Constitution deals with three types of emergencies. The first one is national emergency under Article 352, President's rule under Article 356, and third one is financial emergency under Article 360. Okay, now if I ask you about national emergency, do you think the word national emergency is mentioned in your Constitution? If it is not mentioned, then what does Article 352 consist of? Proclamation of emergency. Very good. Now, the first type of emergency I am going to discuss, that is national emergency under Article 352 of the Constitution. Your Article 352 does not mention the word national emergency. Rather than national emergency, we have one word known as proclamation of emergency in Article 352. Then why is the word national emergency mentioned in our textbooks? Because whenever this emergency was imposed under Article 352, till date it was imposed thrice, and for 3 times this emergency was imposed nationwide. That is the reason we call the emergency under Article 352 as national emergency, though the word national emergency is not mentioned in the Constitution, right? And after that, what is the main condition to impose national emergency? What is the condition? That are not the conditions, my dear friends. What is the main condition? What you are talking is the grounds of imposition of national emergency. My question to you was, what is the condition to impose national emergency? Perfect. When there is a threat, according to Article 352, if the President of India is satisfied that there is a threat to the security of India or any part of it. So the main keyword is threat to security of India or any part of it. This is the condition. There must be a threat to the security of India or any part of it. And if the President is satisfied that there is a threat to the security of India or any part of it, then the President can impose national emergency under Article 352. How there can be a threat to the security of India or any part of it? There are 3 grounds. War, external aggression, and armed rebellion. There can be a threat to the security of India or any part of it, either by war or external aggression or armed rebellion. Are you getting? Until date in India, your national emergency was imposed thrice, 3 times. Our national emergency was imposed in India 3 times. First was from 1962 to 1968 during Indochina War. The second was from 1971 to 1977 during the Indo-Pak War, and third is from 1975 to 1977. Okay, this was during Indochina War. Indochina War. This is during Indo-Pak War, and this is due to internal disturbance. At that time, it was known as internal emergency. Internal emergency imposed on the grounds of internal disturbance. I forgot to ask you one question. What is the difference between war and external aggression? I made you write the 3 grounds: war, external aggression, armed rebellion. Please tell me the difference between war and external aggression. What is the difference between war and external aggression?
War is a two-way.
War, what is the difference between war and external aggression? War is a formal attack on a country. External aggression is an informal attack on a country, point number 1. War is a high intensity combat. External aggression is not a high intensity combat. External aggression is because of the non-state actors or maybe by the enemies of foreign countries. Who are non-state actors? Terrorists. Are you understanding? The external aggression might be because of the armies of the other countries, or the external aggression may be because of the non-state actors like terrorist attacks in the country. Mumbai attack is an example of external aggression. Pahalgam attack is an example of external aggression. Are you getting? So in normal terms, if someone asks you what is the difference between war and external aggression, war is a formal attack, external aggression is an informal attack. Okay, external aggression may be because of the armies of other countries like Chinese aggression. Do you know the first emergency which was imposed was because of Chinese aggression? Later it turned into a war. Are you getting? Yes, never forget. Now I told you emergency was imposed 3 times during Indochina War, Indo-Pakistan War, and third was on the grounds of internal disturbance, and it was known as internal emergency. Actually, the third ground to impose national emergency was internal disturbance until 44th Constitutional Amendment Act 1978. The word internal disturbance was replaced by the word armed rebellion. This word was replaced by the word armed rebellion. Why? Internal disturbance could be misused. Internal disturbance can be misused and it is too vague. Anything can be shown as an example of internal disturbance. But in case of armed rebellion, until and unless you take arms into your hand and start attacking the state institutions. Are you getting? It can be clearly visible. It can be judged easily. Armed rebellion can be judged easily. Armed rebellion involves the use of violent means to overthrow the government. And if someone is doing that, immediately national emergency can be imposed on the third ground. Getting? Yes. Then once let us consider the president is satisfied that there is a threat to the security of India or any part of it. And he imposed national emergency, perfect. Then your national emergency, once it is imposed by the president, it must be approved by both the houses of parliament.
Special majority type 2.
Good. Good. It must be approved by both the houses of parliament within dash time and by which majority? Within 1 month. Within 1 month by special majority type 2. Never forget. It must be approved by both the houses of parliament within 1 month by special majority type 2. Now my question to you is, once both the houses of parliament approve national emergency, then it will continue to remain in operation for 6 months. 6 months from the date of imposition of national emergency or 6 months from the date of approval of national emergency by both the houses of parliament.
On the date of approval.
Very good. From the date of approval of national emergency by both the houses of parliament. Don't forget. Are you understanding? Earlier, the national emergency could be imposed only on the advice of Prime Minister. But now, the national emergency can be imposed only on the written recommendation or written advice of the Council of the Cabinet. It was here the word Cabinet was included in Article 352 by 44th Constitutional Amendment Act 1978. Are you understanding? Earlier, our president used to impose national emergency only on the advice of Prime Minister. But this provision was changed by 44th Constitutional Amendment Act, and now the president can impose national emergency only on the written recommendations of the Cabinet. Here 2 words were added, written recommendation and the Cabinet. That is how your Cabinet got included in Article 352 by 44th Constitutional Amendment Act 1978. Once the president imposes national emergency, your national emergency continues to remain in operation for 6 months. 6 months from the date of approval of national emergency by both the houses of parliament. Never forget. Within 1 month, 1st Feb, and this is within 1 month. Let us consider president impose national emergency on 1st Jan. Then before 1st February, your national emergency must be approved by both the houses of parliament. Then let us consider on 15th January. On 15th January, your national emergency was approved by both the houses of parliament. Then it will continue to remain in operation for 6 months. 6 months from the date of approval of national emergency by both the houses of parliament. So your national emergency will continue to remain until 6 months. Okay, what is the date here? 15th July. 15th July. Are you understanding? Yes. Now, suppose if you want to extend national emergency further, then you need to approve national emergency before the expiry of 6 months. Then again, national emergency can continue to remain in operation for another 6 months. So in this manner, what is the maximum time period for which national emergency can be in operation? Indefinite period of time. Your national emergency can be in operation for an indefinite period of time in this manner. The only requirement is your national emergency must be approved by both the houses of parliament for every 6 months. Did you understand? For your clarity, I have drawn this diagram. This is within 1 month. This is from the date of approval of both the houses of parliament, right? Had it been president's rule, the president's rule would continue to remain in operation for 6 months from the date of imposition of president's rule by the president. Don't forget this. Okay? Yes. And for further continuation of national emergency, the parliament must approve the national emergency resolution again by which majority? Special majority type 2. Special majority type 2 before the expiry of 6 months. Okay? Yes. Suppose, let us consider here instead of both houses of parliament, Lok Sabha got dissolved. Suppose, let us consider. Then, please listen to me carefully. Here, instead of parliament approval by both the houses of parliament, let us consider Lok Sabha got dissolved due to any circumstances. Now, what is the only house present there? Rajya Sabha. So, in that cases, your national emergency will continue to remain in operation if and only if the Rajya Sabha approves national emergency within 1 month by special majority type 2. Did you understand? And within 6 months, the fresh elections to Lok Sabha must be held. And the time within which the newly constituted Lok Sabha must approve national emergency is 30 days. It is not 1 month. It is 30 days. The newly formed Lok Sabha, the newly constituted Lok Sabha must approve national emergency within 30 days. Don't forget. Right? Yes. Suppose if the newly constituted Lok Sabha does not approve national emergency, then what is the fate of national emergency? The national emergency will come to an end. Why? The basic requirement for continuation of national emergency is it must be approved by both the houses of parliament. Here only one house has approved in case of dissolution of Lok Sabha. So there is necessity of the second house approval also. But if the newly constituted Lok Sabha does not approve the national emergency, then the national emergency will come to an end. This is the case of dissolution of Lok Sabha during national emergency. Did you understand? Yes. Now, who can revoke national emergency? Who has the powers to, or how a national emergency can be withdrawn or revoked? There are two ways. There are two ways of withdrawal of national emergency. The first point is the president can revoke national emergency at any time, point number 1. The second is the Lok Sabha can withdraw national emergency by passing a resolution by simple majority. Did you understand? The Lok Sabha can pass a resolution to withdraw national emergency by just simple majority. But Lok Sabha, to do that, there is a procedure mentioned. Earlier, the Lok Sabha did not have these special powers. The Lok Sabha was given special powers by 44th Constitutional Amendment Act 1978. Before 44th Constitutional Amendment Act 1978, Lok Sabha did not have these special powers to withdraw national emergency. Then what is the procedure to withdraw national emergency? If 10% of the members of Lok Sabha, gives a written notice to the speaker if Lok Sabha is in session. Suppose if the Lok Sabha is in session, if 10% of members of Lok Sabha gives a written notice to the speaker, and if Lok Sabha is not in session, then these 10% of the members of Lok Sabha will give a written notice to the President of India. Okay? Then a special sitting of Lok Sabha should be convened within 14 days. Did you understand? Special sitting of Lok Sabha should be held within 14 days, and in these 14 days, if Lok Sabha passes a resolution by simple majority, then immediately your president should revoke national emergency. Did you understand? Yes, this is all about national emergency. But
10% of Lok Sabha is before 44th.
no, before Lok Sabha did not have any special powers to withdraw national emergency. It was 44th Constitutional Amendment Act which empowered the Lok Sabha to withdraw national emergency. It gave special powers to Lok Sabha. And Lok Sabha does not have these special powers to withdraw president's rule or financial emergency. There Lok Sabha does not have any special powers. Did you get, my dear friends? Yes. Then what is the effect or impact of national emergency on the legislative relations between center and states? What will happen when national emergency is imposed to the state executive? Yes, state executive.
State will be exception. State will be the same.
State executive will exist as it is. Very good. Then what will happen? Whenever, see, now let me discuss with you the effects of national emergency. Effects of national emergency on the executive relations of the state, center state. Whenever national emergency is imposed, the center can give executive directions to the state on any matter. So what is the keyword here? The center can give executive directions to the states on any matter. On any matter is the very important word which you must remember. The center can give executive directions to the state on any matter. But during normal conditions, the center used to give directions to the state only on some specified matters. Only on some specified matters. But during national emergency, the center can give executive directions to the states on any matter. Point number 1. Okay. The second point is, during national emergency, the center becomes all powerful and the states go into the complete control of the center. During national emergency, the center becomes all powerful and the states go into the complete control of the center. Thus, what we can say? Therefore, during national emergency, the federal structure of the country is getting converted into the unitary structure without formal amendment of the constitution. Did you understand? What is happening during national emergency? The center is becoming all powerful. The states are going into the complete control of the center, and therefore, during national emergency, the federal structure of the country gets converted into the unitary structure without a formal amendment of the constitution. And this type of political transformation, this type of transformation of a system of a country from federal during normal times to unitary during emergency provisions or emergency during difficult times is one of the unique features of Indian constitution. Did you understand? Did you get?
Yes, sir.
The transformation of the country from federal during normal times to unitary during emergency times is one of the unique features of Indian constitution. Don't forget. This is all about the effect of national emergency on the center-state executive relations. Only 2 points you need to remember. The center can give executive directions to the states on any matter. During normal times, on some specified matters. The second point, the states go into the complete control of center. Therefore, federal structure gets converted into unitary structure. Right. This is all about executive relations. Then what will happen to the legislative relations between center and states when national emergency is imposed? Very good. Good. What will happen when national emergency is imposed on legislative relations between center and states? Whenever national emergency is imposed, immediately Article 250 comes into operation. What is Article 250? During national emergency, the parliament can make laws on the state subjects. However, the states can also make laws on the state subjects. Parliament is making laws on the state subjects. The state legislatures are also making laws on the state subjects. Therefore, what we can say? Very good. The state list slowly gets converted, or the state list acts as the concurrent list. The state list will act as the concurrent list during national emergency. Okay? Yes, the state list will start acting as the concurrent list during national emergency because both the parliament and the state legislature are making laws on the state subject. And from this, what we can say? During national emergency, the parliament acquires the concurrent powers of lawmaking. Are you understanding? And the laws made by the parliament on the state subjects will remain in operation for how many months? Even after the revocation or withdrawal of national emergency, they will remain for 6 months. The laws made by the parliament will continue to remain in 6 months, even after the withdrawal or revocation of national emergency. Getting? Yes. And one more thing I want to say. During national emergency, can the president promulgate ordinances? Can the president promulgate ordinances? Who will promulgate ordinances on the state subjects?
Basically governor, sir, but in this situation, president.
Yes. During national emergency, the president can promulgate ordinances under Article 123 of the Constitution. Don't forget. But during normal times, who promulgate ordinances on the state subjects? Okay. During normal conditions, the governor promulgates ordinances on the state subjects under Article 213 of the Constitution. But during national emergency, the president can promulgate ordinance on the state subjects. Don't forget. So until now, how many did we discuss? Effects. One is legislative relations and second one is executive relations. Then the third is the impact of national emergency on the financial relations between center and states. Right? Anyone? What will happen to the financial relations between center and states? No, that is during financial emergency. What will happen to the financial relations between center and states? Rakesh, please tell me.
Grants will be
During national emergency, the president may modify the distribution of revenues between center and states. And this is not important. He will modify the revenue distribution arrangement between center and states. But what is important is the modifications which he has made will continue till the end of financial year. Are you getting? Suppose, let us consider our national emergency was imposed on 15th January. And the president made changes in the distribution of financial relations. And for that, he will introduce before the parliament whatever he made. Let us assume that the parliament approved the modifications in financial relations also. In that case, those modifications will also continue for not 6 months. They will continue till the end of financial year, in which the national emergency is going to be revoked. Suppose if I am changing the date for your convenience. Suppose let us consider the national emergency was imposed on 15th June. 15th June. Then according to you, again, let us consider the president has revoked the national emergency on 15th December. Just assume. 15th December, let us assume our president has revoked the national emergency. Then according to our assumption, the modifications which the president has made in the financial relations must end here. Yes or no? But they will not end here. They will end on 31st March next year. Why? Your financial year starts from 1st April and ends with 31st March of next year. Don't forget. Whatever modifications the president has made in the distribution of revenues between center and states, they will continue to remain in operation till the end of financial year, but they will not stop on the date on which the national emergency was revoked. Did you understand? Yes. Then any other effect which you know? Yes, grants can be reduced. The statutory grants from center to states can be reduced during national emergency. Other than that, what are the effects of national emergency on various aspects of the state? Other than legislative relations, executive relations, financial relations, other than this? Anyone? What happens with what are the other effects which you know? Effects of national emergency?
suspension of fundamental rights.
Very good. Suspension of fundamental rights. Good. Fundamental rights will get suspended. Morning itself I made you write. There are 3 articles related to national emergency. 352, 358, 359. 352 talks about the national emergency, the grounds of national emergency, the conditions of national emergency. 358 talks about the suspension of fundamental rights during emergency. Whenever national emergency is imposed on the grounds of war and external aggression only, then Article 19 gets suspended automatically. Whenever national emergency is imposed on the grounds of war, external aggression or armed rebellion, on any ground it might be, all the fundamental rights will get suspended, not automatically. They will get suspended by the separate presidential order. Did you understand? They will get suspended by separate presidential order. However, I would like to make you know that in case of Article 359, the president is suspending the enforceability of fundamental rights. The fundamental rights are available with you, but you cannot approach the Supreme Court under Article 32, and you cannot approach the High Courts under Article 226 for enforcement of your fundamental rights which have been suspended. Okay? Did you understand? Yes. Now there is one more effect. Please tell me, what is the effect of national emergency other than these which we have discussed? Anyone?
What if state doesn't comply?
President's rule? If states does not follow the executive directions given by center, immediately president's rule will be imposed. Do you know under which article? Very good, 365. Unions, centers, unions duty. I will tell you. Right. Please tell me one effect. I want to know from you. What is the other effect? See, I made you write the national emergency impact on legislative relations. I made you know. Executive relations, on fundamental rights, on the financial relations between center and states. Now, my question to you is, other than these, what are the other impacts of the national emergency? Anyone in this class? You can, if you know, you can see and tell me, but I want to know from you. How many effects does the national emergency have on various aspects of the state or Lok Sabha? You are saying something?
Houses of
Extension of
Very good, very good. Good, keep it up. Good, good. The effect of national emergency. There is one more effect of national emergency. That is the effect of national emergency on the life of the duration, life or duration of Lok Sabha and state legislative assemblies. Good, good. Which article deals with the extension of Lok Sabha's life during national emergency? Which article deals with the extension of the life of Lok Sabha during national emergency? Anyone? No. 83 clause 2. Article 83 clause 2 deals with the extension of the life of Lok Sabha during national emergency. Never forget, during national emergency, the life of Lok Sabha and the life of state legislative assembly can be extended by 1 year at a time. During national emergency, the life of Lok Sabha and state legislative assemblies can be extended by 1 year at a time for any number of times. For example, according to Article 83 clause 2, it provides for extension of, it empowers the parliament to extend the life of Lok Sabha by 1 year at a time for any number of times. Immediately, what will the parliament do? The parliament will enact a law, and that law will enable the parliament to extend its life for 1 more year. Like this, the 5th Lok Sabha's tenure was extended by 1 year at a time for 2 times. 5th Lok Sabha's tenure, 1971 to 1976 actual tenure. But the 5th Lok Sabha's tenure spanned from 5 years, 10 months, 6 days. The life of 5th Lok Sabha, was extended by 1 year at a time, and this was done for 2 times. Did you understand? However, even before the second time, national emergency got revoked and fresh elections were held, and Morarji Desai came to power in 1977. Article 83 clause 2, the extension of life of Lok Sabha. Article 172 clause 1, the extension of life of state legislative assemblies by 1 year at a time. Article 172 clause 1, the extension of life of state legislative assemblies by 1 year at a time. Never forget. However, you need to know, my dear friends, I told you that the life of Lok Sabha can be extended by 1 year at a time. The life of state legislative assemblies can be extended by 1 year at a time. But this extension cannot continue beyond a period of 6 months if the national emergency gets revoked. Whenever national emergency gets revoked, please remember one point: fresh elections have to be held within 6 months. Did you understand? Yes. Then If someone asks you what happens with the life of Rajya Sabha during national emergency, if someone asks you, what will you say? It does not get impacted. There is no effect of national emergency on the life or duration of Rajya Sabha. Don't forget this. Did you understand? This is all about the impact of national emergency on various aspects of the state. Now, what are the changes that were made, or what are the constitutional safeguards that were made by 44th Constitutional Amendment Act? Anyone from your side, can you tell me?
Introduce the word cabinet.
Okay, first word, they introduced the word cabinet. Good.
2 months to 1 month.
Excellent. Good. Second point, the term or the approval, the parliament need to approve national emergency by 2 months by simple majority before 44th Constitutional Amendment Act. After the 44th Constitutional Amendment Act, the parliament must approve national emergency within 1 month by special majority type 2. One change you told. Second change, one more. Second, see, these are constitutional safeguards. Please remember. The second important change was, before 44th Constitutional Amendment Act 1978, the president could impose national emergency only on the advice of Prime Minister. But after 44th Constitutional Amendment Act, the president can impose national emergency only on the written recommendation or written advice of the cabinet. Did you understand? Yes. More, I need more. Over. Very good. Before 44th Constitutional Amendment Act, the national emergency could continue for an indefinite period of time. Before 44th Constitutional Amendment Act. But the 44th Constitutional Amendment Act has allowed for extension of national emergency for an indefinite period of time. But the only condition is it must be approved by both the houses of parliament by special majority type 2 for every 6 months. This is the safeguard which was added to national emergency provisions. Other than these, please. Excellent. Before 44th Constitutional Amendment Act 1978, the three grounds were war, external aggression, and internal disturbance. After 44th Constitutional Amendment Act, what are the grounds? War, external aggression, armed rebellion. Don't forget. Yes, more? Earlier. Very good. Before 44th Constitutional Amendment Act, the Lok Sabha did not had any special powers to withdraw national emergency. But after 44th Constitutional Amendment Act, the Lok Sabha has been given special powers to withdraw national emergency. More, any other provisions which you know? Other than these? You told me five provisions you told.
The word cabinet also introduced.
That already we discussed.
Judiciary.
Good. Judicial review was not allowed before. Now national emergency is subjected to judicial review. Perfect. More. I need more. Please understand what you told are each and every point which you have said is right. But you should not forget about the fundamental rights. Before, when Article 358 comes into operation, Article 19 could be suspended on any grounds. Are you getting? Not only on the grounds of war, external aggression, it could be suspended even on the grounds of internal disturbance. However, before 44th Constitutional Amendment Act, under Article 359, not only your fundamental rights of all the fundamental rights were suspended before 44th Constitutional Amendment Act 1978, but after 44th Constitutional Amendment Act 1978, all the fundamental rights could be suspended except 20 and 21. Before 44th Constitutional Amendment Act, even Article 20 and 21 could also be suspended. Did you understand? These are 8 to 9 points which are considered to be the constitutional safeguards related to the national emergency. In mains, a number of times this question has been asked. Did you understand? However, it is also important for your prelims. Okay? Yes. Then, is there anything that we need to discuss regarding national emergency other than this? Yes. Now let us move towards President's rule. This diagram will help me again. See, the Constitution has provided for not only national emergency, it has also provided for second type of emergency known as President's Rule. However, the word emergency must not be used for President's Rule. And I would like to say that your President's Rule is also called as state emergency or constitutional emergency. Why is it called constitutional emergency? Because it is imposed on the condition that failure of constitutional machinery in a state. The main condition to impose President's Rule is failure of constitutional machinery in a state. Failure of constitutional machinery in a state is the precondition to impose President's Rule. Did you understand? Yes. Then, I told, as you are aware, President's Rule under Article 356 is the most controversial, most misused, and most misinterpreted article of the Indian Constitution. Actually, Dr. B.R. Ambedkar hoped that Article 356 should be used as a last resort and it must remain as a dead letter. But Article 356 is the most misused article of Indian Constitution. Till date, more than 134 times or else 125, more than 125 times the President's Rule was imposed in various states. And the first state where the President's Rule was imposed was the state of Punjab in 1951. And the President's Rule was imposed for maximum number of times. In which state? Manipur 11 times. Second is Uttar Pradesh 10 times. Third is Kerala 9 times. And your President's Rule is not yet imposed in which states? Telangana, Chhattisgarh, and newly formed Andhra Pradesh. Why it is not yet imposed? Because they are newly formed. Still, there is time for them to impose. Are you getting? If a state has more old history, it will have these type of incidents. These states are relatively new states. Telangana, Chhattisgarh, and new state of Andhra Pradesh, newly formed Andhra Pradesh. However, the President's Rule was imposed in the erstwhile Andhra Pradesh state for two times. One is in 1973. Second time was in 2014. Are you getting? Yes. Then, now let us come back. Or let me ask you one more question. Your President's Rule was imposed for maximum number of days in which states? Maximum number of times. I am not asking about maximum number of times. I am asking maximum number of period or maximum number of days. Punjab and Jammu and Kashmir. First is Jammu and Kashmir. Second is Punjab. Your President's Rule was imposed for minimum number of days in which state? Karnataka for 7 days. Good. All note points. Good. Your President's Rule was imposed for minimum number of days in Karnataka state, that is 7 days. Now, my dear friends, as I told you, this is the main condition for imposition of President's Rule under Article 356. Now, what are the cases under which the President's Rule can be imposed? This is the condition. As I told you, the condition to impose national emergency is there must be a threat to the security of India or any part of it. This is the condition to impose President's Rule. As we discussed just before, what are the grounds for imposition of national emergency? War, external aggression, armed rebellion. Then what are the grounds for imposition of President's Rule? In how many cases the President's Rule can be imposed? Huh?
Failure of constitution.
Okay, failure of constitutional machinery under Article 356. Okay, I will take it as, and see, now I am discussing with you the grounds or cases under which the President's Rule can be imposed. The first one is, as some of you have said, under Article 356, if there is failure of constitutional machinery in a state, one condition. That is, if the state's governments are not functioning as per the provisions of Constitution. If the state governments are not functioning as per the provisions of Constitution, the President's Rule can be imposed. Point number one. Go ahead. More. Article. Perfect. The second ground is Article 365. Good. If the state governments do not comply or follow, if the state governments do not follow or do not comply with the directions given by center, with the directions given by center. Even then, the president can impose president's rule under which article? Under Article 356 only. This is if state governments do not comply or follow the directions given by the center, then the president can impose president's rule under Article 356. Then the president can impose president's rule under Article 356. Again, it goes to here. You told me two conditions, my dear friends. By the way, please tell me what are these executive directions? Give me some examples of executive directions. Executive directions given by center. Just give me one or two examples of the executive directions which can be given by the center to the states under Article 365 of the Constitution. Very good. Protection of railways. The protection of means of communication. Very good. More instructions to be followed to provide education in mother tongue. All these are what? Executive directions. One is protection of railway property. Second one is maintenance of means of communication. Third one is facilities for instructions in mother tongue. All these are executive directions, and the center expects you to follow these directions, right? I am happy that you told me Article 356 and 365. My question to you is, why should the president impose president's rule? Who is asking him to impose president's rule? Okay, I accept governor. But which article of the Indian Constitution? According to which article of the Indian Constitution, the center is supposed to impose president's rule in a state? What is the obligation on the center? Who is saying 355?
355.
Very good. It is Article 355. Center's duty to protect the states. Perfect. Article 355. What is the title of Article 355? Union's duty to protect the states. Union's duty to protect the states. Yeah, we have one provision from external aggression and internal disturbance. Even today you have this word internal disturbance in Article 355. Don't forget, right? Union's duty to protect the states from external aggression and internal disturbance, and it is the union's duty to ensure that the state governments are functioning as per the provisions of Constitution. And if the state governments are not functioning as per the provisions of Constitution, if they are not functioning as per the provisions of Constitution, then the president can impose, are you getting? Then the president can impose president's rule under Article 356 if they are not functioning as per constitutional provisions. If state governments are not functioning as per the constitutional provisions, if state governments are not functioning as per constitutional provisions, then the president can impose president's rule under Article 356. Never forget, this is the union's duty to protect the states. Union's duty to protect the states from external aggression and internal disturbance. It is the union's duty to ensure that the state governments are functioning as per the provisions of Constitution. So, if they are not following, immediately under president's rule, he will impose president's rule under Article 356. Did you understand? Until now we have covered 3 articles: 355, 356, 365. But there is one more ground to impose president's rule. One more case.
No party has majority vote shares to form.
Good. Okay. Rather than that, there is one more important thing. What you told is right. If the state government follows, if the state government pursues anti-secular politics, if the state government pursues anti-secular politics, even then the president can impose president's rule. If there is hung assembly, if there is political crisis, if there is political deadlock after elections and no party is coming forward to form the government, even then the president can impose president's rule. These are the other conditions, my dear friends. Supreme Court has added, Supreme Court said that in SR Bommai versus Union of India case 1994, if the state government pursues or follows anti-secular politics, then the president can impose president's rule. Did you understand? You should not forget this. These are mentioned in these are mentioned in Constitution. Article 355 is mentioned in Constitution. 356 is mentioned in Constitution and 365 is also mentioned in Constitution. But what is not mentioned but added by Supreme Court was if state government pursues or follows anti-secular activities. If there is a hung assembly in case of political crisis or political deadlock after general elections, no other option. You can impose president's rule under Article 356 of the Constitution. Did you understand? Now, let us consider the president impose president's rule. Right? Let us consider the president imposed president's rule. Then what will happen? See, initially, I am talking about the fate of the state. I am not talking about the parliament. Or else let me complete this point. Once the president imposes president's rule, it must be approved by both the houses of parliament within 2 months. Suppose if this is president's rule, then the time within which the parliament must approve president's rule is 2 months. And the parliament must approve president's rule by which majority? Simple majority. And once the parliament approves president's rule, it will continue to remain in operation for 6 months. From which date? From the date of imposition of president's rule by the president, but not from the date of approval of president's rule by both the houses of parliament. Right? Never forget. If it is national emergency, it will remain in operation for 6 months from the date of approval of national emergency by both the houses of parliament. And if it is president's rule, it will remain in operation for 6 months from the date of imposition of president's rule by the president. Did you? Huh? Here already 2 months have been spent. There it was only 1 month. Are you getting? And already with respect to this president's rule has more impact on the states. Which impact? For example, how to impose president's rule? Who sends the report that there is a failure of constitutional machinery? Governor sends a report to the president. I mean to say to the Ministry of Home Affairs that there is failure of constitutional machinery in a state. And if the president is satisfied with the governor's report that there is a failure of constitutional machinery in that state, then immediately he can impose president's rule. And then the parliament must approve president's rule within 2 months. Now, what is the fate of state? What will happen to the state? We have 3 organs of the state normally: legislature, executive, and judiciary. Whenever national emergency is imposed, the first thing which will happen is your state executive is dismissed. What do you mean by state executive? State government, that is Council of Ministers headed by Chief Minister. Whenever president's rule is imposed, the state government will be dismissed immediately. Please use the term dismissed. Never use suspended or dissolved in case of state governments. Did you understand? The state government will be dismissed immediately. then what will happen with the state legislature? Yes. Initially, the state legislature will be kept in suspended animation, especially the state legislative assembly will be kept under suspended animation. The state legislative assembly will be kept under suspended animation, and once the parliament approves the president's rule, the state legislative assembly will be dissolved. After parliament's approval, the state legislative assembly will be dissolved. Now you might be thinking, what is the difference between suspended animation and dissolution? In this case, MLAs will remain as MLAs, but they cannot make laws. MLAs are MLAs, but they cannot make laws. In this case, the president can, in this case, the MLAs, the suspended MLAs can participate in the president's election here. Even in this case, the MLAs can participate in the president's election in this case. Okay, I will write, if you members are writing. Here, suspended MLAs or else let us write like this, MLAs of suspended state legislative assembly. This would be more better. MLAs of suspended state legislative assembly can participate in president's election. However, in this case, MLAs are no more MLAs. They are very much as you are, as I am. Are you getting? So when MLAs are no more MLAs, when they don't hold the membership of any state legislative assembly, how will they participate in president's election? Therefore, in this case, they do not participate. They don't participate in president's election. They have become former MLAs now. They don't participate in president's election if the state legislative assembly is dissolved. Did you understand? Yes. Here we have one more organ. This is the fate of state executive. This is the fate of state legislature. What will happen to this? What is the fate of state high court?
No change.
Or high court in a state, rather than writing like this? What will happen with high court in a state? How many of you think that the powers of state high court will reduce? Please raise your hands. How many of you think that the powers of high court will be assumed by the president? No? Then what will happen with the high court in a state? It remains as it is. Very good. Good. What is high court, my dear friends? High court is an independent organ. In the morning I made you write, legislature and executive are dependent on each other, but our judiciary is an independent organ. Point number one. Judiciary is not a part of state. State executive and state legislature are a part of state. Therefore, state government got dismissed. State executive got dismissed, and state legislative assembly is first suspended and later dissolved. But your high court, which is the judiciary, is not a part of the state. It is a part of an integrated judiciary functioning within the state. What do you mean by integrated judiciary? When we have Supreme Court at the top, and below the Supreme Court we have high courts, and below the high courts we have a hierarchy of subordinate courts. This is known as integrated judiciary. And integrated judiciary is an example of dash feature, unitary feature. Independence of judiciary is a federal feature. Never forget. I repeat, the state executive and state legislature got dismissed and dissolved because they are a part of state. The judiciary is not a part of state. It is an independent organ, point number 1. It is a part of integrated judiciary functioning within the state, point number 2. And the third point is, what is the main function of judiciary? To ensure the constitutional provisions, to ensure that the constitutional provisions are upheld. Why did the president impose president's rule? Because the state is not following as per the constitutional provisions. In that case, how will the president dissolve or dismiss or take away the powers of High Court? Are you understanding? That is the reason whenever president's rule is imposed, nothing will happen to the High Court. Okay? Judiciary will remain as it is. But other organs of the government, other organs of the state, like state executive gets dismissed and state legislative assembly will get suspended initially and later dissolved. This is all about what? President's rule. Did you understand? Now, please tell me the effects of president's rule. What do you know about the effects of president's rule? What will happen when the president's rule is imposed in a state? Anyone? Right. Please tell me what will happen when the state government, when the president's rule is imposed in a state. Okay. Bills will be passed by whom? Okay. Under Article 356, as you are aware, okay, the Parliament has exclusive powers to make laws. Why Parliament has exclusive powers to make laws? State Legislative Assembly is not there. It is dissolved. Then who should make laws for the state? Parliament. Who should enact the state budgets? Parliament. Are you getting? Who should spend the money out of the consolidated fund of states? President. Are you getting? Now, whenever the president's rule is imposed, the president can assume in himself, the president can take away or assume in himself any functions of the state government or all functions of the state government, point number 1. He can take away he can take to himself all the functions of state government. Whenever president's rule is imposed, the president can also take away the powers of the governor as well as other constitutional officers of a state. Other executive authorities of a state. Whenever president's rule is imposed, the president can take into himself, can assume all the powers of the state government. Whatever powers the state government has, all those powers will lie with whom? President. And not only that, he can also take up all the powers of the governor or any powers of the governor or any other executive authority in a state. Okay? Second point. If there is no state government, who should administer the state? If there is no state government, who should administer the state? So, the second impact is, whenever the president's rule is imposed, the state government gets dismissed immediately, as I wrote here. So when president's rule is imposed, if the state government is dismissed immediately, who should administer the state? Okay. Do you want to answer? Who will administer the state? Anyone in this class? Huh? No? Whenever president's rule is imposed, who will administer the state? If someone asks you, please tell them. Governor. Please listen to me. Yes, Chief Secretary, yes. Whenever the president's rule is imposed in a state, the state will be administered by the governor on behalf of the president. President cannot come here, no, to administer. That is the reason the governor will administer the state on behalf of the president with the help of Chief Secretary of the state, with the help of advisors appointed by the president, with the help of other important officers like DGP and some other officers. However, you should not forget to mention two names. The president, whenever the president's rule is imposed, the state administration will be carried on by the governor on behalf of the president with the help of Chief Secretary of the state and advisors appointed by the president. Did you understand? Yes. Okay? Yes. And therefore, as the state is being administered by the governor on behalf of the president, Whenever emergency is imposed on the grounds of Article 356, we call that emergency as President's rule. Now you came to know why it is known as President's rule in a state? Because the state administration is being carried on by the governor on behalf of the president. Whatever the president says, the governor will do that. That is the reason the emergency or any, you should not use emergency actually for Article 356. Therefore, the rule during emergency imposed under Article 356 is known as President's rule. Did you understand? Yes. Then what is the fate of state legislative assembly? Third point, I mean to say third effect. Whenever the President's rule is imposed, initially the state legislative assembly will be suspended and later on dissolved. Who said this? Yes, once the parliament approves the President's rule, it will be dissolved. Who said this? That initially the state legislative assembly should not be dissolved immediately. The Supreme Court in SR Bommai case has said the same thing. Whenever the President's rule is imposed, the imposition of President's rule and the dissolution of the state legislative assembly should not happen together. Are you understanding? Initially, the state legislative assembly should be suspended, and once the parliament approves the President's rule, only then the state legislative assembly must be dissolved. And even the Sarkaria Commission's recommendations of 1987, they also mentioned the same. The state legislative assembly should be kept in suspended animation. This word was mentioned there, suspended animation. And later on, when the parliament approves PR, President's rule, only then it must be dissolved. Did you understand, my dear friends? Now, as the state legislative assembly is dissolved, now comes the question, who should make laws for the state? Then the parliament will make laws for the state under Article 357 of the Constitution. The parliament will make laws for the state under Article 357 of the Constitution, and the parliament has exclusive powers to make laws under Article 300 when President's rule is imposed under Article 356. Okay, the parliament has powers to make laws under Article 357. Never forget. Okay, yes. And whenever President's rule is imposed, if the state legislative assembly gets dissolved, as you know, fresh elections have to be held within 6 months. Okay, that is common, right? And see, until when the laws made by the parliament will remain in force on the state subjects. This is important, no? In case of national emergency, I told you, the laws made by the parliament, yes, you remained about 3 years. I'll make you know that point. Yes, no, please listen to me carefully. In case of national emergency, we discussed that the laws made by the parliament will continue to remain for 6 months, even after the revocation of national emergency. What is the case with President's rule? Let us consider the President's rule was revoked on 1st January. Revoked on 1st January. In that case, the laws made by the parliament will remain in operation for how much time, I am asking?
Until the state will,
Very good. That 6 months, 1 year, 8 months, 2 months, this time is not mentioned in the Constitution. Until the state legislative assembly either modifies it or alters it or abolishes it, until then that law will remain in force. Did you understand? Huh? Election should be held within 6 months from the date of dissolution of state legislative assembly. Are you getting? When state elections will take place, new government will form. Now it is up to the new government whether to keep that law or whether to make any changes in that law. Are you getting? Yes. Okay, friend? Now, who will enact budgets for the states during President's rule? The parliament will enact budgets for the state. Who will empower the parliament to do that? The president will empower the parliament to do or to perform all the functions that are performed by the state legislatures or state legislative assembly. On the contrary, the parliament will empower the president to take money out of the consolidated fund of states. Otherwise, how will the state government employees survive? They also need to be given some amount, and there must be one person who takes money out of the consolidated fund of states. Okay, the president will take money out of the consolidated fund of states, right? And this point already I told you about. See, whenever president's rule is imposed, the president can assume in himself all the powers of the state executive and state legislature, but not the powers of judiciary, state high court. Never forget, right? And as one of our friends have told, I forgot to tell you this point. For how much time the president's rule can continue to remain in operation? Please listen to me carefully. Whenever the president's rule is imposed, the president's rule will continue for 6 months if it is approved by both houses of parliament. Suppose if president's rule has to be continued for another 6 months, then a resolution extending president's rule must be approved by both houses of parliament by simple majority. Now, what is the condition to continue president's rule beyond 1 year? If you want to continue president's rule beyond 1 year, there are two conditions, and either any one condition should be met to extend the president's rule beyond 1 year. What are those two conditions? Do you know? Election Commission of India must certify that to conduct elections in that state, it is not possible with me. So Election Commission of India must certify that it is impossible to conduct elections in that state where the president's rule is imposed. This is condition number 1. If the Election Commission of India certifies that it is impossible to conduct elections in that state, then the president's rule can be imposed. Again, the second condition is if there is national emergency in operation throughout India or in any part of it. If there is national emergency in operation throughout India or in any part of it, even then the president's rule can continue beyond 1 year. However, the maximum time for which the national emergency can be in operation is 3 years. 3 years. Never forget. Huh?
Maximum time president rule.
Yes, Amma, yes. The maximum time for which president's rule can be in operation is 3 years. But the maximum time for which national emergency can be in operation is indefinite period of time. Don't forget, my dear friends. However, can you continue president's rule beyond 3 years? Anyone? Can you continue president's rule beyond 3 years? What is the requirement if you want to continue the president's rule beyond 3 years? For your kind information, let me inform. The president's rule was imposed in the states of Jammu and Kashmir and Punjab for more than 5 years. President's rule was imposed in Jammu and Kashmir and Punjab. In these two states, the president's rule continued for more than 5 years. But I am telling you, the maximum time for which the president's rule can be in operation is 3 years. Then to extend president's rule beyond 3 years, what is required? Very good. A constitutional amendment act is required. Excellent. Did you understand? If you amend the constitution, then the president's rule can continue beyond 3 years. Okay? Yes. Then I need not again discuss with you the differences between national emergency and president's rule. You are very much aware. Yes. Then what about financial emergency, my dear friends? Not yet imposed. Then what is the condition, main condition to impose financial emergency?
It should be a threat to the check of CFI.
Financial crisis,
What is the condition? First comes the condition.
financial instability in the state.
Okay. More than 60 days?
Survival.
See, financial emergency can be imposed by the president under Article 360 if one condition is met, and that condition is if the president is satisfied that there is a threat. Again, I am using this word. If the president is satisfied that there is a threat to the financial stability of India or credit of India. If there is a threat to the financial stability of India or credit of India, then the president can impose financial emergency immediately. And once the financial emergency is imposed, the parliament must approve the financial emergency within 2 months by simple majority. And once the parliament approves the financial emergency, it will continue to remain in operation for an indefinite period of time. For your kind information, let me tell you, approval of parliament for every 6 months is not required in case of financial emergency. Did you understand? Approval of parliament for every 6 months is not required in case of financial emergency. Once it is approved by both the houses of parliament, it continues to remain in operation for an indefinite period of time till it is revoked by the president. Did you understand? Yes. Then what are the effects of financial emergency? Yes. Whenever financial emergency is imposed, again the revenue distribution arrangement between center and states comes to an end. Ceases to exist. Cease to exist means what? Comes to an end. Point number 1. Whenever financial emergency is imposed, the salary and allowances of the Supreme Court judges, the High Court judges, the persons serving in the union government, the persons serving in the state government will get reduced. However, even during financial emergency, the salary and allowance of the president cannot be reduced. Never forget. Even during financial emergency, the salary and allowance of the president cannot be reduced. Okay? And in India, we have not yet imposed the financial emergency even when we faced the 1991 economic crisis. Did you understand? Yes. This is all about financial emergency. Okay? Okay, friends. Now after this, let me start part 5 of the Indian Constitution. What is part 5? The Union. Yes or no? Part 5 is the Union. And from Article 62 to Article 52 to Article 78, it is the Union Executive. Then who are a part of Union Executive? The President, the Vice President, the Council of Ministers, the Attorney General of India, and CAG. Okay? Yes. What happened? Right. The next topic which I am going to discuss with you is the Union. The Union is dealt from Article 52 to 151. Article 52 to Article 151 in Part 5 of the Constitution deals with the Union. Article 52 to 151 in Part 5 of the Constitution deals with the Union, and in this, the Union Executive is from Article 52 to Article 78. And in this Union Executive, the most important executive is the President, the Vice President, the Council of Ministers, the Attorney General of India in this here. Okay, right. Yes, CAG is also there, but I have taken from Article 52 to Article 78. Right. The important executive which we must discuss is the President of India. And Union Executive can be divided into two types, just for your kind information. One is the political executive and another is the apolitical executive. Political executive and apolitical executive. Political executive and apolitical executive. Who are a part of political executive? President, Vice President, Council of Ministers, Cabinet. Here I am including Cabinet also. Cabinet, Attorney General of India. They are a part of, and CAG. CAG is also a part of political executive. Political executive is also known as temporary executive. And your apolitical executive is also known as permanent executive. Permanent executive. Right? And first, let me make you write who are political executive. First one is president. Second, vice president. Third one, council of ministers. Fourth, I am writing cabinet because this is also an important part of executive. Fifth one, attorney general of India. Sixth one, CAG. Here are we missing anything? Prime minister. Yes, I was seeing for this. After this one, please write down. After vice president, most important executive is the prime minister. Fourth one, council of ministers. Fifth one, cabinet. Sixth one, attorney general of India. And leaving this attorney general of India, I can also consider him as temporary executive because when the government changes, automatically the attorney general of India will also change. Right? Then, why should I call these executives as temporary executives? Because they are elected. If you see, most of these executives are elected. And is there any guarantee that these executives will be appointed again, will be elected again after 5 years? No, as there is no guarantee that the same executives will come to power after 5 years. We cannot ensure that they will remain in office even beyond 5 years. They will come to power again after 5 years in next elections. That is the reason we call these executives as temporary executives. Then who are these permanent executives? Why should I call these bureaucrats and civil servants as permanent executive?
All civil servants are bureaucrats, but all bureaucrats are not civil servants.
They are not elected.
Because, see, why they are permanent? Okay, no problem. What is there? Right. They are called permanent executives because once they clear this examination conducted by UPSC, once they clear the examination, if they clear the examination at early stage, they will remain in operation. They will continue to serve the government of India for the next 30 to 35 years of age until they attain either 62 years or 65 years of age. It depends on the post which they are holding. Are you getting? Why I wrote permanent executive? They serve government of India after clearing examination. These are selected. They are elected. These people are elected. These are selected after clearing examination. They serve government of India for 30 to 35 years of age. Based on how much early they enter into this service. Are you getting? That is the reason I call them as permanent executives. Okay? Yes. And all bureaucrats, all civil servants are bureaucrats, but all bureaucrats are not civil servants. Why all bureaucrats are not civil servants? Huh? See, bureaucracy not only includes the civil servants, they also includes other officers who are working in public sector undertakings and other government institutions. Are you getting? Yes. Right. About president, please tell me, what do you know about president? Which articles of the Indian Constitution talks about the president of India? Article 52 to 62, Article 71, Article 72, Article 78. 78 talks about prime minister and president relationship. 52 to 62, 71, 72, 74, 75. Please write down if you know. If you know, then you need not write. Right? Article 52 to 62, 71, 72, 74, 75, 77, 78, Article 111, Article 123, and so on. All these articles deals with in part 5. Don't forget to write in part 5. in part 5 deals with the office of president, especially these. Especially if you want to write exclusively with president, 52 to 62. Deals with the office of president. Okay, what is the presidency? We have a parliamentary system, and I told you the one best feature of parliamentary system is the existence of dual executive, the presence of dual executive. Dual executive, why there should be dual executive in parliamentary system? This is the requirement of parliamentary system. Feature, that is one of the feature of parliamentary system. There will be de facto executive, there will be de jure executive. There will be nominal executive, there will be real executive. Our president is the nominal executive, de jure executive, titular executive. He is the constitutional head of the Indian state. He is the executive head of the Indian state. Are you getting? He is the ceremonial head. He is the supreme commander of armed forces. Okay, which article says that the president shall be the supreme commander of armed forces? I already made you write in the morning, friends. Which article says that the president shall be the supreme commander of armed forces? Which clause? 53 clause 2. Never forget, okay? According to article 53 clause 2, the president shall be the supreme commander of armed forces. Never forget. And he is the first citizen of India. He occupies the first place in the table of presidents. Okay? And thereafter, as you are aware, the president is an integral part of the parliament. Which article deals with the parliament? 79. According to article 79, the parliament shall consist of, the constitution of parliament is Lok Sabha, lower house, upper house, and the president of India. Why should the president be an integral part of the parliament? Okay. Why should the president be an integral part of parliament? Anyone? Yes. Without the president's assent, the bills will not become enacts. Point number 1. Second point, he summons or prorogues both the houses of parliament. Point number 2. Third one, he dissolves the Lok Sabha on the advice of Prime Minister. Fourth point, he summons a joint sitting of both the houses of parliament in case of deadlock between two houses. And next one, he addresses the parliament in the first session after each general elections. He addresses the parliament first session of each year. Financial year. Yes. Next one, he nominates 12 members to Rajya Sabha. There are these many reasons for which we call the president as an integral part of parliament. Are you getting? Next one. And moreover, his prior recommendation is needed to introduce certain types of bills. Which types of bills? Money bills, very good. No, not constitutional amendment text. Very good. A bills under Article 3 of the Indian Constitution. Okay? A bills under Article 3 of Indian Constitution, money bills and bills which require expenditure from Consolidated Fund of India. They require the prior recommendation of the President of India. Don't forget. And thereafter, if you want to know more about the President, why President is called executive head of Indian states? Or why President is known as the executive head of Indian state? All the executive functions are exercised in the name of President. Which article says that all the executive powers shall be exercised in the name of President? Which article, please? Article 53. Article 53 says all the executive powers of the Union shall be exercised in the name of President. And not only that, all the laws of Parliament are implemented in whose name? President's name. Now, can I call the President as the legislative head of Indian state? When the President is called the executive head of Indian state, can I call the President as the legislative head of Indian state? No. Why? The President is not the legislative head of Indian state because the laws are not made in his name. The President is called executive head of Indian state because the laws are implemented or executed in his name. Are you understanding? Yes. Then, what is Article 52? Let us go by article by article. What is Article 52? There shall be the President of India. So whenever the word shall comes, I told you just before, then that office must remain compulsory. It must not lie vacant. Are you getting? Article 52 says there shall be the President of India. The word shall indicates that this office must continue to exist and there must be no vacancy or this office cannot be abolished. Did you understand? Yes. Then what is Article 53? All the executive powers of the union shall lie with the President of India. This is Article 53 of the Constitution. What is 54 of the Constitution? Article 54. It deals with what? The election of the President. Okay? And may I please know how the President is elected?
Electoral college.
Right? The President is elected indirectly by an electoral college, by PRSTV system, proportional representation by means of single transferable vote system. And what is an electoral college? Yes, please tell me about electoral college. It consists of all the elected MPs of both the houses of parliament. It consists of the elected MLAs of all the state legislative assemblies. It consists of the elected MLAs of the union territories of Delhi, Puducherry, Jammu and Kashmir. My question to you is, from when did the union territories of Puducherry, Delhi, Jammu and Kashmir start participating in the president's election? Huh? From when did the union territories of Delhi, Jammu and Kashmir and Puducherry started participating in the president's election? For some time, please keep Jammu and Kashmir aside because Jammu and Kashmir was formed in 2019. Please tell me, huh? No? Who is saying 1992? Very good. Yes, good. The union territories of, I mean to say the MLAs of the legislative assemblies of the union territories of Delhi and Puducherry started participating in the president's election from 70th Constitutional Amendment Act 1992. Don't forget. 70th Constitutional Amendment Act 1992. But do you think 70th Constitutional Amendment Act has empowered or allowed the MLAs of the union territories to participate in the president's election? But do you think they started participating from 1992 onwards? From when did they participate? Please understand, by the time this 70th Constitutional Amendment Act came into force, it was 1995. But in 1995, president's elections were not held. The president's elections were held in 1997. Therefore, the members of the legislative assemblies of Delhi and Puducherry started participating for first time in the president's election from 1997 onwards. Did you understand? They started participating in the president's election from 1997 onwards. Don't forget, my dear friends, 1997. However, the Constitutional Amendment Act which allowed for their participation was 70th Constitutional Amendment Act 1992. Right? Yes. And one more thing, no one is telling me this point. You are telling only elected MPs of both houses, elected MLAs of state legislative assemblies, elected MLAs of union territories of Delhi, Puducherry, Jammu and Kashmir. You should say one more point there. The suspended MLAs or the MLAs of the suspended state legislative assembly during president's rule. I know this point will not be there in your books. Please write down. The MLAs of the elected MLAs. Please write down the elected MLAs of the suspended state legislative assembly. The elected MLAs of the suspended state legislative assembly during the president's election. The elected MLAs of the suspended state legislative assembly during the president's rule in a state, they also participate. However, the MLAs of dissolved state legislative assembly don't participate. I will make you right. Then, who does not participate in the president's election? Wait, one by one. Rakesh, please tell me who does not participate? Nominated? Nominated members of Rajya Sabha? No, okay. Only nominated MLCs? Okay. Both elected and nominated MLCs. Wow, perfect. 2. Nominated see here. Tomorrow, if you get this point, you will get confused, my dear friends. First tell me, what is the composition of Puducherry State Legislative Assembly? Puducherry State Legislative Assembly. Suppose if UPSC gives this statement, the members of all the members of Puducherry State Legislative Assembly participate in the president's election. If UPSC gives this statement, is it correct or wrong?
No, sir.
Answer is no. The Puducherry Legislative Assembly consists of 3 nominated members. There are 33 members in the Puducherry State Legislative Assembly. Out of 33 members, 30 members are elected MLAs and 3 members are nominated MLAs in Puducherry. So tomorrow if you get this statement, all the members of Puducherry State Legislative Assembly participate in the president's election, then it is wrong. Point number 1. Then if you get this statement, all the members of Jammu and Kashmir State Legislative Assembly participate in the president's election, again you are wrong. Why? In Jammu and Kashmir State Legislative Assembly we have 95 members, in which 90 are elected and 5 are nominated. And suppose if you get this statement, all the members of Delhi Legislative Assembly participate in the president's election, what would be your answer? In Delhi we don't have nominated members. Please tell me yes or no about Delhi. See, about Puducherry and about Jammu and Kashmir. Then what about Delhi? In Delhi, we don't have nominated MLAs. So if you get this statement, all the members of Delhi Legislative Assembly participate in the president's election, then all members are elected MLAs. And in Delhi, we have 70 MLAs and all are elected. Don't forget. Did you understand? Yes. There you write down who does not participate in the president's election. Nominated MPs of Rajya Sabha. Point number 1. Elected and nominated MLCs of, elected and nominated members of state legislative councils, that is MLCs. Next, nominated MLAs of the union territories of Puducherry and Jammu and Kashmir. Please write down. Nominated members, nominated MLAs of the union territories of Puducherry and Jammu and Kashmir. Puducherry and Jammu and Kashmir. In just behind that Puducherry, please write down. 30 are elected and 3 are nominated. Total membership of Puducherry State Legislative Assembly is 33, in which 30 are elected, 3 are nominated. Nominated by whom? President. President, good. And in case of Jammu and Kashmir, these 95 we have, 90 are elected and 5 are nominated. Who nominates the members to the Jammu and Kashmir State Legislative Assembly? Lieutenant Governor, please understand. In case of Puducherry, it is President. In case of Jammu and Kashmir, it is LG, Lieutenant Governor. Please understand. Right? There you write down one note point. Delhi Union Territory, the Union Territory of Delhi does not have nominated MLAs. The Union Territory of Delhi does not have nominated MLAs. All the 70 MLAs of the Union Territory of Delhi are elected MLAs. Okay? Right. Delhi does not have elected MLAs. Next one. Elected MLAs, last point, if someone is writing. Elected MLAs of the dissolved State Legislative Assembly during President's rule. They don't participate in the President's election. Elected MLAs of the dissolved State Legislative Assembly during the President's rule. Right? Then, we completed 54 election of President. 55 deals with what? The manner of election of President. Manner of election of President. That is, the President shall be elected by which method? PRSTV method. And voting is done by secret ballot. Never forget, voting is done by secret ballot. Then the voting of Vice President is done by dash secret ballot. And secret ballot applications are, other than these, what are the other applications of secret ballot? Very good. To elect MPs, to elect MLAs, we do secret ballot. We vote by means of secret ballot only, no? Okay, don't forget. Next one. And as I told you, why should the MLAs participate in President's election? Why should the MLCs not participate in President's election?
All the states.
He's the head of the state. Head of the state.
Head of the Indian state. Good. Then why should the MLCs not participate in President's election?
All the states.
Perfect. Very good. See, the MLAs are allowed to participate in the president's election because the president represents not only the center, he also represents the states. And equal representation of states and center should be there to uphold the spirit of federalism in India. And president being the head of the Indian state, it is his responsibility to ensure that both center and states are represented in his president's election. Are you getting? Right. And MLCs don't participate in president's election because out of 28 states in India, only 6 states have state legislative councils. So if you give this weightage to 6 states, then we are giving preference to these 6 states over other states. Never forget, right? Next one, if we take one state, then the value of vote of one MLA in one state will be equal to that of another MLA in the same state? In the same state. In the same state. In the same state it is yes. The value of, for example, if we all are members of MLAs of State Legislative Assembly of Telangana, we all, let us consider, my value of vote will be equal to your vote. Suppose we are members of Telangana State Legislative Assembly and they are Andhra. Now, the value of vote of our, the value of vote of our value of vote in Telangana will not be equal to that of Andhra. Why? Because there is difference of population. Don't forget, right? Then suppose we all belong to we all are MPs. In case of MPs, the value of vote of MPs will be same for all the MPs irrespective of the state to which he belongs. Are you getting? And the value of vote of Lok Sabha, MP of Lok Sabha will be equal to that of value of vote of Rajya Sabha. However, if we sum up the value of vote of Lok Sabha MPs, then it will be more than the value of vote of Rajya Sabha MPs. Don't forget. And the value of vote of MPs will be equal to that of the sum of the value of vote of all the MLAs of all the states combined. Never forget. Did you understand? The value of vote of all MPs, 543 plus 245 in Rajya Sabha. This number will be equal to value of vote of all MPs will be equal to the value of votes of MLAs of all the states in this country combined. Did you understand? Yes. Right. Which article did we discuss until now? Article 55. Then what is Article 56? Is it only term of the president? In your Lakshmikant it is written term. It does not mean that your Article 56 consists only term. Article 56 talks about the term, resignation and removal of the President of India. This is the title of your Article 56. Term, resignation and removal of the Vice President of India. Then what is the term of the President? The President shall hold office for a term of 5 years. Understood? Next one, the President, while coming to resignation, the President can resign by submitting his resignation letter to Vice President of India. And while coming to removal of President of India, the President can remove, yes, very good. The President can be removed even before the completion of his term of 5 years by the process of impeachment. However, the procedure for impeachment is mentioned in Article 61, but the ground for impeachment, that is violation of the Constitution, this is mentioned in 56, Article 56. Never forget. The ground for violation, the ground for impeachment of President, that is violation of the Constitution, this ground is mentioned in Article 56, but the procedure of impeachment is mentioned in Article 61. Never forget. Now, what is Article 56 again? Please tell me. Term, resignation and removal of President. Then what is Article 57? Very good. Article 57 talks about the re-election of President. Okay. Now please tell me, in case of America, the President can be elected for how many terms? Maximum of 2 terms. If first term is 4 years, and then if he gets elected again, he can remain in office for another 4 years. So the maximum term for which the US President can remain in office is 8 years. What is the case with Indian President? He can get elected as the President of India for any number of times. Okay, he can act as the President of India. He can get re-elected as the President of India for any number of times. This is mentioned in which article? Article 57 of the Indian Constitution. Can you name me the president who was elected twice? Dr. Rajendra Prasad was the only president of India who was elected twice. His first term was from 1950 to 1957 and second term was from 1957 to 1962. Did you understand? Yes. And see, US president can be re-elected as for only 2 terms. This is mentioned in which amendment of the Constitution? US Constitution. 22nd Amendment of the US Constitution. 22nd Amendment. You told me first. It is 22nd Amendment of the US Constitution says the president of USA can be re-elected for only can act as a president for only 2 terms. Okay, don't forget, right? Next one. See, I discussed with you 52, discussed with you 53, 54, 55, 56, 57. What is 58 of the Indian Constitution? 58 of the Article 58 of the Indian Constitution deals with the qualifications to become or qualifications for election as the President of India. You know very well. The basic qualification is he must be a citizen of India. Now, can a citizen by birth only become the President of India, or a citizen by naturalization, or a citizen by registration also can become? Okay, that please check once. If you become citizen by any way, naturalization is correct answer. A citizen, if you are a citizen of India, then you can become the President of India. On the other hand, if you take the American president, only a citizen by birth can become the American president. A citizen by naturalization cannot become the American president. Don't forget. Okay, right. And thereafter, what is the age that President of India must have completed? 35 years of age. The President of India, in order to be a person to get elected, in order to qualify for election as the president, he must have completed 35 years of age. And he must be qualified for election as a member of Lok Sabha. And if it is vice president, it is Rajya Sabha, right? And he should not hold any office of profit. Now, what is office of profit? The office which brings some gains. Okay, right. Then who is considered to be not holding an office of profit? Who is considered to be not holding an office of profit? President, sitting president, vice president, governor, union ministers, chief minister, state ministers. All these offices are considered to be offices of, not the offices of profit. Therefore, they can become the President of India. Can the Attorney General of India become the President of India? No. Attorney General of India's office is a office of profit. Therefore, Attorney General of India cannot become the President of India. Huh? Resign just. Okay, right. Then what are the other qualifications to become President of India? Until now, what you have told are the qualifications that are mentioned in the Constitution. Then what are other qualifications which the President of India must have, a person must have to become to be eligible for election as president?
Not be a member of either of the house.
Okay, good. He should not be a member of either of the house. He should be supported by 50 electors, and he should be proposed by 50 electors, and he should be supported by 50 electors. Good. And this is mentioned in which act? This is mentioned in which act? Is it Representation of People's Act?
Election code.
No, I am asking from my side. Or is it the Presidential and Vice Presidential Elections Act 1952? Are you understanding? The Presidential and Vice Presidential Elections Act 1952 says if the nomination of a person who is going to contest the election of president must be subscribed by 50 electors as proposers and 50 electors as seconders. So we have so many members in the Electoral College. We have elected MLAs, we have elected MPs. Out of that, if 50 members support the president and if 50 members give additional support to the president, totally 100, then that person's name can appear on the ballot paper of the president's election. What happened, Amma? Did you understand? 50 members as proposers, 50 electors as seconders. Don't forget, right? Next one, see, and there is one more additional qualification. It is not qualification. 15,000 rupees must be deposited in RBI. And if he gets less than 6% of votes, then that amount will get forfeited. Right. Good. You are very much aware. Actually, you don't need any classes if you ask me. Right. Okay. Right, my dear friends, we completed Article 58. Then what is Article 59? Conditions of President's office. 59 talks about the conditions of President's office. Please tell me about, you told me something, no? He should not be a member of any house of the parliament, or he should not be a member of state legislative assembly, and he should not hold any office of profit. And the condition is, once a person gets elected as the president, he is entitled to use, he can use Rashtrapati Bhavan, Lok Bhavan as without any payment of rent. Okay, did you understand? Yes. Then the emoluments, allowances and privileges of president shall be determined by whom? Shall be determined by, yes. Shall be determined by parliament. No, Schedule 2 until this act is enacted. Okay. Now when the act came, it will be, now once the parliament starts enacting a law, it will be looked after by that. Right? Please understand, the emoluments, allowances and privileges of the president shall be determined by the laws of parliament. And accordingly, the parliament has enacted the President Emoluments and Pensions Act 1951. Is it there in your books? There? Yes. The President Emoluments and Pensions Act 1951. And recently, in 2018, the president's salary was increased to how much? What is the present amount the president receives as salary? 5 lakh rupees. And this was done by which act? The Finance Act. The Finance Act 2018. Okay? Yes. Now, what is the pension which he can receive? 50%, right? Okay. Now, see, the president enjoys some privileges and immunities. What are those? What are the privileges and immunities that the president enjoys? No, the criminal proceedings cannot be initiated against the president. Can he be arrested? He cannot be arrested or imprisoned. Okay. And can he be, for example, can a civil proceedings be started against the president? Yes. Yes. Civil proceedings can be started against the president after giving a prior notice of 2 months, not 14 days. 2 months. Okay. And on an overall note, what you have to understand about president? President is immune from criminal proceedings, but president is not immune from civil proceedings. Why? By giving a prior notice of 2 months, you can initiate civil proceedings against the President of India for his official acts, right? Good. Next is Article 60 of Indian Constitution. What is Article 60 of Indian Constitution? Oath or affirmation. Oath or affirmation by the President. Who administers the oath to the President of India? Chief Justice of India administers oath. And in the absence of Chief Justice of India, who administers the oath? Senior most judge of the Supreme Court. Very good. And what is written in his oath? I need not read. You will also, that questions will not come. Right? Now, next is, what is Article 61? Impeachment of the President of India. Yes, wait for 1 minute. Right. Impeachment of President of India. May I please know on what grounds the president can be impeached? And which article talks about the impeachment of president? Article 61 talks about the impeachment of president. And then what are the grounds for impeachment? Violation of Constitution. The phrase violation of Constitution is mentioned in Article 56, but is it defined? The phrase violation of Constitution is not defined in the Constitution, but mentioned in the Constitution. And mentioned in which article? Article 56 of the Indian Constitution. Now, did the Constitution describe which acts of President would lead to violation of Constitution? The constitution did not describe that also. Which acts of president will lead to violation of constitution? The constitution did not describe the violation of did not describe what does the word violation of constitution means. The constitution also did not describe which acts would lead to violation of constitution, right? And thereafter, what is the procedure for impeachment of president? You know very well. Please tell me, what is the procedure? Yes. Okay. Okay. Good. Okay. Then a committee. Which committee? It's not committee. See. No. Why Rajya Sabha? Second house will act as an investigating house. Please let me tell you. The impeachment of president, please listen to me carefully. The impeachment process can be initiated in any house of parliament. In any house of parliament, it might be, you can initiate the process of impeachment, point number 1. And once the impeachment process starts there, but before starting that, in order to get a resolution adopted there, the impeachment resolution must be signed by 1/4 of the members of that house. If it is Lok Sabha, 1/4 of the total members of Lok Sabha must sign that. If it is Rajya Sabha, 1/4 of the total members of Rajya Sabha. And once the impeachment resolution is accepted in the first house, then the president will be given a 14 days prior notice. Are you getting? Before the impeachment resolution is discussed in the first house. Before the impeachment resolution is discussed, the president will be given a prior notice of 14 days. And once the impeachment resolution is discussed in the first house, it will be passed by which majority of the house? Special majority type 4 of the house. Then what is special majority type 4 of the house? 2/3 of members, total membership of the house. Right, very good. Now, my dear friends, once the first house passes the impeachment resolution by special majority type 4, it is sent to the second house. Okay, what is the action of the first house called? Action of the first house called. I am not discussing with you the action of the second house. What is the action of the first house called? The action of the first house is known as political action only. Are you getting? Now, once the impeachment resolution is approved or passed in the first house, it is sent to the second house. Now the second house will start acting as an investigating house. Now the president will have an opportunity to defend himself either by representing himself or through a lawyer. The second house can start investigating against the house by investigating the charges, by forming against the president through an investigating officer. The second house can also ask the CBI to investigate the charges against the president. Are you getting? And the president has the right to defend in which house? In the second house. He can either defend by himself or through a lawyer. And moreover, in the second house investigation also, if the president is found guilty, then what will happen? Then in the second house also, if the president is found guilty, then the impeachment resolution will be passed by special majority type 4. And once both the houses of parliament passes the impeachment resolution by special majority type 4, the president stands impeached. Why the president stands impeached? There is no other executive to remove the president or to sign on the removal order of the president. But in case of others removal process, it is known as removal only. Why? Even after the passage by both the houses of parliament, the president signs it. But here, who is there to sign the removal order of the president? No one. Once the impeachment resolution is approved by both the houses of parliament by special majority type 4, the president stands impeached. Therefore, as the president is being removed by both the houses of parliament, this action is known as impeachment, as the president is being removed by the legislature only. Did you understand? Never forget. Now, there are some extra points which I want to discuss with you. The impeachment process is a quasi-judicial process. Okay, impeachment process is a quasi-judicial process. The action of the second house is considered as quasi-judicial action. Quasi-judicial action. Okay, yes, and the action of the first house is seen as political action. Why? Charges against the president have been leveled in the first house. It is the first house which passed the impeachment resolution initially. So the action of the first house is seen as political action. The action of the second house is quasi-judicial in nature. Don't forget, right? And few more points which you must remember is the nominated members of Lok Sabha and Rajya Sabha participate in the president's election, but the nominated don't participate in the president's election, but they participate in the process of impeachment of the president. Don't forget. And on the other hand, the elected MLAs have participated in the president's election, but now the elected MLAs are not participating in the impeachment of president. Okay, and the impeachment of president is subjected to judicial review, and no president has been impeached so far. Did you understand? Yes. Do you want some break? Okay. Okay, take some break. I'm also feeling. See, I will complete this union executive at any cost, whatever time it might be. Union executive. Okay. Union executive, I will finish. What happened? Already some aspects of center-state relations we have covered from morning. Some aspects like union, center can give directions to the states. See, one is center can give directions to the states. The parliament can make laws on state subjects. The union article 246 in 7th schedule deals with distribution of. Let me complete this now. I will try to see. I will keep your request, but I will try to complete that. Right. Okay. Take break for 10 to 15 minutes. Okay. Right. Again, we will meet again. Article 33. Article 33 is Parliament can make laws. Ante, Parliament can make laws, abridging your fundamental rights, abridging the fundamental. The Parliament can make laws and take away the fundamental rights of persons serving in armed forces. That is 33. 34 it is related to whenever the partial law is in force, your fundamental rights can be violated. 35 is what? Wherever we have non-self-executory fundamental rights, there the Parliament can make a law for implementation of fundamental rights. That is mentioned in Article 35. Nothing that I will come again. Don't worry. In between, whenever I finish the class there, I will come. If I finish the class there early, there. Okay. Yes. I am getting this neck pain actually. Actually, I'm getting this neck pain. No. We'll continue. I said no. I will complete that. At least see if some major part is completed, or at least some is completed. Remaining, you can go through that. That is the reason I am telling you each and every point. Otherwise, only important points if you teach. Then, for example, in impeachment of president, at the most, two to three points are important. But I am covering here everything so that the rest you can read by yourself.
Next to CABF.
No.
అంటే ఇయర్ ప్రిలిమ్స్ రాయట్లేదు.
రాయట్లేదా?
సిఏపిఎఫ్కి నెక్స్ట్ అటెండ్ చేద్దాం.
ఓకే, గుడ్ గుడ్.
సో ఇప్పుడు ప్రిలిమ్స్కి తగ్గట్టు చదవాలి.
రీడింగ్ హోలిస్టిక్ అర్థమైందా? ప్రిపరేషన్ షుడ్ బి ఇన్ సచ్ వే దట్ ప్రిలిమ్స్ మీన్స్ దట్ ఇట్ విల్ మేక్ ఇట్ సేఫ్. Much patience. What about other classes? Same? You came to other classes also?
Which article did we complete? Article
61.
61. Okay. Yes. Huh? Right. See, having discussed about various aspects of the president, now let us discuss about the veto powers of the president. The president has veto powers under which article of the Indian Constitution? Veto powers of the president are mentioned in which article of the Indian Constitution? Article 111 in Part 5 of the Constitution deals with the veto powers of the president. May I please know, when a bill is sent to the president for his assent, what are the options that Indian president has? He can either give his assent to a bill, then, or he may withhold his assent to a bill, or he may return the bill for reconsideration. Now, what do you mean by withholding his assent to a bill? Which type of veto power it is? Withholding his assent to a bill. Absolute veto. What do you mean by president returning the bill for reconsideration of the parliament? It is suspensive veto. When president does not take any action on the bill and simply keeps the bill pending, then what is it called? Pocket veto. So never forget, my dear friends, normally there are 4 types of veto powers, that is absolute veto, suspensive veto, pocket veto and qualified veto. The Indian president has only first 3 types of veto powers, that is absolute veto, suspensive veto and pocket veto. The Indian president does not have qualified veto. Then what do you mean by absolute veto? When president withholds his assent, if the president does not give his assent, then the bill comes to an end. Then that is known as absolute veto. When can the president exercise absolute veto? The president can exercise absolute veto in 2 cases. When a bill is introduced by any private member. Who is called a private member? Any MP who is not a minister is known as a private member, point number 1. And when a bill was introduced by the previous government, but elections have taken place and the fresh government came to power, and now they have asked the president not to give his assent to the bill which was passed during the time of previous government. Did you understand? Yes. Did you understand, Rakesh? Absolute veto can be exercised in 2 cases. One is when a bill is introduced by any member of parliament who is a private member. Second one is when elections have taken place and when there is a new government formed at the center, it can ask or it can aid and advise the president not to give assent to the bill which were introduced during the time of previous government. Did you understand? Yes. Did the president exercise absolute veto? When did the president exercise absolute veto? 2 times. What were those? No. What were the 2 examples when the Indian president exercised absolute veto? Dr. Rajendra Prasad exercised absolute veto. What happened? Dr. Rajendra Prasad exercised absolute veto with respect to PEPSU appropriation bill. And PEPSU appropriation bill was a money bill at the time. Getting absolute veto can be exercised over money bills. One example is your Dr. Rajendra Prasad has exercised PEPSU has exercised absolute veto over PEPSU appropriation bill. Are you getting? Second one is R. Venkatraman has exercised absolute veto over the salaries and allowances of MPs amendment bill. R. Venkatraman has exercised absolute veto over the salaries and allowances and pensions of MPs amendment bill 1991. Now you tell me one thing, this is mentioned there everywhere. Is absolute veto power the discretionary power of the president or not the discretionary power of the president? Why the absolute veto power is not the discretionary power of the president? Because he has to act on the aid and advice of the Council of Ministers. Therefore, the absolute veto is not the discretionary power of the president. Don't forget. Are you understanding? Yes. And over money bills, which type of veto power can be exercised? Absolute veto can be exercised over money bills. And please remember these 2. What happened? That is what I am saying. Earlier government was there. during that government, money bill was passed by parliament. In the meantime, government came to power, another government. It will ask the president not to give his assent to the money bill. Did you understand? Right. Please, next one. Remember only these 2 points. The absolute veto is not the discretionary power of the president. An absolute veto can be exercised over money bills. Don't forget these two. Then what is suspensive veto? The president can return the bill for reconsideration of the parliament. This is known as suspensive veto. Is suspensive veto the discretionary power of the president? Yes. Why? He can send the bill for reconsideration of the parliament once. For that one time, the suspensive veto is the discretionary power of, yes, the discretionary power of the president. However, if the parliament sends the same bill again, with or without amendments, the president must give his assent to a bill, okay, bill which has been returned by the parliament again. Did you understand? Yes. What you are saying? That is different. Constitutional amendment bill. I will make you understand. 24th Constitutional Amendment Act 1971. Okay? Yes. And my dear friends, absolute veto is not the discretionary power of the president. The suspensive veto is the discretionary power of the president, and the president cannot exercise suspensive veto over the money bills. The president can exercise suspensive veto, absolute veto over money bills, but he cannot exercise suspensive veto over money bills. Don't forget. And are there any examples of president exercising suspensive veto? Dr. APJ Abdul Kalam has exercised suspensive veto over the Office of Profit Bill in 2006. Don't forget, okay? Next, the third type of veto power and the last veto power is the pocket veto. So what do you mean by pocket veto? See, normally when a bill is sent to the president, he must either give his assent to the bill, or he must return the bill for reconsideration, or he can withhold his assent. But if the president is not doing any of this, he simply keeps the bill pending, he is not taking any action on the bill, then it is known as pocket veto. Then he is exercising which veto power? Pocket veto. On the other hand, if you see, American president must take action on the bill within 10 days. Within 10 days. On the other hand, Indian president does not take action on the bill for so many days or so many months. Therefore, it is regarded that the pocket of Indian president is bigger than the pocket of American president. Don't forget, the pocket of Indian president is bigger than the pocket of American president. What does this mean? The Indian president, there is no time limit fixed for the Indian president to take any action on the bill. Don't forget this. And did any Indian president exercise absolute pocket veto? Yes, please remember, there was a president known as Jail Singh. He exercised pocket veto power in 1986 to Post Office Bill. Okay, Indian Post Office Amendment Bill 1986. Right. And yes, pocket veto, for your kind information, out of the 3 veto powers which the president has, out of the 3 veto powers, absolute veto, suspensive veto, and pocket veto, the pocket veto and suspensive veto are the discretionary powers of the president. Don't forget, suspensive veto and pocket veto are the discretionary powers of the president. Right. Now, how many types of bills are there normally? 4. One is the constitutional amendment bill. Second is the money bill. Third one is the financial bills. And fourth one is ordinary bills. And out of these 4 types of bills, the president, let us take first constitutional amendment bills. Is it mandatory for the president to give his assent to a constitutional amendment bill? Is it mandatory for the president to give his assent to a constitutional amendment bill? How many of you are saying yes? 3. Why others are not saying? Is there any basis for your why you are not saying yes? Please understand, according to 24th Constitutional Amendment Act 1971, it is mandatory, it is obligatory, it is compulsory for the president to give his assent to a constitutional amendment bill. According to which Constitutional Amendment Act? 24th Constitutional Amendment Act 1971. The president cannot say no to a constitutional amendment bill. The president has to give his assent to a constitutional amendment bill. Don't forget this. And moreover, with respect to money bills, the president can exercise which veto power? Absolute veto. And with respect to the financial bills and ordinary bills, the president can exercise all the 3 types of veto powers. Don't forget all the three types of veto powers. Next one, let us discuss just ordinance making power and clemency powers. What is ordinance making power of the president? Which article of the Indian Constitution? Article 123 in part 5 of the Constitution deals with the ordinance making power of the president. Now let me ask you one question. Ordinance making power of the president was, borrowed from which act of the historical background?
1935.
From which act of the historical background? Ordinance making power of the president. It was introduced by which act? Anyone here? The Indian Councils Act 1861. The Indian Councils Act 1861. For first time, this ordinance making power of the Governor General was introduced by the Indian Councils Act 1861. Don't forget, Indian Councils Act 1861. Now, when can a president issue an ordinance, promulgate an ordinance? He can promulgate an ordinance during the recess of parliament. What do you mean by recess of parliament? When both the houses of parliament are not in session, or when any one house of the parliament is not in session, it is known as recess of parliament. Don't forget. The president can promulgate ordinance during the recess of parliament. What is recess of parliament? When both the houses of parliament are not in session, or when any one house of the parliament is not in session, then the president can promulgate an ordinance. Okay? Yes. Then why ordinances are called temporary laws?
It doesn't cease to exist after 6 months.
Why ordinances are called temporary laws? Because
6 months,
okay. Yes, good. Because the life of an ordinance is 6 weeks. The life of an ordinance is 6 weeks after the reassembly of both the houses of parliament. However, the maximum life of an ordinance is 6 months, 6 weeks. Why 6 months, 6 weeks? Why 6 months? Because the gap between the two sessions of parliament cannot exceed 6 months. Please don't forget. Right? Now, by the way, is ordinance making power the discretionary power of the president?
No.
Why not? Very good. He can promulgate an ordinance only on the aid and advice of the Council of Ministers headed by Prime Minister. Therefore, the ordinance making power is not the discretionary power of the president. Today you came to know two powers which are not discretionary powers. One is absolute veto powers. Second is ordinance making power. Both are not the discretionary powers of president, right? Then an ordinance can be issued under which cases? An ordinance cannot be issued under which cases? For example, can an ordinance be issued to enact a new law? Can enact any new law? Yes. Can an ordinance be issued to amend the already existing law? Yes. Can an ordinance be issued to enact, to amend or change an already existing ordinance? Yes. Don't forget. An ordinance can be issued to amend the already existing ordinance also. Can an ordinance be No, I will tell that. Can an ordinance be issued to amend the tax laws? Yes. An ordinance can also be issued to amend the tax laws, my dear friends. Please remember for one more time, I am repeating. An ordinance can be issued to enact new laws. An ordinance can be issued to amend the existing laws. An ordinance can be issued to amend or change the already existing ordinance. An ordinance can also be issued to amend the tax laws. Did you understand? Yes. However, the ordinance cannot be issued to amend the constitution. An ordinance cannot be issued to amend the fundamental rights. An ordinance cannot be issued to amend the DPSP's fundamental duties. Are you getting? An ordinance cannot be issued to amend the constitution. Don't forget this, right? Then ordinance will cease under which circumstances? An ordinance comes to an end if president withdraws an ordinance at any time. See, there are two ways by which an ordinance comes to an end. If the president does not, revokes an ordinance at any time, then it will come to an end. Withdraw or revoke is same. If the president withdraws or revokes an ordinance at any time, it will come to an end. And if both the houses of parliament passes a resolution withdrawing the ordinance, If both the houses of parliament passes a resolution withdrawing or disapproving an ordinance, even then the ordinance comes to an end. Okay, that is in who called this ordinance making power or ordinance as necessary evil? Dr. B.R. Ambedkar called the ordinance making power as a necessary evil during the Constituent Assembly debates. Did you understand? Yes. Friend, did you understand? Yes. Simple majority. Okay? Yes. The judicial review untadi. The two cases unnai late. Right. Next one is pardoning powers of the president. This is last topic in case of pardoning powers of the president. Which article deals with the pardoning powers of the president? Article 72. Very good. And according to Article 72, the pardoning power is the sovereign prerogative of the head of the state. Who is the sovereign prerogative? Who is the head of the state? President. That is the reason Article 72. According to Article 72, the president can pardon. The president has the pardoning powers. Now you tell me, while president exercises the pardoning powers, which powers which powers does he exercise when he is exercising pardoning powers? Or pardoning powers of a president are executive powers or legislative powers or judicial powers? Pardoning powers of the president are executive powers of the president, because the president does not sit as a court of appeal. Are you understanding? The pardoning powers of the president are executive powers of the president. Why not judicial powers? Because he does not sit as a court of appeal while hearing the case. He does not sit as a court of appeal, don't forget. And these pardoning powers have been conferred onto the president with two objectives. What are those? What are the objectives behind conferring pardoning powers onto the president? Huh? What are the two objectives behind conferring the pardoning powers onto the president? To correct any judicial error. If there is any judicial error, to correct the judicial error, the pardoning power has been given to the President of India. And if the punishment given by the court is too harsh to provide relief, okay, to provide relief to the convict or to provide relief from harsh punishments, the pardoning powers have been given to the president. So there are two objectives behind conferring the pardoning powers onto the president. The first one is to correct any judicial errors, and second one is to provide relief from harsh punishments. To provide relief from harsh punishments. Okay? Yes. If the president feels that harsh punishment has been given for the offense which he has committed. Now, see, Article 72 empowers the president to grant pardons if the punishment or sentence is a death sentence, point number one. If the punishment or sentence is given by a court martial, okay, court martial is a military court or tribunal. Never forget, military court or tribunal established under the military law. Okay, and I repeat, the president can empower. The Article 72 empowers the president to grant pardons if the sentence or punishment is of death sentence, if the punishment or sentence is by the court martial, if the punishment or sentence is for an offense committed against the union law. If there is any law which says that this offense should not be committed, and if any person commits any offense which is of any act which is an offense in that union law, then also the president can pardon. Okay, right. Thereafter, how many powers are included in pardoning powers of the president? 5. What are those? The first one is pardon. What do you mean by pardon? It completely absolves the convict. Once the president grants pardon to any convict, he is free as if he has taken birth today only. Are you understanding? It completely absolves the convict from all punishments, all sentences, all disqualifications. The person is completely free once the president grants pardons to him. Okay. The second one is reprieve. What do you mean by reprieve? It is a temporary stay on the execution of a sentence. Temporary stay on the execution of a sentence is known as reprieve. Okay, especially death sentence. Reprieve is especially regard death sentence. Okay, yes, ma'am. Capital punishment, yes. Reprieve, it is a temporary stay on the execution of a death sentence. And its main purpose is to allow the convict some time to ask for pardon to the president. Reprieve means what? Temporary stay on the execution of a sentence. Then what is the third pardoning power? Respite. What do you mean by respite? It implies awarding a lesser sentence than the one actually awarded. Actually, for example, if I had done anything wrong, I should have been given 7 years of rigorous imprisonment. But due to my physical disability or any other reasons, I have been given only 2 years of rigorous imprisonment. So what does it mean? The court has awarded me a lesser sentence. Why? By understanding some special fact, and that fact is my disableness. So when the court awards a lesser sentence than the one originally awarded, it is known due to some special fact or any reason. The reason might be old age of the convict, or physical disability of the convict, or pregnancy of a woman. Are you getting? It is known as respite. Then remission. What is remission? It implies reduction in the period of sentence. Reduction in only the period of sentence without changing the character. For example, a rigorous imprisonment of 8 years or 9 years may be reduced to rigorous imprisonment of 2 or 3 years. Okay. A death sentence, and moreover remission is all about reducing the period of a sentence. Okay, next one, last one is commutation. What do you mean by commutation?
Years don't change, but
Huh.
punishment changes.
Punishment changes. Okay, good.
Rigorous to simple.
Rigorous to simple, death to life imprisonment. Are you getting? Please, commutation means it implies the substitution of one form of punishment with a lighter form of punishment. Substitution of one form of punishment with a lighter form of punishment is known as commutation. For example, a death sentence may be commuted. A death sentence may be commuted to life imprisonment. A life imprisonment may be commuted to simple imprisonment. Are you getting? Yes. Then
punishment is same but temporarily
respite is special conditions they will see. For example, if there is a woman convict, are you getting? They will not give actual sentence which has to be awarded.
she have to be in the jail for 7 years where it was mentioned 7 years. She have to continue that.
See, while awarding the sentence, if there is any special fact, physical disability, old age, or if there is women convict, that they will not give the actual punishment which was supposed to be given. They will give lesser punishment. Special fact or special reasons. The special reasons might be old age of a person, physical disability of a person, or pregnancy of a woman. Okay, right. And friends, the pardoning power of the president differs from that of governor in 2 respects. May I please know in how many ways the pardoning power of president differs from that of governor?
Can't use the pardoning power instantly.
Huh.
But after the second commutation, tarvata it was 1 year gap.
What he is saying is some additional information. What you are saying is right. Huh? Yes. Please, Rakesh, continue. The president, no, please continue.
Pardoning power directly you don't get.
Huh.
But after the gap of a certain period, you can give the pardon.
Oh, who can give?
Governor.
Okay.
Gap in
Last right. Please listen to me carefully. What is written in textbooks that I am saying? The pardoning power of the president differs from that of governor. Governor's pardoning power is mentioned in Article 161. Pardoning power of president is mentioned in Article 72. 72 is president, Article 161 is governor. And it differs, president's pardoning power is different from that of governor's pardoning power in 2 respects. The president can pardon a death sentence, but the governor cannot directly. Are you getting? And even if a state law, let us consider a state law has prescribed a death sentence. Even in that cases also, who should pardon a death sentence? President of India only. And your governor cannot pardon a sentence or punishment given by a court martial. Court martial means military court or tribunal established under military law. But our president can pardon the punishment or sentence given by even a court martial. Don't forget this. Okay? Right. And finally, I would like to tell you one thing. The pardoning power of the president is not the discretionary power of the president. It is not the discretionary power. So how many powers are discretionary powers of the president? What you have seen, suspensive veto and pocket veto are discretionary powers of president, but ordinance making power, absolute veto and pardoning power is not the discretionary power of president. Don't forget. Okay, now shall we move to vice president? Okay, already the rest we have discussed. Legislative powers, I told you why president is an integral part of parliament, and the president also appoints. We have been discussing that, right? Right, please tell me about vice president, what you know. Which articles of the Indian Constitution talks about the vice president of India? Article 63 to 71 in part 5. I repeat, 63 to 71 in part 5 of the Constitution deals with the office of vice president. And as I told you, my dear friends, in the morning, the office of vice president and the vice president to act as ex officio chairman of upper house. The office of vice president as well as vice president to act as ex officio chairman of upper house. This provision we have borrowed from American Constitution. Both office of vice president as well as vice president to act as ex officio chairman. What do you mean by ex officio chairman? Very good. By virtue of holding one position or one office, you are eligible to hold other office. Did you understand? That is by virtue of, right? Ex officio. Next, see, the vice president is the second highest, occupies the second highest constitutional office in India. He occupies the second highest position in the table of precedence. Okay, and moreover, the office of vice president was created in 1950. When was this office of vice president created? In 1950, after the commencement of Constitution. And who was the first vice president of India? Dr. Sarvepalli Radhakrishnan. He was the first vice president to become the president of India. Point number 1. About Sarvepalli Radhakrishnan, you have to remember 2 facts. He was the first vice president to become president of India. He was the first president to impose national emergency during the Indo-China War. Did you understand? It was Dr. S. Sarvepalli Radhakrishnan who imposed national emergency for first time. Did you understand? Did you hear emergency provisions? Were you present while I was dealing with emergency provisions? No, you were not there. Okay, right, no problem. Please remember, it was Dr. S. Sarvepalli Radhakrishnan who imposed the national emergency for first time in 1962. Don't forget. And he was the first vice president to become the president of India. Then what are the qualifications, friends, to become vice president? Citizen of India. He must have crossed 35 years of age. Next, he must be eligible to become a member of Rajya Sabha, and he should not hold any office of profit. Then what are the additional qualifications? In order to get elected as in order to get his name in the nomination papers, he must be subscribed by 20 electors as proposers and 20 electors as seconders. Had it been the president of India, I would have made 50 and 50. Good. And regarding the election of president, election of vice president, your vice president is elected by directly or indirectly? Indirectly. By which method? PRSTV. And what is his electoral college? What is the electoral college of the vice president? It consists of whom? Very good. Good. It consists only electoral college. It consists only elected and nominated members of both the houses of parliament. Does it include MLAs? Why did our constitution makers did not include MLAs in the election of vice president? See, so మరి అట్లయితే ప్రెసిడెంట్ కూడా ఉండాలి. Please remember one thing. What is the main function of vice president? To act as the chairman of Rajya Sabha, but not to act as the president of India. Had the main responsibility of vice president been to act as the president of India, MLAs also would have participated in the vice president's election. The main duty of the vice president is to preside as the chairman to act as the chairman of Rajya Sabha. Only in few exceptional circumstances he acts as the president of India. Don't forget. Are you understanding? That is the reason in vice president's election, only MPs, that too elected and nominated MPs of parliament, participate in the vice president's election. Did you understand? Yes. Then, see, if there is an election dispute related to president and vice president, very good. Supreme Court, according to Article 71, the Supreme Court will look into all the election disputes related to the president and vice president. And is the Supreme Court's decision final here? Is the Supreme Court's decision final? Subjected to what? It is final. Please understand, the Supreme Court's decision with respect to the election disputes of president and vice president is final. Very good. Now, who administers the oath to the vice president of India? Vice president, president. In absence of president, who administers the oath? Okay, now, in absence of president, who administers the oath to Chief Justice of India? Vice President of India? Okay, right. See, what is the term of office of Vice President? 5 years. He holds office for a term of 5 years. However, he can resign by submitting his resignation letter to whom? President of India. He can resign by submitting his resignation letter to the President of India. Are there any vice presidents who resign till date? How many vice presidents resign till date in India? There are 3 vice presidents who resigned till date. 3 vice presidents resigned till date. The first one was V.V. Giri in 1969. 3 vice presidents resigned in India till date. V.V. Giri in 1969, R. Venkatraman in 1984. Why did these 2 vice presidents resign? To contest the president's election. They resigned to contest the president's election, but recently Jagdeep Dhankar resigned in 2025 citing ill health. Okay, under Article 67 A of the Constitution. Good. Under Article 67 under Article 67 Clause A of the Constitution, Jagdeep Dhankar resigned. Okay, and on the grounds of what? Ill health. Ill health. Article 67 Clause A. Now, can the vice president get re-elected to any number of times? Are there any vice presidents who got re-elected? How many vice presidents got re-elected till date? See, the first thing which you must know is the vice president can get re-elected to that office any number of times. There are 2 vice presidents who got re-elected till date. Two vice presidents. The first one was Dr. Sarvepalli Radhakrishnan in 1952 and 1957. 1952, 1957. Next is Hamid Ansari in 2007 and 2002. In 2012. 2007 and 2012, Hamid Ansari got elected to the office of vice president twice. Never forget this. Now, how to remove a vice president? Okay, initially, it is not only Rajya Sabha. Initially, the Rajya Sabha must pass a resolution removing the vice president by effective majority. Once a resolution is passed by the Rajya Sabha by effective majority, then it is sent to the Lok Sabha. And in Lok Sabha, the vice president can be removed by passing a resolution by just simple majority. Did you understand? In removal of vice president, 2 houses are participating. Don't forget. Good. Now, however, see, the resolution for removal of vice president can be introduced and discussed in Rajya Sabha only after giving a 14 days prior notice to the vice president. Okay, and there are no grounds mentioned in the Constitution. The Constitution does not mention any grounds for removal of Vice President of India. But the Constitution mentioned the grounds for removal of President of India. What is that ground? Violation of Constitution. But to remove the Vice President, no grounds are mentioned in the Constitution. Any ground is not mentioned in the Constitution. Never forget. Okay? And during normal times, as you are aware, the Vice President can exercise a casting vote. In case of a tie, the Vice President can vote, though he is not a member of Parliament. But whenever a resolution for his removal is under consideration, the Vice President cannot vote. Why he cannot vote? Because he is not a member of Parliament. Yes, he cannot preside over the house. He cannot vote in the house even in case of a tie. When a resolution for his removal is under consideration. Okay, you're right. Then, how can a vacancy in the office of vice president be created? Uh, See, if there is expiry of tenure of 5 years, in this case, the vice president himself will act as the president, as the vice president, until his successor assumes charge. However, elections must be held before 5 years. But if the vice president resigns, if the vice president dies, if the vice president is removed, or otherwise, in this case, the elections to the office of vice president must be held as soon as possible. It is written as soon as possible, but not for within how many months. Please understand. In case of expiry of the tenure of vice president, it is clearly written the elections to office of vice president must be held before the expiry of tenure of that vice president. It is written. But here, in case of resignation of the vice president, removal of the vice president, death of the vice president, or otherwise. What do you mean by otherwise? What do you mean by otherwise? If his election is declared void by the Supreme Court, we can consider it as otherwise. So in these 4 cases, the elections to the office of vice president must be held as soon as possible. May I please know any vice president who died in office? Can you name me the name of the vice president who died in office? Who? No? Krishna Kant was the only vice president to die in office. Krishna Kant, please remember, Krishna Kant was the only vice president to die in office. For example, elections have taken place, vice president died, elections took place. Will the new vice president act for a full term of 5 years, or will he act as the vice president for the remaining term? He will act as the vice president for full term from the day he assumes charge. Did you understand? And regarding the functions of vice president, what are the main functions of vice president? To act as the chairperson of Rajya Sabha, chairman of Rajya Sabha. This is the main function of the vice president. And your vice president acts as the president in 2 conditions. What are those? One is in case of vacancy. Another is in case of absency. How can a vacancy of the president's office be created? If he dies, if he is removed, if he resigns, or otherwise. Then when can an office of president be absency? When can we consider that the president is absent? If he is on a foreign tour, or if he is ill. However, friends, my dear friends, please remember, in case of vacancy of the president's office, the vice president can act as president for a maximum period of 6 months. Within 6 months, the elections must be held to the office of president. However, in case of absency, if the president is on a foreign tour, or if the president is ill, the vice president can act as president. That time is not mentioned in the constitution. Until he recovers, the vice president can act as president. That time may be even more than 6 months. Now you tell me, what will the vice president's wish? What will be the wish of the vice president? President must be ill. President undali kani chavoddu. Are you getting? Yes, please understand, right? Then thereafter, see, the salary and salary allowances of vice president are determined by the parliament, and the vice president receives the salary as ex officio chairman of Rajya Sabha. He is not paid a special salary as that of president. President receives 5 lakhs, and your vice president of Rajya Sabha, vice president receives 4 lakh rupees. What happened?
MP Rajya Sabha MP
Rajya Sabha MP are paid how much? See, the salary allowances and emoluments and allowances of vice president are not mentioned in the constitution. They are determined by the parliament. Okay, and the vice president receives the salary as ex officio chairman of Rajya Sabha only. Now, this is what is about vice president. Now, shall we move to Prime Minister and Council of Ministers, Attorney General of India? It is. Right. Now we will discuss about the most important constitutional office of this country, that is the Prime Minister. But this is the though it is this much important, there are only few articles related to the Prime Minister. Though the office is of that much importance, the Constitution talks the least about the Prime Minister. Are you getting? The next topic which I am going to discuss with you is another union executive known as the Prime Minister. Please tell me, the Constitution of India has provided for which form of government? Parliamentary form of government. And the moment I talk about parliamentary form of government, what is the basic feature of parliamentary form of government? Dual executive. It has two executives. One is the nominal executive, second is the real executive. Now let us talk about the real executive or de facto executive, that is the Prime Minister of India. Are you getting? See, there are only 3 articles which talks about the Prime Minister of India. 74, 75 and 78 in part 5 of the Constitution deals with the Prime Minister of India. I repeat, 74, 75, 78 in part 5 of Constitution deals with the Prime Minister of India. See, what is Article 74?
Indian Council is headed by PM.
Okay, good. What is Article 74? According to Article 74, there shall be a Council of Ministers headed by Prime Minister to aid and advise the President of India. Good. Then, is this aid and advice binding on the President?
Yes.
How? On what basis you are saying that the aid and advice is binding on the President? The 42nd Constitutional Amendment Act has made the ministerial advice binding on the President. The 42nd Constitutional Amendment Act 1976 has made the aid and advice of the Council of Ministers headed by Prime Minister. This aid and advice is binding on the President. However, the 44th Constitutional Amendment Act 1978 has given one relaxation to the President. Yes, the President can ask the Council of Ministers to reconsider their advice once. According to 42nd Constitutional Amendment Act, the aid and advice of the Council of Ministers headed by Prime Minister is compulsory. It is binding on the President. But according to 44th Constitutional Amendment Act, the President can ask the Council of Ministers to reconsider their advice only once. This is Article 74. I told you there are 3 articles related to Prime Minister. One is 74, second one is 75, third one is 78. Now let us discuss Article 75. What is Article 75? See, actually Article 75 has 6 clauses. 75 clause 1, clause 2, clause 3, clause 4, clause 5, clause 6. What is Article 75 clause 1? The Prime Minister is appointed by the President of India, and other ministers are appointed by the President on the advice of Prime Minister. Are you getting? 75 clause 1 says the Prime Minister is appointed by the President of India and other ministers are appointed by the President on the advice of Prime Minister. Yes. Now please listen to me. Now this is the crux of your Prime Minister's chapter. Though the office of Prime Minister is considered to be the most important constitutional office, yes or no? Though the office of Prime Minister is considered to be the most important constitutional office, the Constitution did not mention the specific procedure for selection and appointment of Prime Minister. Article 75 clause 1 simply says the Prime Minister shall be appointed by the President, but it did not specify the procedure on how to appoint, how to select the Prime Minister. That is the reason we have our Prime Minister is appointed by the President in different circumstances, in different manners. One is when a party gets a clear-cut majority after the general elections. Suppose if BJP has won with clear-cut majority after the general elections, then the President will not have any doubt. He will directly call the leader of that political party and he will appoint him as the Prime Minister. Are you getting? When a political party gets a clear-cut majority, then as per convention, this is not as per law. As per convention means traditional practice. As per convention, the President has to appoint the leader of that party as the Prime Minister. Did you understand? What he is saying, I did not get it.
necessary leader appointed.
మరి అపాయింట్ చేయాలిగా ప్రైమ్ మినిస్టర్.
వేరే వాళ్ళు కూడా
Leader of that political party. Political party will decide whom the prime minister should appoint. Whom the president should appoint as the prime minister. Did you get? Political party ఎవరి పేరు చెప్తే president will appoint that person. Normally, the leader of that majority party will be chosen as the prime ministerial candidate. When is this case? This is in case of the if the political party gets clear-cut majority. Okay? Yes. Then what about when no party gets a clear-cut majority? When no party gets a clear-cut majority, the president exercises his personal discretion. Now the president exercises the personal discretion. When no party gets a clear-cut majority, then what he will do? He will call the leader of the single largest party. Please listen to me carefully. If the no party gets a clear-cut majority, then the president will call the leader of the single largest party, or the leader of the pre-poll alliance, or the leader of the post-poll alliance to form the government. And there he will give, to prove his majority, the president will give him how much time? 1 month. I repeat, when the political party got a clear-cut majority, the president, according to convention, the president has appointed the leader of the political party as the prime minister. But when no party gets a clear-cut majority, then the president will exercise his discretion. Okay, he will ask the leader of the largest single political party or pre-poll alliance. There will be pre-poll, no? Even before elections, parties form alliances. Or he may ask the post-poll alliance, leader of the post-poll alliance, to form the government. And once he will appoint him as prime minister, he will ask him to prove the confidence of the house, to prove majority support of the house within how many days? Within 1 month. Don't forget this. And are any presidents appointed in this manner? Neelam Sanjeeva Reddy exercised his personal discretion and appointed Charan Singh as the prime minister. Neelam Sanjeeva Reddy exercised this discretionary power and appointed Charan Singh as the prime minister. Don't forget. Okay. Yes. Now, the third case is when the prime minister dies suddenly, then what should the president do? If the prime minister dies suddenly, sudden death of prime minister, in this case, please understand, the president again exercises his personal discretion. Okay? Yes. If the prime minister dies suddenly, again the president exercises his personal discretion and appoints any person as the prime minister. And he will ask him to prove his majority within 1 month, or within how much time? 6 months. No. See, he will ask him to prove his majority in reasonable period. Now, what is that reasonable period? We do not know. Are you getting? When the prime minister in office dies suddenly, the president will appoint any one person as the prime minister, and he will ask him to prove his majority support within a reasonable time. Don't forget. On death of the prime minister, this will happen.
What if he appoints any other person, like me? He appoints me. So then I need to elect within 6 months.
If he elects not a member of parliament,
Then for 6 months he can continue as prime minister. I am coming to there. That is according to Article 75, Clause 5. I am coming there. See, did any president appoint any person as prime minister when the current prime minister died? Yes. Jail Singh. There was a president known as Jail Singh. When the Indira Gandhi died, when Indira Gandhi was assassinated, the then president Jail Singh exercised his personal discretion and appointed Rajiv Gandhi as the prime minister. Okay, please remember. However, on the death of the prime minister, please listen to me. However, on the death of prime minister, if the ruling party appoints one person, see, this is the case. When the prime minister dies, if there is no successor, then the president will exercise his discretion. But if the prime minister dies and within short span of time, If the party appoints one person and asks the president to appoint him as prime minister, then the president has no other choice but to appoint him as prime minister and ask that person who has been appointed as prime minister to prove the majority support within reasonable time. Did you understand? Within reasonable time. Now, what is this reasonable time? We do not know. Are you getting? Yes. Now comes to the question which one of our friends has asked. Please remember, according to Article 75 Clause 5, according to Article 75 Clause 5, any person can be appointed as any minister or the prime minister. But he can continue as a minister for a maximum period of 6 months. Within 6 months, he has to get elected to any house of parliament. Okay, any house of parliament. Now, how will he become a member of parliament? Either by getting elected or by getting nominated to Rajya Sabha. Did you understand? Yes. Then, see, in India, a member belonging to any house, he might belong to Lok Sabha or Rajya Sabha, he can become prime minister. Can you name me 3 examples who became the prime ministers from upper house? Okay, good. Manmohan Singh, he became the prime minister in 2004. He was a member of Rajya Sabha. Indira Gandhi in 1966 and H.D. Devegowda in 1996. Never forget. Indira Gandhi in 1966, H.D. Devegowda in 1996 and Dr. Manmohan Singh in 2004. These were the prime ministers who belonged to Rajya Sabha. Okay, are you getting? Yes. However, see, this is in case of India. But in case of Britain, in case of Germany, in case of Japan, the prime minister must belong to lower house only. He must belong to lower house. A person belonging to upper house cannot become the prime minister in Britain, Japan, Germany. But in case of India, a prime minister belonging to the upper house can also become the prime minister of India. Right. Then thereafter, who administers oath to the Prime Minister of India? The President administers oath to the Prime Minister of India. According to which article? 75 Clause 4. According to Article 75 Clause 4, the President administers the oath to the Prime Minister of India. And the oath of Prime Minister is same as the oath of Union Ministers. Oath of Prime Minister is same as the oath of Union Ministers. Don't forget. And see, is the term of the Prime Minister fixed by the Constitution? No. According to Article 75 Clause 2, please listen to me carefully. The term, the President, the Prime Minister as well as the ministers hold office during the pleasure of President. Now, may I please know what do you mean by during the pleasure of President? Wherever the Constitution is silent regarding the term of a office, there the President will, that person will enjoy to remain in office during the pleasure of the President. Are you getting? During the pleasure of President. Can you name me some of the constitutional officers who hold office during the pleasure of President? Huh? Who holds office during the pleasure of President? Prime Minister, Union Minister, Governors, Attorney General of India, the Chief Ministers of Union Territories, the Ministers of Union Territories, or for that matter, civil servants. They hold office, yes, public servants. They hold office during the pleasure of President. Okay? Right. And see, my dear friends, the salary that is received by the Prime Minister is same as the salary that is received by any other Union Minister, and that is same as the salary that is receivable as a member of Parliament. Okay? Yes. No, CAC's term is fixed, no, 6 years, 65. Okay? Yes. And see, as you are aware, I will take only 1 minute regarding Prime Minister, then I will go to Council of Ministers. In Council of Ministers, we will discuss only 2 more articles. 74, 75, 78 are same. 2 more articles we will discuss there. An Attorney General of India, it will take just 5 minutes, my dear friends. Okay. Now, what are the powers of Prime Minister in relation to the Council of Ministers? He recommends the persons who can become the ministers. The ministers can be appointed by the President only on the advice of the Prime Minister. Point number 1. He distributes or he allocates the portfolios among the ministers, and he can ask a minister to resign. Suppose if there is a difference between a minister and the Prime Minister, the Prime Minister will ask the minister to resign, and if he does not resign, he will ask the President to dismiss him. Are you getting? Please don't forget. Next, in relation to President, what is the functions of Prime Minister in relation to President? It is aid and advice. Don't forget aid and advice. According to Article 74, the Council of Ministers headed by Prime Minister shall aid and advise the President of India. Okay? Yes. And 75? Clause 1. You are talking about which article? 74, clause 1. 74. Okay. And my dear friends, there is only one article, that is Article 78. It talks about the duties of the Prime Minister. The Prime Minister must perform two duties. One is he must inform the President what are the affairs taking place in the Union. Okay, 78. According to Article 78, the Prime Minister must inform the President regarding all the decisions of the Council of Ministers, regarding all the affairs or proposals for legislation. This is according to Article 78. Suppose if the Prime Minister does not reveal, then according to Article 78 Clause B, the President can ask the Prime Minister. That's all. This is all about Prime Minister. Now let us discuss about the Council of Ministers, or let me discuss about the Attorney General of India. Right. Which article of the Indian Constitution talks about Attorney General of India? Article 76 in Part 5 of the Constitution talks about Attorney General of India. Who appoints the Attorney General of India? The President appoints the Attorney General of India. And Attorney General of India holds office during the pleasure of President. Attorney General of India, the only article which deals with Attorney General of India is Article 76. Now, who is Attorney General of India? He is the highest law officer of this country. Highest law officer of this country. And what is the main role of Attorney General of India? Yes, what is the main function of Attorney General of India? Very good. He is the chief legal advisor to the government of India. Okay? He suggests the government of India on all the legal matters. He represents the government of India in all the courts of India. It might be Supreme Court or High Court. And moreover, he performs the duties of legal character. For example, if there is anything which, if there is any suggestion required in a law, then he will give his suggestion while enacting a law. Are you getting? And moreover, he represents government of India he has represented government of India, and he represents government of India not only in the Supreme Court and High Court, he also represents government of India in international forums also, if there is anything, if he has to be represented there. And he assists the President of India under Article 143 of the Indian Constitution. What is Article 143? Advisory jurisdiction of Supreme Court. Wherever the President refers any case to the Supreme Court, who will represent the President of India? The Attorney General of India. Next one, my dear friends, he assists the Parliament in the lawmaking process. As I told you, while enacting any law, he will assist the Parliament in the lawmaking process, and he advises the government of India on any global treaties, conventions, which our lawmakers are unable to understand. However, my dear friends, even after having these many powers or functions which Attorney General of India can perform, there are some rights. According to Article 88, the Attorney General of India has the right of audience in any court of India. He can speak and take part in the proceedings of both the houses of Parliament. However, he does not have the right to vote. He can participate in the proceedings of both the houses of Parliament. He can participate in the joint sitting of both the houses of Parliament. However, he does not have the right to vote. And he has the audience in all the courts of India. Same like ministers. Good. And moreover, he enjoys all the privileges and immunities that are available to the MPs. These are the rights of Attorney General of India. Then what are the limitations of Attorney General of India?
He cannot take a private case without permission. He can be government.
Huh? He can take up private cases, no?
Criminal case.
Wherever government of India is involved, he does not. That is the reason we call Attorney General of India as lawyer of the government. Lawyer for the government. We don't call Attorney General of India as lawyer of the government. We call Attorney General of India as lawyer for the government. Why? He can take up private cases also. However, if in that case, if government of India is involved, he will not take up that case. Okay. Then what are the limitations, my dear friends? He should not advise anything against the government of India in any courts. Point number one. This is normal thing which you can find everywhere. He should not advise anything against the government of India, and he should not defend the accused person without he should not defend the accused person in the criminal cases without the permission of government of India. And moreover, he has the right to speak and take part in the proceedings of any house of parliament, he does not have the right to vote. And fourth one is, his recommendations are advisory in nature, not binding. His recommendations are advisory in nature and not binding, and he is not a part of the cabinet. Okay, and Attorney General of India is not a part of cabinet. However, Attorney General of India is in Britain, if you take Britain from there, the Attorney General of India is a part of cabinet, but in case of India, your Attorney General of India is not a part of cabinet. He can participate only in the proceedings of parliament, but not there. Okay, shall we stop, or shall we stop? Yes. Okay. Thank you, friends. Thank you for your patient hearing. You sat for this much time. I'm very much happy. I'm very much satisfied with you. For next time when we come, I don't want to say next time you will see me. Okay? Right. Thank you, friends. Thank you for your patient hearing. Have a nice day.
Sir, any expected questions for this prelims? Please.
See, I come there. My style of teaching is I teach everything. For me, each and everything is important. That is the reason when our students write, they will attempt all questions. At least 90% strike rate they will maintain. Why? Each and everything they will get. My style of teaching is like that. Awesome. 1 minute. Rakesh, what do you want? Unandi, podamma. Bye, ma'am. Thank you very much. Thank you for your patient hearing. No. If you find there is no each and every point any no points available. No, you take any ones and now if you see now present batch in the action to ask your students in the one they are writing in main also now they are writing moreover, I don't teach only Indian politics, I teach all subjects. I teach all subjects. Here I am given Indian politics, I am teaching politics from the last 1 year. In this subject, I have been teaching from 2013. I teach geography, I teach Indian history, architecture, environment. You meet against your answers are very good. You are very close to me. Are you getting it? That is the real answer. Very, very close.